Someone's running late.
Good morning. Today is Friday, January 23rd, 2026. This is the New Hampshire House of Representatives Municipal and County Government Committee. I am Representative Diane Power, and the committee has convened today for the purpose of hearing bills. Now, please make sure that your cell phones are silenced and join us in the Pledge of Allegiance led by Representative Walker.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. And as always, I have a few morning announcements before we're going to start in on the public hearings. So the committee is convened today at 9 a.m. for public hearings on 11 bills. We will plan to break sometime for lunch after the hearing scheduled at 11:15 a.m. And as a friendly reminder, please remember that food and beverages other than water are not permitted in committee rooms. And additionally, as publicly noticed pursuant to House Rule 44, executive session on pending legislation may be held throughout the day, time permitting, from the time the committee is initially convened. Okay. So no. This is not the bill.
No, you should just.
Oh, okay. So again, as another reminder, in order to stay on schedule today and to accommodate our bill load, the chair will allow for up to 5 minutes for bill introductions, followed by questions and answers, and then up to 3 minutes, also followed by questions and answers for in-person public testimony. If somebody has additional information that they want to share with the committee, I encourage them to please let us know. If you have hard copies, pass them out at either end of the table. And additionally, please, you're welcome to follow up with email. So also as a reminder, for the record, when you take the stand, please state your name, who you represent, and your position on the bill up front. Okay. And at this time, the chair will open the public hearing on House Bill 1417 FN, enabling municipalities, cities, and towns to adopt a land value tax system and making an appropriation therefore. The chair recognizes Representative Karazinski to introduce the bill. Unfortunately, the prime sponsor of this legislation is unable to be here today, and he has not made provisions for a co-sponsor or someone else to introduce the bill for him. So, Representative Karazinski, thank you.
Thank you, Madam Chair. It was. Now it is. Thank you, Madam Chair. 1417 FN. This bill enables municipalities, cities, and towns to adopt a land value tax system and appropriates money to the Department of Revenue Administration to help implement such systems.
Thank you.
Thank you.
Next, the chair recognizes Attorney Ramsey and Mr. Is it Denoncourt? You can take the stand and Good morning to you both, and welcome to Municipal and County Government.
Thank you, Madam Chair. Good morning, members of the committee. My name is Jennifer Ramsey. I am Tax Policy Counsel for the Department of Revenue Administration. And with me today is Adam Denoncourt, who is the Director of our Municipal and Property Division. This bill would create a tax system very different than the one that we currently utilize. It would allow towns to have different rates for the land value versus the improvement value. This is a tool that is not clear to us from the text of the legislation whether those rates would be set by the towns themselves or whether we would still be tasked with the rate setting. I think it's intended to be the latter, but we would appreciate clarification in the language of the bill in that regard. The second concern that we have would be with the effective date of the legislation. We don't believe it would be possible to implement the bill before tax year 2028. And the last thing to let you all know is that the bill does have a $1 placeholder appropriation for the agency, but it would cost a great deal more than that to actually give effect to this. Our existing municipal tax rate setting portal is not capable of processing this kind of information. It is still functioning remarkably given its age. But this would put us beyond the ability to continue to utilize it. We would need to convert the whole portal over to our revenue information management system. We haven't gotten a cost for that because getting that cost would sort of go beyond just the scope of this bill. But just to give you a rough estimate, we think that would be somewhere in excess of $1 million. And Director Denoncourt can answer more specific questions about any of those if you have them. I just wanted to give you that brief overview.
Thank you. Questions? Representative Walker is recognized for a question.
Yes, thank you. So it's going to cost the DRA an estimated over $1 million for your system. What kind of costs are you looking at all the camera systems throughout the state?
That's an excellent question. I don't know that I can answer that or really give an estimate, but there are 259 separate taxing districts in the state. Each of them manage basically their own software contract with a vendor. So one would assume as many as adopt this provision would need pretty significant changes to their CAMA system.
Follow up?
Yes.
Well, the camera systems are set up now to the current system, so I think this would be a total overhaul or a brand new system throughout the state on every community.
That's right. I can't imagine there's an existing CAMA system at this point that would be able to manage the change without a significant overhaul.
Thank you.
Further questions? Representative Grund is recognized.
Thank you, Madam Chair, and thank you for taking my question. Another piece that was referenced, it's page 3, lines 27 to 28, says the department will provide training and materials. Does the department already have any expertise or training materials? Would all that have to be created too at a cost?
That's correct. We do not, and that's correct. Yeah.
Further questions? Representative Elward is recognized for question.
Thank you, Madam Chair, and thank you for taking my question. Does this bill ensure uniform assessment standards across municipalities to avoid inconsistent valuations and increased tax appeal litigation?
I'm sorry, can you repeat the question one more time?
Sure. Does the bill ensure uniform assessment standards across municipalities to avoid inconsistent valuations and increased tax litigation appeals?
It's difficult to say in the abstract whether or not that would be the case, but certainly to the extent that it involves setting different tax rates on different portions of a property, it would be a significant difference to what we do today.
Follow up?
Yes.
Is the appropriation intended as a one-time implementation expense or an ongoing state obligation? And what happens to municipalities if state funding is later reduced or eliminated?
The appropriation that we spoke of earlier, the REMS upgrade or the municipal rate setting portal to REMS conversion would be a one-time expense. Once things were converted, there would not be a continuing appropriation that would negatively impact business if there was not additional funding.
Thank you.
Vice Chairman McDonald is recognized for a question.
Thank you, Madam Chair. Are you aware of any other states that have adopted something like this type of program?
I'm not, but I've also not extensively researched the topic, so it may be the case, but I'm not aware of any.
Thank you.
Further questions? Representative Elward is recognized for a question.
Thank you, Madam Chairman. Again, thank you for your participation today. Do municipalities currently have the technical capacity and trained assessors necessary to accurately and defensively separate land value from improvement value? And if not, how is that gap addressed?
I believe the Municipal Association is here, and that might be a better question for them.
Thank you.
Further questions? I have a question. So my reading of this bill is that it creates two parallel, I guess, tax systems, if you will. Is it correct in saying that the two would be one assessment for the municipalities and then another form of assessment which would retain the current methodology for the purposes of statewide SWEP tax, statewide property education tax, SW, yeah, statewide education property tax, SWEPT, and the county. So that's my reading of the bill. And if that is a correct interpretation, could you please comment as to the complexity of such a system? And I would also like to add, to follow up to Representative Elward, is it's not clear to me who's going to make those assessments, if it's like avatar type groups. So that's one thing, and I'm going to have another question on that. And the other thing is, with regards to setting the tax rate under this new system, the municipalities would be left up to do that? Is that something that's going to be contracted out? Is the governing body going to do that? And are they equipped and have the background and the knowledge to actually set a fair, accurate tax rate under this very complex scheme? I know that's a lot. Try to do your best.
Yeah, let me take a beginning at it, and then I'm sure Director Denoncourt will fill in where I've left out. So it's been a second since I read the bill. If there's a specific line with respect to SWEP that you were referring to, that would be helpful. My recollection is that the department would still do equalization studies under the new system, that the land values would be assessed separately from the property values, but then the rates would be different. So it would still be possible, I believe, to use the local assessing data for purposes of SWEPT. We would just set a SWEPT rate for the state, which we do now, but we would still use equalized local values and adjust them. It might make the equalization study more complicated, but we would still do that, not too dissimilarly from the way we do now. However, the tax rate is a question that we have as well. There's a portion of the bill that makes it sound like the towns might set their own tax rates. That would be a great departure from the way that we do things now. Currently, the towns let us know what their appropriation is that is needed for a year. They tell us what the property values are for their town, and then we do the math to get to the tax rate. If the towns are going to set the tax rate, I'm not at all certain how that would operate. Do you want to elaborate on that?
Sure. Just one other item. We do have a regulatory role in the tax rate setting process in determining that appropriations are legal and not procedurally defective. So leaving that at the local level would seem to kind of circumvent that process to an extent.
Thank you. Further questions? Representative Gilman is recognized for a question.
Thank you, Madam Chair, and thank you for taking my question. In reading the bill, is it your interpretation of the, was it pure tax? I've lost the line. In the definitions, page 1, line 17, where the definition of the pure land tax means the land value tax in which the improvements are taxed at zero. Do you think that in doing that, I understand it's actually kind of a nice thing or idea, but do you think what kind of effect would that have on the actual land value? If we send in a budget that says here, this is what we're budgeting for this year, and here's out the value of the land, would we end up making the land more expensive than it is now because of the rate we need to bring up?
I don't know that it would impact the value of the land. It's going to impact where the incidence of the local property tax lies with respect to ownership within the municipality. So if you have a lot that's worth $200,000 and $1 million home on that lot, right, then that $1.2 million would be the portion of the tax base. And if your neighbor only has a $200,000 home on a similar lot, then they would have $400,000 in the tax base. And whatever the appropriation is, the rate would apply to those two assessed values, so that the owner of the $1 million house is going to pay more tax than the smaller house. If it was a pure land tax situation, only the lot value
Right.
would impact who paid how much of the local tax burden. So if that hypothetical helps as an example of how I think this would operate.
Follow
yeah.
up?
Yeah,
Yes.
thank you. No, I understood that aspect of it. I guess my question is, we set a land value, or the valuation comes in at, for those two similar sized lots. Are we going to have, working together with the town's proposed budget, would we find that the land values are going to, land values go up? Yeah. Because we have to make up the money for the budget that we need to run our town.
Oh, yeah, so, right, and the tax rate itself is a kind of self-solving problem. So if you reduce the tax base, you need a higher tax rate.
Right.
So if you've reduced the tax base in any way, whether through this scheme or any other, you're going to need a higher tax rate to raise the same amount of money.
Thank you.
Further questions? Representative Elward is recognized.
I'm sorry, I didn't catch whether you were in support or opposed to the bill.
GRA does not take positions on the policy behind legislation. We wanted to come today to share any information we could, and specifically the implementation challenges that we would have with this bill as it's currently written.
Follow up?
Yes.
Thank you. This is enabling legislation, correct?
That's correct.
And does that necessarily mean that it's harmless?
We're certainly prepared for it to be implemented in any number of taxing districts in the state, whether it were an option or required.
Thank you.
Further questions? So quick comment with regards to my interpretation that the bill establishes a two-tier or a parallel tax system. And that would be on page 1, lines 22, well, actually, line 23. So
Yes.
you would agree?
Yes.
Okay. Further questions? So I had another question. Oh, Representative Frocht is recognized.
Thank you, Madam Chair. Thank you for taking my questions. I understood you to say that you've estimated a one-time startup cost of somewhere north of $1 million. Given the perhaps sketchy information that you have now, is it possible for you to estimate any increase in ongoing or operating costs, both to the DRA and to the municipalities, should they introduce or should they decide to implement the provisions of this bill?
Yeah, so the estimate, the very rough estimate that we gave you, it would be a one-time cost. Whether or not we were able to absorb additional personnel costs would depend a lot on what the budget looks like for the biennium in which this would be introduced. We haven't analyzed that because it is still unclear whether we would need any additional personnel. And as far as the municipal costs, we haven't had any input from municipalities about that. But again, the Municipal Association is here, and I bet they'd be happy to speak to it.
Oh, sorry, excuse me. Further questions? I have a further question. So, with regards to the implementation of this land value taxation system, I'm thinking, and this focuses on land. So I'm thinking about perhaps like a large parcel of land, 50 acres, 100 acres, that's in current use, it's undeveloped. Could you comment or describe to the committee how something like that would be assessed for the purposes of local property taxes? Would it be assessed as a whole, or could it be assessed as like individual parcels for development? It's just not clear to me, because there's many different ways to look at a piece of land and say, well, this is its value. Because clearly when it just sits there in current use, it's sitting there and it has a certain value. But clearly if in the future a developer wants to sell it, build, X number of houses, that clearly has a different value. So from the reference point where we're looking at some large parcel of land to apply a LVT assessment on, how do you determine what's, I guess, fair, proportional, with regards to the application to in that instance? Because we're not just talking about parcels of land that exist, that are subdivided and might have a blighted property on it. We have to consider other types of land that's out there in the tax base.
Thanks for the question. I think generally on a property that doesn't have any improvements on it, from my understanding, you're not going to see a whole lot of difference. The difference is going to be from one property to another. So if you have a large parcel that doesn't have any improvements on it and the same size parcel that does have an improvement, and we're talking about the zero or the pure land value tax, the improvement is not going to make any difference when you're comparing those two assessments. But in terms of developing an assessment for a parcel that's only land, I don't understand there to be any difference.
Okay, I understand. I understand your response, but my point is the interpretation of the intent and the application. So I would agree that your comment could be one interpretation, and maybe it's not fair to ask the DRA. It would be more appropriate to pose that question to the prime sponsor. So I appreciate your input. Further questions? Okay, seeing none, thank you for being here today and for fielding questions on this bill. So next, the chair recognizes Mr. Michaud.
I'm going to defer based upon the skeptical neutralism of the DRA and the committee's skeptical.
Okay. So, yep, that's okay. Mr. Michaud, although he filled out a pink card, he said that he is waiving off. And that's that's my last pink card on this particular bill. So at this time, I would ask, is there anybody present who wishes to speak to this bill who has not yet had the opportunity to do so? Seeing none, the chair recognizes Representative Gilman to report out the blue sheets.
Thank you, Madam Chair, and I will tell you that the blue sheets numbers, or the remote sign-in changed from last night. So people are still filing in. On the remote side, we had 2 in support and 5 opposed. And on today's blue sheet, we have 1 opposed.
Thank you. And with that, the public hearing on House Bill 1417 FN is now closed. At this time, the chair will open the public hearing on House Bill 1385, prohibiting the use of negative property tax rates in certain municipalities. I don't have a pink card, but that's okay. So I assume that you are Representative Markle? Excellent. Thank you. Mhm.
And I'm also, in terms of written testimony, what I'm presenting is a copy of the RAND decision that deals with the negative swept tax. And it might be useful for the committee.
Thank you. So at this time, the chair recognizes the prime sponsor, Representative Markle, to introduce the bill to us today. Good morning and welcome to Municipal and County Government.
Thank you very much. My name's Jay Markell, and I am Rockingham County, District 18, that's Atkinson, New Hampshire's representative. And the reason for filing this bill was a result of looking at various funding issues, and in particular, the RAND case. I claim, first of all, I think it's important to note, I claim no particular expertise in terms of finance or taxation. I am an attorney in New Hampshire, and I'm also admitted in Massachusetts and in both jurisdictions since 1998. What brings me to this one, basically just a few sentences, is when I looked at the RAND case. For those, and I'm certain that everybody in the room is familiar with it, but if you're not, you have a copy of the Supreme Court decision. Concisely put, the SWEP tax was initiated, I think, around 1999. And the idea was to help school funding, and I think it goes into the Education Trust Fund. What had happened below, and what brings me here today, is that there was a case in Rockingham County, which was RAND, and it dealt with the negative SWEP tax and how it was applied, in addition to a variety of other things. The case was appealed at the trial court level, if I recall. The trial court found that the negative SWEP tax was unconstitutional. New Hampshire Supreme Court reverses, affirmed the trial court's decision below, but reversed on some key issues. And so what brings us here today is respectfully suggesting that we look at page 8 of the decision here, which should be in front of you. And it deals with the negative aspects. It deals with basically the negative SWEP tax. In essence, what the negative SWEP tax did was allowed the DRA to set different tax rates. And certain jurisdictions, it varies obviously by jurisdiction, by locality and municipality and so forth. But if I read this correctly, the negative SWEP tax was kind of a way that different places, such as is indicated here, Hales Landing, where you have taxable property but little to no school involvement, to be able to set a negative SWEP tax. So in effect, it allowed jurisdictions that can do this to basically escape the impact of it. And Hale's location is a particularly nice town, if anybody knows it, and it's really well off. So the court's analysis was very simply that it violated, and just let me get my notes out here. The court's analysis was that it basically violates Part 2, Article 5 of the New Hampshire Constitution, the way this is being applied. And so what I'm looking to do here is to outlaw the practice so that, in essence, everybody will pay their fair share. And this is simply looking at the Rand decision from the New Hampshire Supreme Court. And while some of these decisions I understand are controversial, and, the Conval decision is controversial, I understand that. And what happens here is the analysis is that traditionally, the Supreme Court has been the arbiter of what the legislative intent was. And basically, the court here is saying that it wasn't, when you look at what the legislative intent was, that of the swept tax, it wasn't to allow this to happen. So what I'm asking this body to do is to outlaw the practice of the DRA setting a negative swept tax. And the reason why is that other legislation is pending which may have an influence on how schools are funded. Okay? This would be only a portion of it, and it would be the way the legislature could step up and say, well, there may be other debates about whether or not schools are funded in one particular direction. But here we can say that no matter how it goes, that the DRA should not be setting negative swept tax, and whatever the outcome is, legislatively or judicially, that that money should be, that tax should be fairly apportioned. And that's basically it. And I'm happy to take any questions if anybody has any.
Thank you, Representative Markell.
Yes?
Representative Elward is recognized for a question.
Thank you, Madam Chairman. Welcome to our committee.
Thank you.
How often are negative property tax rates actually used in New Hampshire, and are they common enough to warrant a statutory prohibition?
Well, that is one thing I really am not equipped to answer at this time. However, if it exists, I guess I think you're asking me a scope of the problem question. And scope of the problem is if it exists, and beyond this, and there are other jurisdictions that are doing this, then it should not. It should not be allowed. If it's a tax avoidance strategy where the legislature has already applied the swept tax. That's basically my position.
Follow up.
Yes.
Has any analysis been done on potential unintended consequences of prohibiting negative property tax rates, particularly for municipalities with volatile revenues?
That I'm not able to answer. What I'm saying here is that I'm asking that this be construed fairly narrowly. If I remember, the swept tax's goal is to raise something on the order of $330-odd million, more or less, to assist with school funding. So you're raising a good question with a good point. But if it comes up in a New Hampshire Supreme Court decision, it's obviously significant enough to, I think, warrant judicial action. I'm sorry, legislative action.
Thank you.
Representative Elward, could you just repeat your question? Because I didn't quite get it.
Has any analysis been done on the potential unintended consequences of prohibiting negative property tax rates, particularly for municipalities with volatile revenues?
Thank you. Further questions? Representative Colby is recognized.
Thank you, Madam Chair. Thank you for taking my question.
Sure.
It's going to be a little bit of an explanation, but we've heard over and over again, especially when it comes to the Conval decision, that the majority of the legislature has taken a position that court cases and judges should not be dictating to the legislature what a constitutional level of education funding in the state should be providing to public schools. Why would the Rand case be treated differently?
I guess because the Rand case brought some different issues up. Now, I've read Conval, and I'm familiar with what the rulings are. And you're certainly right. There is considerable disagreement as to whether Conval is actually valid or whether or not the legislature can actually override the Conval decision. And obviously, in the hierarchy of things, it can. We have the level of authority in this country, as I understand it, is that we have the Constitution, we have statute, and then we have court decisions. So notwithstanding that, nevertheless, it has been the prerogative of the judiciary to say what the law is. So it's fairly true, I think, that we actually can, to a certain extent, pick and choose the court decisions that we want to follow. I mean, as disturbing as that sounds, there is a basis for it. For example, by way of further answer to your question, Medicaid work rules were deemed to be unconstitutional years ago when New Hampshire had tried to implement them to be eligible for Medicaid. I think that was the Azar-Agar decision, somewhere around 2019. Well, guess what happened? Federal government decided that Medicaid work rules were going to work. That's in the statute right now. So now, even if they were unconstitutional, now they are. So it's a legislative override. So I guess what I'm asking here is a policy decision. Now, on this particular narrow aspect of law, it's basically what I think it of doing is plugging a hole. That's how I'm looking at it. We can all, I think reasonable people can disagree as to what Conval should be, what RAND should be, okay? But I think reasonable people can agree that, as this points out, you really can't be employing tax strategies to protect people if it's particularly in violation of what was clearly the legislative intent, number one. Number two, I think the other thing we have to ask ourselves, was this a proper delegation of legislative authority to be able to say that the Department of Revenue Administration can do what it wants and accept tax avoidance strategies? And so that's a decision, I think, a policy decision that the legislature has to make. So I'm hearing good questions about exactly how far this reaches. On the other hand, when we're in a tight budget situation, and we're in a situation where the state really does need every dollar it can get, good, bad, or indifferent, okay, to fund education, that this should not be a practice unless the legislature specifically authorizes it. And so that's where I think the value of RAND comes in. And that's how I see it. So that's an excellent question you're asking.
Follow up? Oh, new question? Yes.
Thank you, Madam Chair. Thank you for your answer.
Sure.
The way you have, or this has been written,
Mhm.
it's, and please correct me if I'm wrong, but this statute could be satisfied provided a municipality has a tax rate of a penny.
Well, it could, but in other words, if you're setting negative tax rates, I mean, if you're setting negative tax rates and you're using it as a tax avoidance strategy, okay, where other people don't avail themselves of the same thing, let's look at what the possible implications are if this were to be widely adopted. So if everyone were to set a negative tax rate, okay, what would the impact on this web tax be? And that could damage funding to whatever extent that we need.
Further questions? Representative Frocht is recognized.
Thank you, Madam Chair. You'll forgive my naivety. I am not a tax wonk, as
Okay.
it were.
Yeah?
As I understand, your proposal would prohibit a negative tax rate. And that negative tax rate is derived by some formula that the DRA uses and applies across every municipality in the state. Might it be might a different approach which sets a minimum tax rate avoid the situation where you have a non-negative but 1 cent type of tax rate?
Well, I think that would be reaching the same place. So I guess the larger question here, from my reading of Rand and from my knowledge of legislation, is was this the delegation, was this setting of a negative tax rate an intentional delegation by the legislature? Rand seems to think, after reading the entire legislative intent of the SWEP tax, that it wasn't. So the legislature, so this should be the prerogative of the legislature to decide what it is, not the DRA. So if, for example, and so what our proposal here is that the DRA should not set a negative tax rate. It should be a legislative decision, not a decision of an agency. And that's kind of where we're going with it. So to further answer your question, Representative, that's a legislative decision, not a DRA decision.
Further questions? Representative Majori, did I see your hand? You can take time to think.
Well, thank you, Madam Chair. I will ask the question, but I think it goes back to scope. Thank you, Representative, for considering this. I'm just trying to figure out if this is an ongoing problem where a community has consistently, and the question would be better asked to DRA. If there are communities where we see this consistent negative rate, that should send up a red flag. And again, I think that goes to scope. So maybe you've already answered that question.
Yeah. And I had heard, and by way of further answer, inferentially, I had heard Plymouth and a few other towns might be involved in that. Now, I can't say that that's the absolute gospel, okay? But at a conversation, I'm repeating what I overheard, okay? So if this may be bigger than what Hales Landing is, but the Supreme Court certainly found it significant enough to mention it. And, you know, when we look at it and the decision, it points out, I believe it points out that such a negative tax rate nearly or completely offsets taxpayers' swept obligation in certain unincorporated places. So in other words, it doesn't say that this is, and that's on page 8, that's paragraph 1, 2, 3, fourth down, it's paragraph 22. It says offsets taxpayers' swept obligation in certain unincorporated places. It doesn't say there's only one place. It goes on to say, for example, in 2021, the DRA set a local education tax rate for Hales Landing, an unincorporated place, at a negative $1.84 per thousand, which combined with Hales location swept tax rate of $1.85 per thousand, resulted in an effective property tax rate of 1 cent per thousand. So that's negligible. So in other words, it's using that as a particularly, with all due respect, egregious example. And so, in other words, I think the Supreme Court here is recognizing that the problem is bigger than Hales Landing.
Further questions? Seeing none, thank you.
Okay,
Thank you for being here.
Okay, thank you.
Next, the chair recognizes Mr. Power. Good morning and welcome to Municipal and County Government.
Morning, Madam Chairwoman and committee members. For the record, my name is Eric Power. I'm from the town of Brookline, and I'm in favor of this bill. I'm starting my 6th year of the planning board. So I have an interest in land use and taxes and also in education taxes. And there was a question earlier about negative tax rates, and they actually do occur. If you go to the DRA website, you can see them. This year in 2025, there's 11 negative tax rates in different, mostly unincorporated municipalities. And if you go back to the previous year, there's 23 negative tax rates. So this is not something that's not happening. This is happening. It's happened recently. It's happening now. And what happens is, if you look at the tax rates, and I'm not a complete expert in this, but what's happening is they have a mandated statewide property tax SWEP that they have to pay for the education, and then they'll just make a negative rate on their municipal rate. Or they may do the same. I saw some in 2024, there was a negative swept rate for whatever reason. I'm not sure why that happened. But to me, I think the solution is that there should not be a negative rate. That's almost like you're giving money back in some ways. So I think that the right thing to do is to make a floor of 0. Not have to be a penny or anything, but you do not have a negative number. And I'm an engineer, so I can, 0 is not a negative number. So you could say the lowest the DRA can set a tax rate would be 0. That would, if a municipality based on the SWEP formula ends up paying a little bit more, then so be it. But that it's not going to be that much money. And I just think that, with the RAND decision and everything, I think it makes a lot of sense to legislate this and to have a tax rate of 0 as the minimum. Thank you.
Thank you. Are there questions? So I had a quick question. You made a comment saying that it's like they're giving money back. Who is they in that sentence? Just for clarification, thank you.
Well, they raise the rate for the SWEPT, but it's more than they need for their education. So then they end up using that to pay for the municipality. So they're moving it around. Their total tax rate is never negative, but some components are negative. And that you can go back and see that this is actually happening. A DRA could probably say more, but I just wanted to mention, I wasn't planning on testifying on this, but I wanted to mention that this is actually happening.
Thank you. Further questions? Seeing none, thank you. So that represents my last pink card for House Bill 1385. Is there anybody present in the room who wishes to speak to this bill who has not yet had the opportunity to do so? Seeing none, the chair will recognize Representative Gilman to report out the blue sheets.
Thank you, Madam Chair. For remote testimony on this bill, we have 2 in support and 2 opposed.
Thank you. And with that, the chair will close the public hearing on House Bill 1385.
Madam Chair.
Oh, I'm sorry.
That's okay. On today's blue sheet, we have 2 in support.
Okay, I apologize for not observing and speeding, pushing ahead.
That's all right.
Okay, so I was just going to announce the time, but we are a little bit behind, so we will proceed.
Okay, I'll now open the public hearing on House Bill 1134. And could I ask the prime sponsor, Diane Power, to please come up, introduce the bill?
Thank you, Mr. Chairman and honorable committee members. For the record, I am Representative Diane Power. I represent the towns of Brookline, Mason, and Greenville in Hillsborough County, District 36. I am the prime sponsor, and I'm pleased to introduce to you today House Bill 1134. This bill was filed in response to a number of inquiries that I received both from state legislators as well as local officials regarding the procedure as to how to properly apply tax and budget cap laws. And so, in my mind, this bill is simply a procedural complement to the current law. So the purpose of this bill is twofold. First, the bill addresses an important procedural question for town meeting governance applicable to political subdivisions that have adopted tax or budget caps. And second, and importantly, the bill ensures clarity on how total appropriations and warrant articles accumulate when determining if an article will trigger the local tax or budget cap vote override. So the key provisions of this bill are as follows. First, let me talk about accumulation of appropriations. So total accumulation of appropriations from the warrant articles under the tax or budget cap, they accumulate in the order in which the articles are taken up at a traditional town meeting. And when a warrant article appropriation will cause the total appropriations to be above the adopted cap at a traditional meeting, the moderator will use a secret ballot to determine if, in fact, the 3/5 required override has been met to override the cap. And then for towns that use the SB2, the official ballot referendum form of town meeting, or also if there is a municipality that operates under a charter pursuant to RSA 49D, then the warrant articles accumulate in the order in which they appear on the official ballot, which of course is determined at a deliberative session of the meeting. And then under those two circumstances, after the balloting session is complete, the moderator and the clerk will then review the results of ballot votes. And when they determine that an appropriation is going to push total spending over the cap, they will ensure that, in fact, a 3/5 supermajority override vote threshold has been achieved to determine if the warrant article, in fact, passes. So ballot voting requirements, the bill also clarifies that if a warrant article does in fact require a ballot vote, the moderator will ensure that a yes/no vote will be conducted by, in the case of a traditional meeting, a secret paper ballot. And also I passed around an amendment, and that simply just points to the new law that was passed last year under RSA 40:11 that gives primary petitioners the opportunity to speak to and introduce any petition warrant articles. Doesn't change anything in the original bill as filed. It's just a pointer and a reminder to that RSA. And with regard to approval thresholds for SB2, Section 2 of the bill importantly contains some long overdue corrections in paragraph 13 that clarifies that some warrant articles are in fact approved by a 3/5 vote. Currently under the laws as they are now on the books, for some reason, the paragraph only states that votes under SB2 are by majority or a 2/3 vote. So in short, this bill clarifies accumulation of appropriations and warrant articles for moderators, the governing body, and the voters. It ensures consistency in how appropriations are accounted for in determining cap overrides, and it supports transparency and accountability at annual meetings for voters and local officials. And finally, it upholds the legislative intent of the laws governing both tax caps and budget caps in New Hampshire. And so for these reasons, I respectfully urge this committee to recommend House Bill 1134 ought to pass with amendment. Thank you, Mr. Chair. That concludes my introduction, and I'm happy to take questions.
Thank you, Representative Powers. Any questions, Representative? Representative Gilman?
Thank you, Mr. Chair, and thank you, Representative, for taking my question. Do you see, right now in SB 2 towns, bond articles have to be put first on the ballot, but the selectmen then set the rest of the ballot. Do you see an opportunity here for the selectmen to load the ballot up front and, get what they want? We're accused of being manipulative all the time. Is this not opening up another door for that?
Thank you for the question, Representative. So, as you state, yes, the order of the warrants on the order of the articles on the warrant is in fact determined by the governing body. And as you have correctly stated, that bonds by statute must come first. So I don't really see with this clarification, complement, supplementary explanation bill that changes anything that's currently in place. So your concern stands and it's there, whether or not we pass 1134. It's what is right now, if I understand your question.
Follow up, Mr. Chair?
Yes, please.
What I'm talking about is the warrant articles that are placed on the ballot after the bonds, and that some will be for 25,000 and some will be for 75,000. If the governing body really thinks that new sidewalk plow is important, would they not put that up to the front of the list of the warrant articles and then be accused of,
Thank you
Craft.
for restating your question, Representative. And if I do understand your question, and I believe that I do, my answer remains the same in that currently, right now, without House Bill 1134, yes, the governing body does determine the order of the articles as they are placed on the warrant. So I don't, again, see any change as a result of this bill.
Representative Howard?
Thank you, Mr. Deputy Chair. My question is concern about removing moderator discretion in managing the meeting flow when ballot voting is required. Does this bill potentially force a ballot vote even if discussion is incomplete or circumstances change?
So if I understand your question, are you concerned about a Roman numeral 2? So that
Correct.
section?
Correct.
And your question was?
Whether or not the bill potentially forces a ballot vote, even if discussion is incomplete or circumstances change.
Thank you for the question, Representative. I don't see that being an issue or a concern. I don't see a clear reading of lines 6 through 8 that could be construed to allow such conduct at a meeting. I have confidence that moderators act with high levels of professionalism, and I don't foresee that a moderator would read such a thing into this this bill. And so, to answer your question plainly, no, I don't see that anything in this bill would force or enable a moderator to, call a question, if you will, prior to debate. That is not how meetings are conducted. Meetings are conducted according to rules that are established and adopted by the meeting. So I don't believe that would happen.
Thank you.
Representative Colby?
Thank you, Mr. Chair. Thank you for taking my question. Really quick one. In regards to Section 2, is there, and I don't want this to come across as snarky, it's an awesome, honest question. Is there another way other than a yes or no ballot that municipalities have been voting on ballots?
Thank you for the question, Representative, and I'm happy to clarify any concerns that you have. So the wording says, if voting on a warrant article requires the use of a ballot. So in statute, there are types of warrant articles that in fact do require a paper ballot at a traditional meeting. So that's what this Roman numeral 2 is pointing towards. That law, the current law, not that this is going to change anything, it's just affirming it and making it clear that that vote will occur.
Follow up?
Yes, go ahead.
I guess I was more concerned, are people getting handed blank ballots at some town meetings? So that we have to define that the ballot has to be a yes or no? Or
Yeah.
it can't be agree, disagree, it has to say yes, no.
So yeah, thank you for
That's all.
thank you for the question. That's an important question, and my answer is that again, RSA requires the use of a ballot, and when we vote on measures, it's yay or nay. It's not cool or I don't want it, right? It has to be very, very clear, yes or no. And in my town, I attend 3 annual meetings, and 2 of them happen to be traditional. And yes, there are paper ballots, and it clearly it's pre-printed, and it's a yes with a box and the no with a box, and you check, because that's really important to have that, to be clear, so that when the individuals counting the votes can discern voter intent.
Representative Grund?
Thank you, Mr. Chair, and thank you for taking my question. So the petition warrant articles, which typically fall at the end, are also subject to the tax cap and budget cap according to this, because they would be falling in order. Is that correct?
So, yes, petition warrant articles are legal, and if they, follow the requirements to be placed on the ballot by citizens, and typically the governing body, for whatever reason, we typically see them being placed at the end. And so it depends on the petition warrant article. If it's the subject matter of that warrant article is such that, number one, it's allowed, it's a lawful petition warrant article that the legislature has allowed such a vote to be taken, and it requires a ballot vote, yes, it will. However, if the subject matter of a petition warrant article is that which the legislature has not given permission, if you will, if it's not, for lack of a better word at this point, a thing, then that petition warrant article is unlawful and is advisory only.
Representative Alwood?
Thank you, Mr. Chairman. If early warrant articles consume available cap space under the accumulation rule, is there any mechanism in the bill to prevent later articles from being effectively precluded solely due to their position on the bill, on the warrant or the ballot?
Thank you for the question. I will preface that by saying that clearly, I would say as a tip that the order that the articles appear on the warrant, they make a difference, and that the governing body is the body that determines the order. Okay, so that being said, you were concerned about downstream warrant articles potentially not passing. Well, that's why all caps, be it a tax cap or a budget cap, they must they must provide for an override mechanism. Otherwise, it's unconstitutional. And yes, the laws that are on the books are constitutional, and they do provide for an override mechanism. So to quell your concerns, so long as the voters deem that the warrant article, the spending is what they support, then there's that override mechanism. And if that vote threshold is achieved, then the spending can occur. So yes, despite the fact that there's a cap, caps can be overridden by the will of the voters.
Any further questions for Representative Power? Seeing none, thank you, Representative.
Thank you.
The chair will call Mr. Brody DeShays.
Thank you, Mr. Vice Chairman, and thank you to the committee for taking my testimony this morning. For the record, Brody DeShays, I represent the New Hampshire Municipal Association, and we are opposed to House Bill 1134 as currently drafted. Our qualm isn't the fact that the bill would formalize DRA's general practice regarding the 10% limitation established in RSA 32:18 as is cited in the bill. What's concerning is that it doesn't appear to give a traditional meeting the ability to go back and fix the problem of an overappropriation, which would be done by reconsidering warrant articles and lowering appropriations for those warrant articles. So when the Budget Committee presents a budget in the warrant articles, the legislative body has a limitation where it cannot increase spending by more than 10%. There are times where, especially in smaller towns, where smaller budgets and smaller appropriations, where that 10% limitation is reached, and it forces the legislative body to reconsider and go back to warrant articles and decrease appropriations, or even potentially limit them to $1, or take up the warrant article and kill the warrant article. So our concern is on specifically lines 13 and 14 of the bill in a traditional town meeting, because it's now going to be required by this legislation that the amount will accumulate in the order in which the warrant articles are taken up at the annual meeting. There would be a limitation on the legislative body's ability to reconsider. It would also arguably eliminate the ability of SB2 towns, town ballot form of meeting, ballot form of town meeting, to amend warrant articles at the deliberative session to add contingency language to express a preference about what happens if multiple articles pass and one of them has to be eliminated because the total appropriations go over the limit. So what we would ask is some additional flexibility in this legislation to ensure that warrant articles can be gone. The legislative body can go back to previous warrant articles, or to ensure that at the deliberative session or the governing body can add these contingency languages to warrant articles in SB2 towns. And with that, I'd be happy to answer any questions.
Thank you, Mr. DeShays. Questions? Representative Allwood.
Thank you, Mr. Chair. Thank you for taking my question. Who decides about reconsideration? Is that a moderator duty, or?
So thank you for the question, Representative Alward. So are you asking how the process for reconsideration on the warrant
Yes.
article? It would be the legislative body.
Okay.
So someone would make a motion to reconsider. It would need to be seconded. There could be debate or discussion on reconsideration. And then if it passes, you go back to that previous question. Very, very similar to how it would happen in the legislature.
Thank you.
Other questions? Seeing none, thank you, Mr. DeShays.
Thank you.
The chair will call Mr. Eric Power, please. Morning, Mr.
morning.
Power.
Good morning, Mr. Chair and members of the committee. For the record, my name's Eric Power. I'm from Brookline, and I'm here in support of this warrant article. This piece of legislation that talks about warrant articles. And I previously served on our Hollis Brookline Cooperative School Board, so I'm very familiar with this. I'm very involved in town government. As mentioned, I'm on the planning board. And I also are very active at the town meetings. I have one district that is a SB2, and then I have two the other district is traditional, and so is the town meeting. So I'm familiar with all the different forms of town meeting. Also, about 8 years ago, we put up a petition warrant article and for a local tax cap for our Brookline School District, and it was approved. So we have a local tax cap in place. So with the changes that have come up with HB 200 and HB 374, there's been a lot of discussion on how does the local tax cap work. And, you know, really the law as it exists today tells you what to do. There's some areas where you have to interpret. And so this bill is really an attempt to sort of put that in law, what's already sort of what you need to do, but put it in law so it's more clear for moderators, for governing bodies, for voters to understand how things work. And so it does make a lot of sense when you have a tax cap or a budget cap, the order of the warrants makes a difference. So you have to put what you think is most important first, and the voters at a traditional meeting decide the order in which they want to take up the warrant articles. And under SB2 at a deliberative session, the deliberative session can reorder the warrant articles subject to some RSA limitations. And so that's, you know, part of the legislative process under a tax cap or a budget cap. And keep in mind, these are budget caps and tax caps are not easy to adopt. You have to get a 60%. You need a supermajority of voters to put them in. So it makes a lot of sense that, you know, they want this. And so it makes a lot of sense to have some details on how this should operate. I think that, you know, I don't think the reconsideration, I've never seen a reconsideration where you've gone before and then want to go back and do something after you've already approved it. People usually restrict reconsideration. If you've seen moderators, that after something passes, they restrict reconsideration right away. So the thing that was talked about earlier, I don't see it being really something that happens. And this bill isn't really going to prevent that, I do not believe. I think there's also that oversight under SB2 in lines 21 and 22 of the bill that should have, 3/5 should have been in there a long time ago, and it's been overdue. So I think that's a correction that should have been made before. And it's always logical to have the ballot vote and actually have yes, no. We had a case in Brookline, in our Hollis Brookline Co-op, where we were voting on a turf field, and they had a ballot where you tore it in half, and people didn't know what that meant. Some people put both pieces in, some people put one in. So yes, no ballot makes a lot of sense to clarify that, and it ended up going to a lawsuit. It wasn't good for anybody except for the attorneys that made money. So for those reasons, I recommend this bill ought to pass, and ought to pass this amendment. I think the amendment that was put up is a good one because that helps clarify the new law under HB 228. I'll take any questions. Thank you.
Thank you, Mr. Powers. Any questions for Mr. Powers? Representative Grund.
Thank you, Mr. Chair, and thank you, Mr. Power, for taking my question. So it's actually two parts, so hopefully you'll let me have a follow-up. Would you believe that there are towns that actually do use the reconsideration throughout New Hampshire?
Thank you, Representative. There may be some that do it. I have seen it occasionally, but I haven't seen it recently because everybody restricts reconsideration immediately after something passes.
And your follow-up?
Thank you. So why would we restrict a process that's actually available to voters through this new bill?
Thank you for the question, Representative. I don't believe that this does anything to restrict that. It basically is giving the guidance to the moderator and to the voters on how you basically keep a scorecard under a local tax cap or a budget cap. You have to keep track of where you are with relative to the cap. If you want to undo something, this is not saying you can't subtract it out. You know, that's something that can be done unless you've restricted reconsideration. If you've restricted reconsideration, then you can't. But if you haven't, then you could go back. So I don't see that this limits this in any way.
Representative Allwood.
Thank you, Mr. Chair. Are there occasions where a warrant article is not acted upon prior to the final adjournment of a town meeting because it's not practical to continue the meeting?
No, thank you for the question, Representative. Every warrant article has to be acted upon, and that's why meetings sometimes last a long time, and they can continue the meetings. But you do have to act on every warrant article, and that's already in the law. Thank you.
Okay.
Any further questions of Mr. Power? Seeing none, thank you, sir, for coming in.
Thank you.
At this time, that was the last pink card that I have. Is there anyone else present who would like to speak on this bill? Seeing none, Representative Gilman?
Thank you, Mr. Chair. On the today's remote testimony, there were 4 in support and 15 opposed. And on today's blue sheet, there is 1 opposed.
Thank you, Representative. I now close the public hearing on HB 1134.
At this time, at this time, the chair will open the public hearing on House Bill 1427 FN, limiting the authority of a municipality, county, or school district to issue bonds. And the chair recognizes Representative McFarland, the prime sponsor, to introduce his legislation. Good morning, Representative McFarland, and welcome back to municipal and county government.
Good morning, Madam Chairman. Thank you, and pleased to be here to talk to you and to the members of the committee. First of all, briefly, I would like to address the fiscal note. What's striking is that the note does not identify any actual fiscal costs imposed by this bill. The tables show zero impact or indeterminable, and the narrative concedes that spending may go down. Of course, that's not a problem. That is the policy working as intended. Much of the concern in the fiscal note rests on an assumption that borrowing is the only way to plan ahead, and that's simply not true. New Hampshire law already provides for capital reserve funds, and this bill explicitly encourages their use. Planning and saving are not prohibited here in the Granite State. Routine debt is in this bill. The argument that towns might rush to issue bonds before the transition period ends, which is made in the fiscal note, is not a critique of the bill. It's direct evidence of the mentality and the behavior that this bill is intended to correct. The note also repeatedly warns about delays to emergency or critical infrastructure projects, but those projects are expressly exempted. Emergencies, public health, water, wastewater, public safety, and essential building systems are all remaining fully bondable if this bill were to become law. Finally, voter approval and accountability are framed as costs, and I would suggest that they are in fact safeguards, and liability applies only in cases of bad faith or fraud. In short, the fiscal note reflects a discomfort with fiscal restraint, not a demonstrated fiscal harm. And this bill strengthens planning, transparency, and voter control, and it does so without imposing new costs. With that said, I don't want to take more of the committee's time than necessary because the case for the bill is largely made in its text and in the statement of purpose. House Bill 1427, the SHIELD Act, the Sustainable Honest Investment and Elimination of Local Debt Act, is about good governance and intergenerational fairness. Borrowing today binds our future residents who never consented to the obligation. That should be the exception and not the norm. The principle is simple. Debt should be reserved for true emergencies, extraordinary circumstances, or when voters knowingly approve it. The bill also provides a reasonable transition period so that communities can adjust their capital planning without disruption. It strengthens transparency, reinforces voter control, and encourages the fiscal habits which the Granite State long has valued: prudence, thrift, and honest budgeting. In short, this bill does not prohibit necessary investment. It ensures that investment is deliberate, accountable, and honestly paid for. For those reasons, I respectfully ask the committee to recommend this bill as ought to pass, and I'd be happy, Madam Chairman, to yield to any questions.
Thank you, Representative, for your bill introduction. Are there questions? Representative Gilman is recognized for a question.
Thank you, Madam Chair, and thank you, Representative, for taking my question. From what I read here, what you're really looking at is lots of different checking accounts: capital improvement for a truck, capital improvement for a building, capital improvement for some other piece. If a new building has occurred or a renovated building happens in 1979, and the lifespan of it is about 20 years, 25 years, so you know at that point you're going to have to rebuild or add on. Would we open a capital improvement plan in 1979, hoping that we earn 17 million by whenever the building gets to the state of misuse?
So there's quite a few questions embodied in there, and I will try and attend to them. First of all, it is very appropriate when you are managing funds and the public trust that you use different accounts to maintain a track of what has been spent against the line items in the budget and against particular capital reserve funds. Many towns already maintain multiple capital reserve funds. I'm the trustee of trust funds in my town, where it's a small town, and we still have a couple of dozen or so capital reserve funds, which are all satisfactorily managed through the NHPDIP and accounted for in that way. As far as what type of planning and what type of reserves a town should have, I don't think it is our business here in Concord to dictate to every municipality and county and school district how they plan and how they see that their needs being. I will say again, with reference to my town, our townhouse is over 200 years old, and we have been perfectly capable of anticipating the repairs that are needed upon it and reserving money for that without any kind of crazy speculation of we need to reserve an amount sufficient to rebuild the entire thing. Whereas I'll give you a counterexample. In Grafton County, in which my district lies, we have a county commission who is trying to bond $47 million for a new county courthouse and is not even willing to contemplate in a meaningful way what is it going to take to refurb and maintain the existing premises, or what other options that are more fiscally prudent are available to them. I hope that answers your question.
Yes, thank you.
Further questions? Representative Elward is recognized for a question.
Thank you, Madam Chairman. Welcome to our committee. Does this bill affect bonds that are already authorized or issued? And if so, how are existing contractual obligations protected?
It does not.
Thank you.
Further questions? Representative Majori is recognized for a question.
Thank you, Madam Chairwoman, and thank you, Representative, for taking my question. And it kind of piggybacks a little bit onto what Representative Gilman said. A number of years ago in Northampton, we identified that our library and our fire and police department were both were not ADA compliant. Furthermore, we knew that neither the police nor the fire had adequate facilities if we would have hired a female officer. With those items, now when the facilities were built, they were, and I'll put in quotes, compliant. Could those issues be considered emergencies and therefore allow us to bond?
I think it's an interesting question. From my perspective, and I am not a lawyer, I would view that if the facility was in that kind of a way non-compliant with the ADA, that it becomes a public safety issue, especially if you were to have residents and constituents in your town in the building and then unable to egress properly in an emergency. So in that sense, yes, I believe it would be.
Representative Colby is recognized for a question.
Thank you, Madam Chair. Thank you for taking my question. A community building used primarily for recreation is also the only declared emergency shelter in a community. The cost to repair or replace that building is $12 million, and it currently exceeds the provisions placed in this bill on page 1, lines 25 through 29. The governing body argues that non-replacement would be a threat to public health and safety. Under your bill, would they have the right to bond for this replacement?
So I take it that what you're presenting is a hypothetical?
Yes.
Thank you. I'm not familiar enough with the details of the hypothetical you just walked through to be able to answer the question yay or nay. I think there's questions that we might engage in if that was the true circumstance. And I think one of the questions that I would be asking is as to what other opportunities are available to satisfy that need.
Follow up?
Yes, thank you. So I'm telling you about a scenario that has happened, minus the restrictions. And in this case, on line 16, you say that provided that the finding by the governing body made in bad faith or with fraudulent intent shall be subject to members voting in favor to personal liability. So I guess I am presenting a situation that is very real, that has happened. Are we saying that we don't know how to interpret this bill?
I don't believe I'm saying that. And I would also say that I do not find it objectionable to suggest that if you have elected officials acting fraudulently, that they should be held to account for that.
Further questions? The chair recognizes Representative Grund.
Thank you, Madam Chair, and thank you, Representative, for taking my question. So nowhere in here, even including under essential infrastructure, do I see schools being mentioned as something that you could bond. Schools can cost $50 million easy, except the only reference could be to secure federal or state matching funds with state building aid is one of those state funds available. But with a minimal amount in there, most schools can't access it. So towns are choosing to produce $30 million bonds to pay for this. So you're saying they can't do that?
What I am proposing, first of all, I think that schools are encompassed in here in a number of ways relative to the provisions around things like emergencies and public safety and water and so on and so forth. But if you're talking, which I think you are from your question, if you're talking about building an entirely new school, then I would put it to you that it is not a typical circumstance that a community out of nowhere suddenly requires an entire new school that has never had a school before. That is akin to creating a new town and creating a new set of residents in that town. And under those kind of circumstances, there is provision in this bill for precisely that circumstance to have a vote of the people and to have this be the decision of those voters.
Follow up?
Thank you. So can you clarify then a school district right now or a town right now is looking at dropping their school and rebuilding a new one? Would they be able to bond that next year, or would they be able to bond it in 2032?
I see. So I'm going to take your question in two parts, because I think, first of all, you've changed the hypothetical to where there is an existing school and there is a decision that there is a need to wholly replace it. And I think that that is an entirely different scenario than we're going to create a school out of nowhere. When you have an existing school and the circumstances are incrementally changing to the point where a reasonable decision may be made to replace it, that is not unforeseeable. That is not something for which municipalities and counties and school districts should not be able to plan. And in this case, the school district, I put it to you, should have been able to foresee that, should in the future be able to foresee that, and should be able to plan for it. The second part of your question, I think, is as to whether they would be able to do that next year. And as I indicated in my testimony, there is an introductory period where bonding is allowed for several years without these restrictions until this bill would take full effect.
Further questions? Representative Walker is recognized.
Thank you, Madam Chair. You mentioned in this bill that if you wanted to do a bond, you'd have to go basically back to the voters to get it authorized. But that's in town form of government. When you're doing like a city, is that the governing body that would make that decision, or you're still looking for a referendum vote from the people?
So if I anticipated when you started asking the question that you were going to say if it was a school district or whatever, and I'd be like, we know who the voters are for that. I don't know the particular legalities around cities, and whether there is a problem in the language here relative to cities, I can't comment on. I would be happy to go back and look at it, but I'm not familiar with the nuance that you're saying is different in the case of cities.
Follow up?
Yes.
Yeah, the city's representative form of government, and the people don't vote on the budget or anything. The city council does. So that's what the angle of my my question.
That makes sense. I think it's a very good question, and I don't want to answer off the cuff.
Very good.
The chair recognizes Representative Majori.
Thank you, Madam Chairwoman, and thank you for taking another question. My question is with regards to one word on line 27 in section 3. And it's regard to the bond shall not exceed 100% of the entity's annual budget. So if this were a school, would the entity be could it be the entire town, the cooperative school district inclusive, or is this just the school?
In my view, the word entity here is acting on the previously stated words at the start of that same sentence, a municipality, county, or school district. So in your example, I believe it would be the school district, sir.
Further questions? Representative Elward is recognized.
Thank you, Madam Chair. Thank you for taking my question. So has any analysis been done on whether limiting bonding authority could delay or prevent critical public safety, water, or school projects?
Yes. And I think that there are differing opinions on that. We've heard from the New Hampshire Municipal Association that they believe it would create those kind of issues. And we've heard from me that I don't believe that it would. And I'm sure that there are other opinions that will make themselves known here.
Thank you.
Representative Stavis is recognized for a question.
Thank you, Madam Chair, and thank you for taking my question. It concerns section small b, lines 19, no, I'm sorry, excuse me, section A, lines 14 through 18. Provided that a funding by a local and governing body made in bad faith or with fraudulent intent shall subject the members voting in favor to personal liability under RSA 3139 and other applicable laws. How does the due process work in that situation? And follow-up question is, do not select board members and other government officials have a level of immunity from these things?
So I very much appreciate the question. And I would say that we do indeed have a number of different statutes on the books already, which govern these kind of concerns. And 3139A, the conflict of interest ordinances, is one of them. I'm not looking to change any of those existing statutes. And I do think that in this case, it is important that we make a distinction between people who are serving their communities and acting in good faith and acting honestly, and people who, in a hypothetical circumstance, and I'm not saying that this would happen, but people who would just arbitrarily attach an emergency designation to any kind of spending whatsoever.
Follow up, Madam Chair.
Yes.
Could somebody just arbitrarily accuse a select board member or a city councilor of voting of fraud or fraudulent intent? Where's the due process?
It's my understanding that people can sue whomever they want, whenever they want, today.
Thank you.
The chair recognizes Representative Colby.
Thank you, Madam Chair, and thank you for taking my question. Page 2, Section E, seems to encourage voters to stay home. Do we have concerns that we are going to we are going to encourage people to not participate in an election and in SB2 communities, in other voting activities, because it is more prudent. We are prioritizing in this bill as more prudent to stay home and not reach the 50%, 51% of registered voter threshold.
I think it's a very interesting viewpoint. In my opinion, a registered voter who is looking to be engaged in their community and fiscally responsible, I believe, is the type of voter that you're painting here, is likely to want to come out and vote for any other warrant articles as well. And I think that if anything, this would encourage participation in the process, but I do understand that there may be times when members of a body try and avoid a quorum for a certain decision.
The chair recognizes Representative Grund.
Thank you, Madam Chair. So my question, I'll end up having a second one, but my question following up on Representative Davis's. So when you have a bond, there's required public hearings and public discussion where anybody can come and information has to be discussed and displayed in So how would this be calling a selectman or school board member placing this ballot, this article on a ballot fraudulent or being done in bad faith when it's a public hearing?
With respect, I didn't describe any individual as having done anything in bad faith or with fraudulent intent. I put in a safeguard here.
Further questions? The chair recognizes Representative Majori.
Thank you, Madam Chairwoman. Thank you for another question because it's about, again, one word, and I'm sorry I don't have the line number. But in section 5, Roman 5, little a, it says the action may be brought by a taxpayer of the issuing political subdivisions. There are several communities, many communities, where there are residents who do not pay any taxes because of credits that have been issued. Does that exclude them from being able to bring action?
So I think you're describing a circumstance where the net taxation paid by an individual is zero or negative. Is that right?
Yes.
In my opinion, if they pay taxes, even if they subsequently get monies back, they are a taxpayer. However, I am happy to consider that question in greater detail with you afterwards. But in my opinion right now, they would still be taxpayers.
Further questions? Representative Colby is recognized for a question.
Thank you, Madam Chair, for allowing another question. We have many today. And thank you for taking my question. For page 1, line 8, who is the arbiter for a true emergency or an extraordinary circumstance under this bill?
I believe that that is laid out on lines 14 through 16 of that same page.
As a follow-up,
Yes.
those descriptions aren't the same. We have a true emergency on line not on 8, and we have a described definition for a declared emergency. We have no definition for extraordinary circumstance or true emergency. So I'm wondering also, and who would be the arbiter?
I see.
to
So
decide.
your question is to whether or not the text in the statement of purpose, section 2, is text which is relevant from a statutory interpretation and from a legal basis? The answer is no. A statement of purpose provides you with understanding as to the intent of the bill, just as this testimony does, and just as any majority or minority reports may do in any testimony on the floor of the House. However, the governing language as far as the statute goes does not include any of the text on lines 3 through 9.
Oh, I was waiting to see if you had a follow-up. Further questions? Seeing none, I had a question. So while I understand the intent of the bill is to promote fiscal responsibility and prudence with regards to the burdens placed on residents as taxpayers, could you comment with regards to this bill as filed with respect to a situation that I have first-hand experience with? So I think it might have been 15, 20 years ago. My town is part of a cooperative school district, and a very old high school was being utilized as a middle school. And due to the growth in both towns, that middle school was no longer able to serve the student population. So there was a study commission that was stood up, and they looked at the issue, and there was considerable, input, public hearings, study, et cetera. And obviously the options would be to renovate the existing original, extremely old building that was designed as a high school decades ago. And that's where the current building that was under consideration. One of the options would be to add on to that and renovate some portions of it to accommodate the needs of the school. The other option was to build a totally brand new school on a site, and it would be modern, energy efficient, better environment overall with modern building science and features, et cetera. And interestingly, brand new build was less expensive, less costly to the taxpayers versus we're going to renovate something that's old and add on. Well, voters decided to go with a renovation, and there was a reason behind that. I won't get into that, but I will say that it's a cooperative school district. The original school was in the bigger town. The new site was in the smaller town. Connect the dots. But my concern is my understanding of this bill would prohibit the more fiscally responsible and prudent decision if the voters so chose. Is that a correct interpretation?
I don't think it is. And I mean, I'm certainly not, Madam Chairman, going to comment on the circumstances you outlined. It sounds like in that case, there's a strong argument to be made that the voters made an unfortunate choice. At the same time, whatever the actual usage of the funds is that's being sought, I do believe that there are several ways within this bill that spending could have been authorized, whether it is by going to the voters, making the case, and having them approve that bonding, whether it is by making sure that the funds are properly reserved and planned for in advance, or whether it is by obtaining a matching funds arrangement that excludes it from this statute. I think those are three, and there's probably other ways of taking care of that issue.
Well, thank you for the answer. And unfortunately, maybe I provided too much detail that muddied the question at hand. So my understanding is that this bill at its core, it seeks to limit bonding authority. So my understanding of this bill is that the preference, not, I don't even think it's the preference, it's the procedure is first and foremost, if you have an existing structure, building, that this bill requires the establishment, like another committee member said, ahead of time. It eliminates bonding. So it seems to me that when bonding is limited and reserved only in emergency situations, you're eliminating the option in like my instance, minus all the extra detail that was probably unnecessary, to bond a project like that, which would in fact be less expensive to taxpayers. But instead, what this bill does is it takes that off the table and says, you need to establish a capital reserve fund. If you want to build a brand new building, you need to save over a long period of time. And I think that one could argue that that's difficult.
Understood.
And what the bill is doing is saying, which if you want to address school capacity, you're going to have to do like the addition, renovation, which in the end, which is contrary to the intent of the bill, is going to cost, in fact, more.
Understood. I think I understand the point of your question, and I would say these two things to it. First of all, yes, it is prudent to plan for things. If a town knows that a roof is going to last 50 years or a plow truck is going to last 20 years, they have that time to plan for the purchase of not just a renovated roof, but also a new plow truck. There is nothing in this bill that is advancing the cause of renovation and refurbishment over new build or new purchase. What this is doing is encouraging fiscal prudence and planning and foresight. Thank you.
Thank you. The chair recognizes Representative Grund.
Thank you, Madam Chair. And following up on Representative Power's question, we have schools right now, including in my town, that they're looking at building new, like dropping what they have really new, renovating, but it may not come forward for a couple years because it takes time to work with architects and everything. We can't save up $50 million in the next 2 years. So you're removing the ability, the question is, are you removing the ability, which is exactly what the question was before, of school districts to do anything the next 50 years, because it's going to take 50 years to save up that amount of money to do anything on a school.
Well, I'm not going to comment on how long it may take Amherst, whether it's 2 years or 50 years to save a number of millions of dollars. What I will say is that when you are in a circumstance, as you describe, of wanting to spend tens of millions of dollars on a new facility, I understand why it may be in the interest, the selfish interest of certain parents to say, I'm going to commit the children and the children's children and the future residents in this town to paying for that long after I'm gone. But I do not believe that that is appropriate fiscal planning.
The chair recognizes Representative Frucht for a question.
Thank you, Madam Chair. Following up on Representative Grund and probably Representative Powers' questions, with perhaps a slightly different slant. If a school board has a school building that is currently 25 years old, and this bill were to go into effect, the school board then says, okay, we need to plan to renovate or replace this the building in, let's say, another 75 years. Let's start saving up for it. At year 64, it becomes imperative, for whatever reason, to build a new building or conduct those renovations. The cost of the renovation has gone up despite, figuring in inflation. The amount of students that are needed or that would be attending that school has changed either up or down because population shifts. And the school board hasn't saved up enough money at year 62 to do what is required. And they're coming up, let's say, $4.5 million short. What are they to do?
Sadly, I think that the scenario you paint, David, is one which is plausible. And I put it to you that in the 62 years between now and then, that governing body has many opportunities to observe and course correct.
Yes, Representative Fract, you may have a follow-up.
Thank you, Madam Chair. Despite the best efforts to course correct, they come up short and they need an extra $4.5 million. What are they to do?
Again, I think there are many different options that may be available to them, whether it is to go to the voters, whether it is to seek charity, whether it is to do something slightly different in the new build and maybe provide for a new build that is built in multiple phases and defer part of it. There's all kinds of options, but it's not our business here in Concord to tell every different locality how they should do things.
Yes, and then Representative Davis can ask a question.
Is it really our business here in Concord to tell local schools or local municipalities what they cannot do?
When I talk with the constituents whom I talk with about their property taxes and the changes that these property taxes are making to the landscape of New Hampshire, I believe it is.
Representative Davis is recognized for a question.
It's going to be a repetitive question. Thank you, Madam Chair. Thank you for taking my question. You just said verbatim, it is not our business to tell municipalities what to do. This bill tells municipalities what to do from start to finish. How do you reconcile those two things?
Well, with respect, I think there's a difference between saying what and saying how, but as you said, Representative, I think we are getting into the point of repetitive questions. And so, Madam Chairman, I do not yield to further questions.
Okay, thank you.
Thank you.
Next, the chair recognizes Representative McGuire. Good morning and welcome to Municipal and County Government.
Thank you, Madam Chair, members of the committee. For the record, my name is Dan McGuire. I represent the town of Epsom. What I want to do is, so I'm a strong supporter of this bill, and what I want to do is raise the level of the discussion from the minutia to the bigger picture, and to make the point that savings is better than it is commonly thought, and borrowing is much worse than commonly thought. All right, and I'll use some examples here, but when you save, you get not only what you've saved, but you get the earnings of what you've saved over that period of time. And those earnings can be substantial, right? I mean, the whole point of savings is that those earnings are typically, frequently, almost always greater than the rate of inflation, and therefore you end up with more than you would have had you than just what you've saved over that period of time. Similarly, borrowing is worse, right? Because when you borrow, not only do you have to pay back the value of whatever it is you borrowed for, but you have to pay back plus interest, right? So that interest is an added burden. It makes the thing that you borrowed for even more expensive. And let me give you some sort of concrete examples. One of my favorite examples of growth is this. Okay. Less than 80 years ago, there existed in the entire world one transistor. It was on a lab bench in New Jersey in AT&T. Today, this has over 1 trillion transistors, right? When you save that kind of growth, that incredible productivity and growth, you earn it, right? It works for you, okay? Let's talk about borrowing. And I'll talk about something that's hurting every municipality and the state itself, and that's our pension debt. Right now, and I know this well when I work on the budget, right now, every employee's pension throughout the state, I'm talking about every teacher, every municipal employee, policeman, every state employee, and so on, who's in our pension system, which is essentially everyone, their pension cost is twice what it would be if we had no debt. If we had no pension debt, if we had saved enough along the way, if we had saved the appropriate amount, every employee would cost 10% less than they do now. All right? So what does that mean? That means that if we had no pension debt today, which we should not have, but bad decision making of previous members of this body and others, everyone today could have a 10% raise, and it would cost the taxpayers nothing extra, right? Or you could have 10% more employees, or the taxpayers could pay 10% less on those personnel expenses. That's the level of problem we have with borrowing. It's that simple. And this bill, which encourages savings, right, is extremely appropriate in my opinion. Now, I'll just mention, I'll take some questions, but I'm sure we're way over time. But what I handed out is somewhat for amusement, maybe, but it's some wisdom from the past.
Representative McGuire.
Yes.
Perhaps you weren't in the room, and I didn't announce this at the beginning of the bill, but in-person testimony, due to the number of cards, is limited to 3 minutes. Would you be able to wrap up your testimony in a sentence and then take questions?
Yeah. So what I handed out is wisdom for the past on the subject of debt. And also, if you hate this bill, I put a bill from my committee that you will like.
Thank you. Questions for Representative McGuire? Representative Grund is recognized.
Thank you, Madam Chair, and thank you, Representative, for taking my question. So last year we heard a bill about the percentage of registered voters that show up and what would count for or against. In page 2, line 11, it requires at least a majority of all registered voters to participate. One of our arguments was we can't force people to show up. So why is this bill, why is it making a determination that those who show up don't have a voice in their town, potentially? Or maybe a better way to say is, why do those who don't show up have a greater voice than those that do?
Well, I guess, thank you for the question, but I would argue with the second half of that showing, because of the 2/3 vote needed to go, when you show up, you have your vote is twice as much and you're against, right? Your vote is twice as much as those for. So whereas not showing up is more of a 50-50 situation, right? But the main purpose of that whole section, in my opinion, and I didn't write it and so on, but it's to make sure that there is broad agreement across the entire municipality, the voters, that they want this debt, right? I'm trying to make the point that debt is bad, right? And worse than you think, all right? And so in order to, this provision, that's an important provision that makes sure that when we want to go into debt, we have extra. We have broad agreement across the entire electorate that we should do so, because when you go into debt, you gain what you want right away. But any voter who finds later that the debt burden is too much, they have an easy out. They can leave, right? And leave everybody behind who's burdened with this debt.
The chair recognizes Representative Davis.
Thank you, Madam Chair. Thank you for taking my question. Would you advise a young couple wishing to buy a home in New Hampshire and having a couple $100,000 to put down on a $500,000 house not to obtain a mortgage?
Yeah, thank you for this question. And I'll tell you, I want to answer it with my example of my life, okay?
Point of order, Madam Chairwoman. What does this have to do with the bill?
Wait, the chair recognizes Representative Majori. State your point of order.
I don't understand what this has to do with the bill. We're talking about a municipality's ability to bond.
So I understand what you're saying, and to be fair, the committee member had asked a question with regards to taking out a mortgage, and the witness is about to answer that. Would Representative Stavish wish to withdraw her question?
Absolutely.
The question is withdrawn. Further questions? Representative Gilman is recognized for a question
Thank you, Madam
about the
Chair.
bill.
It will be about the bill. My question is I know the local government will have the decision-making about what goes in, how much goes into each capital improvement project fund, or capital project fund. But do you foresee a time, because we need to grow things up, and because we know that construction costs today are going to be 40% more in 30 years, do you see that we might have a warrant article that consists of capital fund for this, capital fund for this, capital fund for this, a capital fund for this, a capital fund for this, a capital fund, putting in some amount of money, plus we have to pay for all the employees, et cetera. So, how long is the ballot going to be?
Well, I don't know. Thank you for the question. I guess my experience is we already do this sort of stuff, at least in my town. I don't know. Our municipal ballots tend to be 4 pages or 5 or something like that. So I don't know.
Thank you very much.
Further questions? Representative Colby is recognized.
Thank you, Madam Chair, and thank you for taking my question. I understand the two schools of thought behind bonding. I do. Bonding tends to be a way to balance a healthy, fiscally responsible savings plan. That is how it is typically best used. So by not allowing more than 10 years, do you think that the unintended consequence of this bill would be that municipalities they have 1 year to save, according to the date of when this shall kick in January 1st of '27. So if they only have $3 million saved towards a project and I just, they have a year to save. So are we placing an unnecessary burden onto already strapped taxpayers by forcing them to pay off a debt in 10 years versus 20 when they may move out in 10 years? You can reverse this philosophy all we want to. We can say that, I guess, so I'm trying to understand how this will help and not just shift a burden.
Thank you for the question, but from my point of view, I don't really agree with the premise of the question, and it's not really what I'm here to testify about, right? I'm here I'm trying to make the point that borrowing is much worse than you think, all right? And that if you're making the point that it's difficult to get from a world where we borrow like crazy, right? Okay, it is difficult, right? But you know, the journey of 1,000 miles starts with one step, right? I mean, you have to take a step to change this current poor situation to get to one where you're flush, because that is worth getting to. It is worth going in that direction. That's the point I'm trying to make.
Further questions? I do have a question. So it's follow up to Representative Gilman's question, and she was asking about a concern about multiple warrant articles to raise and appropriate taxes for the purpose of funding capital reserve funds. So do you have any concern, or do you see any issue with regards to the bill as it's filed with that type of a mechanism, whether it be one capital reserve fund or maybe, I don't know, 10, and that taxes are being raised from taxpayers in the now for a project that may or may not be even come to fruition in the future? And that's very different than a bond where the voters voted on it and it's happening. And we're paying for it, albeit it might depend upon the terms of the bond be 10, 15, 20, even 30 years. So that being, there's a difference, and between, yeah, I think you get it. Could you respond?
Yes, thank you, Madam Chair. So I'll make a little bit of a concession. When you as a person save money and invest, you do it in general, right? You don't make an account that says, well, this is my car account and this is my house account necessarily.
Representative McGuire, I'm going to interject and ask that you respond in the framework not of a personal finances, but of municipal or political subdivision, because that's applicable to what we're talking about. It's a political subdivision in taxes.
Thank you, Madam Chair. But the point I'm making is, I don't believe we gain some kind of strange characteristics when we come together as a community that don't derive from those general characteristics when we're individuals. And so I think what's wise for the individual is wise for a group of individuals as a community. And what I was about to say is, I will concede that it's difficult. It's unnecessarily difficult to plan if you have to plan in the sense that I'm making an account for X and a separate account for Y and a separate account for Z. You wouldn't do that as a person, and maybe you shouldn't have to do that as a community. I mean, you're right in the sense that that's the structure of our existing law, but we're here to fix law and improve it and so on, and that could be a possible improvement.
Thank you. Further questions? Representative Colby is recognized.
Thank you, Madam Chair, and thank you for taking my question. I do like old sayings, and one of my favorites is penny wise, pound foolish. So if my project, are you aware that if my project is $7 million and I can get $2.5 million in a grant, 1.5 million is coming from my capital reserve fund, but I require 3 million for a bond, that would not be allowed under this.
Thank you for the question, but I believe you're incorrect because this bill does just say it doesn't apply when there's grants money involved.
On page 2, line 8, securing federal or state matching funds, provided that the value of such matching funds is at least equal to the principal amount of the bond issued. So I would have to turn down $2.5 million or, insert your
I see
own
what you're
number
saying.
there.
Yeah.
That's penny wise, pound foolish in my eyes.
All right, thank you for the question. So this is not, my testimony is not related to that kind of a detail. If you think that detail is wrong,
Point of order,
feel
Madam
free to
Chair.
change it.
Did you finish your answer?
Yes?
Okay. Representative Stavis is
I would hope
recognized.
that the representative testifying would answer the questions in the context in which they're asked and not continue to refer to his own personal life story.
Further questions? I'm seeing none. Thank you.
Thank you, Madam Chair.
Next, the chair recognizes Representative Murphy. Good morning, it's still morning. Good morning, Representative Murphy, and welcome to Municipal and County Government.
Great. Thank you very much, Madam Chairman, and thank you, colleagues, for taking my testimony. For the record, I'm Representative Mary Murphy. I represent Hillsborough District 27, which is the towns of Deering and Francistown. The town of Francistown does use reserves to try and save for big-ticket items, but they have in the past secured bonds as well for large capital improvement projects. The town of Deering does less of that. They're not as good at setting aside reserve money. It's something that we're working on together. I came here because the number one complaint I've heard, and I'm sure you guys share this from the taxpayers, are that the property taxes are too high. So they're looking for us to try and help give them relief. And another problem that they see is that the participation rates at some of the town meetings where these large capital projects come up, are frequently poorly attended. And that's something that you and I can't fix, really. It's really the town themselves has to heal themselves. So what I see this particular legislation doing and why I'm here to support it is that I feel that it will make people more conscious of the fact that, bonds are a big responsibility and a big expense, not just on the current residents of the town, but the future, generations that are going to inherit this debt. And, but, one of the positions, like you had mentioned, Madam Chairman, about the school project. And I just wanted to call to your attention, and hope I'm interpreting this correctly. On page 2, line 4, it talks about for repair or replacement. So in the scenario you described, it appeared to me that the school was not meeting the town's needs and it had to be replaced. And that appears to be one of the exceptions, I think, or at least I interpreted that way. And if I misinterpreted it, maybe this is something that needs to be clarified in the law or in the bill as presented. So just to kind of wrap up, from my perspective, capital expenditures are one of the biggest expenditures or biggest contributors to local taxes. And this bill is seeking to ensure that projects expensive enough to require a bond are truly needs and not wants, and so that current and future residents are not burdened by high property taxes going forward. It's also seeking to ensure that a supermajority of the total voters in the town, and not just a vocal minority who shows up for the town meeting, agree to this debt. Again, have some skin in the game. So that is all I had to say today, and I appreciate your attention.
Thank you, Representative Murphy, and I appreciate your commentary and an attempt to clarify and answer my question. Referring to page 2, lines 4 and 5, it does say that and in my example, I don't think that would be fulfilled by this because it says that you did note replacement, but it does say clearly essential infrastructure whose failure poses a threat to public health, safety, or welfare, and a school needing to be expanded or it doesn't fall under that category. So you're willing to take questions, is that correct?
I am.
Okay. Questions for the Representative Murphy. Representative Grund is recognized.
Thank you, Madam Chair, and thank you, Representative, for taking my question. So what you mentioned earlier regarding the essential infrastructure, to me, when I read that, I don't see school district being listed or mentioned or even thought about. So can you clarify how you believe essential infrastructure includes school districts or schools?
Well, as you may or may not be aware, Francistown is attempting to withdraw from Conval. So we consider our elementary school very essential to our community. And so I guess that's my perspective. I really feel that particular public elementary school is a very important part of our town. And so we'll do whatever it takes, like to keep that thing open. And that has the support of a town that is mostly over 65 years of age. So we're really doing this for the next generation.
Further questions? Seeing none, thank you.
I appreciate it. Thank you.
Next, the chair recognizes Mr. Power. Good morning and welcome back.
Thank you, Madam Chair and committee members. I'm Eric Power from Brookline. I also serve on our Brookline Planning Board going on my 6th year. And I'm also a fiscal conservative, so I am concerned about the bonds. The bonds right now, to approve a bond is a 3/5 vote, a ballot vote, either SB2 or traditional or charter. Just to give you a little bit of background, when SB2 was invented back in 1995, the threshold for approving a bond then was 2/3. And back then, the traditional meeting was 2/3. In 1999, the legislature decided, well, we have a lot of people voting, so we need to make it 3/5. So it changed in 1999. Stayed that way for a while, and then traditional meetings said, well, it's too hard for us to pass bonds, so let's lower it down in the year 2020 to 3/5, and that's where we stand today. So we've been to the point where we had a 2/3 supermajority needed to do bonds, which is a 2-to-1 ratio. I think I like the part of the bond. I'm speaking in favor of this bill, but I do think it might not make it all the way through the legislature in its current form. But an amendment that might be more palatable might be something along the lines that a 2/3 majority would be required by ballot, unless you have a charter and you've specified 3/5. So I wouldn't override a charter that already has that. But I would say that would simplify a lot of the nuances that have been discussed today, and it would also provide the first step towards making it more fiscally responsible, raising the bar a little bit. Everybody understands what it takes to get 2/3. And the other possibility that you could look at doing would be to, put it on the official ballot in the towns and school districts that have the traditional meeting, to get the number of people out there. They have the all-day balloting, because in a traditional meeting, you get an hour to vote, depending on when it takes place. In my co-op school district, we literally started voting on a multi-million-dollar bond at 1:30 in the morning till 2:30 in the morning. I don't really consider that democracy, but that's what happened, and it didn't pass. But this would be much more fair. It would get to the point where you'd get more people voting, because they would have all-day voting. And the 2/3, I think, is something everybody can understand. And we've been there before, and I think we should go there again. I think a lot of these other things are good in this bill, and I do like it, but I think it might be a little too much to actually pass through the House and the Senate and the governor's desk. But I think this 2/3 idea is a good first step. As was said earlier, the journey solving this starts with, it's the first step in 1,000 steps, and I think this would be a very good one, and a lot of people would understand it. So with that, I'll take any questions.
Are there questions? So I have a quick question. You made a suggestion for the committee to consider an amendment that that would change for a traditional town meeting how bonds are voted upon, and you said to put it on the official ballot. So that question would be voted on election day when voters go to elect officials. And also, typically zoning ordinances appear on the ballot. So my understanding is correct, and I perhaps explain further why you feel that placing a bond vote on the ballot is reasonable.
Thank you for the question, Representative. I think it's reasonable because, as mentioned earlier, public hearings are required, at least one, and in controversial ones. I know in my neighboring town of Hollis, they're having a nearly $20 million proposal for a bond, so they're having multiple hearings. So you have multiple hearings, multiple ways to talk about it. And unlike many other warrant articles, the question to adopt the bond or not is not amendable. So it is an up-down vote. You can discuss it more at a traditional meeting, but I think if you have enough you have the public hearings and you're going to be able to vote on an election day, I think that's the right way to go in a traditional meeting. And in a deliberative session under SB 2, you have that discussion and you have the official ballot vote already. And the charter can do what the charter wants to do, but I think that makes a lot of sense. You have the opportunity to understand, so you'll have informed voters and you'll have the turnout that you would get, and more people would vote, and that would reflect the will of the town or the school district.
Well, I have a follow-up, and there was, I don't know if there was a previous bill that we had heard, and Representative Walker made mention of the applicability of the legislation in front of us with regards to cities, because their governance is different than for political subdivisions such as towns, school districts, village districts, and charters. So my question would be, the amendment, if that's the way the committee wanted to go, would have to accommodate a ballot referendum in cities. And additionally, how would, I see that the bill, in the analysis, it speaks to limiting the authorities and it includes counties. How would something like that be handled? Would it go to the voters in the county? Would it be part of would the county delegation? Well, we already vote on things like that. Could you expound?
Thank you for the question again. So before we always had the legislative body is what had to get the 2/3 vote for a bond. And I believe that, I don't remember if that's for counties, but certainly for cities. So legislative body in a town and a school district is the voters, generally, unless you're in a city. In the city, it's the city council that is your legislative body as well as your governing body. And so the law would apply to them. In a city, they would just need the 2/3 vote of the governing body or the legislative body in a city. So I think it would be very clean and way to get there, and still make sure that as mentioned before, debt is not something you should take lightly. And if you get a super majority of 2/3, that's a great first step compared to where we are now. And that would make it a lot harder for folks to put things forward that aren't really needed. And it would also allow the path for things that are really needed. Thank you.
Further questions? Seeing none. Representative Grund, you sure? Yeah. Okay. Seeing none, thank you.
Thank you very much.
Next, the chair calls Ms. Trombley.
I would actually like to ask, in spite of having duplicative testimonies, could we have Christopher Coates, who is the county administrator for Frederick County, also join me?
Sure, I also have a pink card for him, so the chair will recognize at the same time Ms. Trombley and Mr. Coates. Good morning and welcome to Municipal and County Government.
My name is Chris Coates. I'm Cheshire County Administrator, and Cheryl Trombley is the Finance Director for Cheshire County. We appreciate the opportunity to testify before you today regarding House Bill 1427, as known as the Sustainable Honest Investment and Elimination of Local Debt, or SHIELD. We wish to begin by stating that Cheshire County shares the values expressed in the bill's statement of purpose. Prudence, stewardship, fiscal responsibility are principles that guide Cheshire County government every day. Counties do not borrow lightly, nor do we rely on debt as a substitute for planning. However, we are deeply concerned that the framing and the substance of this bill imply a lack of honesty or discipline among local governments that is not supported by fact or existing law. We hope to provide clarity today by explaining how counties already operate under extensive statutory controls, why this bill would be unworkable and harmful if enacted. This bill asserts that bonds create unfair burdens on future generations, therefore paying for something they did not choose. Counties are political subdivisions of the state that are required by statute to operate and maintain numerous programs, facilities, and services. These obligations are not discretionary. They are mandated by law. Our elected officials are legally required to adopt budgets that allow these programs to exist and remain compliant with state and federal regulations. When capital investment is required to meet those legal obligations, bonding is sometimes the only practical tool available. Further, the length of bonding cannot exceed the life of the asset, which aligns with the future generations benefiting from payments of ongoing debt. Turn it over to Cheryl at this point.
So the Municipal Finance Act, which is the RSA Chapter 33, already establishes a comprehensive and conservative framework governing public borrowing. This framework exists precisely to ensure fiscal discipline, transparency, and oversight. The SHIELD Act would effectively dismantle much of that framework by prohibiting bonding for nearly all purposes after January 1st, 2027, regardless of legal necessity, infrastructure life cycle, or statutory requirements. RSA 33(3)A provides a clear safeguard governing the use of bond proceeds. It explicitly prohibits the use of bond premiums to expand or inflate the scope of a project beyond what is originally authorized. This ensures that borrowing remains tightly tied to the approved purpose. This protection already addresses concerns about misuse or expansion of debt. Counties do not issue bonds unilaterally. In Cheshire County and all counties, any bond issuance must be first presented at a public hearing and then approved by a majority of the county commissioners, the county executive committee, and ultimately by a 2/3 vote of the county delegation. This process is required by statute and occurs in public session. In addition, counties retain bond counsel to ensure that all borrowing complies with RSA Chapter 33 and that funds are used solely for their authorized purpose. RSA 33(4) establishes statutory debt limits for counties and municipalities. These limits cap the amount of outstanding debt as a percentage of valuation, providing a hard ceiling that prevents excessive borrowing. Counties cannot exceed these limits except under narrowly defined circumstances and emergencies already recognized in law. RSA 33(6) already governs emergency borrowing. It allows debt limits to be exceeded only in extraordinary circumstances such as war, natural disaster, or other declared emergencies. This statute already balances fiscal restraint with the practical reality that emergencies do occur. The SHIELD Act would override this balanced approach by restricting borrowing almost exclusively to emergencies while simultaneously narrowing the definition of what qualifies, effectively removing counties' ability to respond responsibly managing infrastructure. RSA 3310 requires public hearings prior to bond issuance, specifies how far in advance notice must be given, and mandates a 2/3 vote of the county delegation to approve county borrowing. These hearings provide the public with direct input into capital decisions and already serve the transparency function that the bill claims is lacking.
As you have the full write-up of what we're presenting here today, I'll cut to the chase as the red card is up. Counties do not operate under a warrant article form of government. There is no statutory mechanism for counties to conduct those. Cheshire County has approximately 66,000 registered voters. This bill would require 33,000 voters to participate in a countywide vote and at least 22,000 to approve the bond. This bill could jeopardize compliance with state and federal regulations governing nursing homes, corrections facilities, public safety infrastructure. HB 1427 is unnecessary, unworkable, and contrary to the existing statutory framework that already ensures fiscal discipline and public accountability. Thank you.
Thank you. Are you willing to take questions?
As best we can.
Okay. The chair recognizes Representative Majori.
Thank you, Madam Chairwoman, and thank you both for taking a question. I heard you in your testimonies talk about statutory caps on borrowing. Are you aware of any statutory caps on what a municipality can hold in taxpayer funds?
Thank you for your question. The RSA 35A actually restricts the amount a county can set aside in capital reserves in any one given year. So in order to be able to plan for the magnitude of replacing the infrastructure that we are responsible for, such as nursing home and jails, that I can't even imagine what they're going to cost when it is time to replace those, we may be restricted by that particular RSA to even set aside that amount of reserves in a particular year. So.
Further questions? Representative Colby is recognized.
Thank you, Madam Chair. Thank you for taking my question. I hear, was it Mrs. Trombley?
Yes.
You're in finance?
Yes.
Okay, thank you for the work you do. I will ask you, as a finance specialist, would you consider it to be fiscally prudent to have a $7 million project, $2.5 million coming from grants, $3.5 million in bonds, and $1.5 million coming from savings or capital reserves? Do you think it's fiscally prudent to have to turn down that $2.5 million grant for a $7 million project?
Absolutely not.
Thank you.
It's how we survive.
Further questions? Seeing none, thank you. Next, the chair recognizes Mr. Deshays. Good morning and welcome back.
Thank you, Madam Chairwoman, and thank you to the committee for taking my testimony again this morning. For the record, Brody Deshays, I represent the New Hampshire Municipal Association. We are a nonpartisan nonprofit that is opposed to House Bill 1427 in furtherance of our member-adopted policies, nothing ideologically driven in our opposition. Just wanted to state that clear for the record. First, purpose of the bill and how we interpreted it is it would prevent municipalities from funding public infrastructure projects with bonds unless there was a public emergency declared by the governor or the federal government, or the, quote, essential infrastructure, end quote, failure poses an imminent threat to public health or safety. I think the key place where you can see what kind of infrastructure can be bonded is where essential infrastructure is defined on lines 19 through 21. So that would be an extreme limitation. The bill also prevents municipalities from bonding new infrastructure and new projects. It can only be done to replace existing infrastructure that, again, is an imminent threat to public health or safety if it were to fail, which is very open-ended and vague. We also have some concerns about the citation of RSA 31:39-A related to sponsoring certain insurance benefits for employees if approved at an annual meeting. And it's cited and it doesn't seem related to the governing body's liability. Maybe it's assuming that the type of insurance that you may purchase for the governing body's liability is purchased like an employee's healthcare plan, but that statute doesn't seem to be entirely relevant. I also want to flag 10-year bonds, as this bill would only require, it would require only 10-year bonds. Those will have a higher annual debt service payments versus 15 or 30-year bonds. So this bill would incentivize increased debt service costs annually for municipalities seeking to replace current infrastructure. I do also want to talk about the fiscal note briefly. And we stand by our fiscal notes. Specifically, I think the key sentence is, the New Hampshire Municipal Association states it's hard to predict the exact cost of this proposal because of many factors that are involved. Things like inflation in the economy, price of goods and services, how much something might cost 30 years from now, interest rates and how those can change. Again, when you're saving for these projects in capital reserve accounts, interest can erode at those savings, especially depending on how they're invested. So there's a myriad of things where you can't really say that that legislation like this would long-term save the taxpayers money. I'll also mention that it's stated in the bill that if the municipality declares an emergency, that it could follow the provisions of this proposed law and bond these projects. I want to flag, though, that municipalities can't just unilaterally declare an emergency. They can ask to have a special meeting if emergency exists, and that's defined in RSA 31:5, Roman 1, subsection B, what exactly an emergency is. But you would need to petition to the Superior Court, and they would have to agree with the municipality's officials that an emergency that's compelling enough for a special meeting actually exists. Lastly, I just want to state that our association views it as unfair that municipalities would be held to a significantly different standard for bonding or funding projects with bonds than the state. The state depends on bonds for much of its infrastructure projects, and as do municipalities. Bonds are one of the tools that our members, like any public officials or any elected officials, need to be able to try to get funds to do large infrastructure projects and to be funding those infrastructure projects or planning for the replacement or creating new infrastructure prior to there being imminent threats to public safety or general welfare. Our members want to be proactive in ensuring that there is good infrastructure for the services that they provide to residents and taxpayers and municipalities. And with that, I'd be happy to answer any questions the committee has about the bill.
Are there questions for Mr. Deshays? The chair recognizes Representative Majori.
Thank you, Madam Chairwoman, and thank you for taking my question. You talked about a municipality's ability to declare emergency. In Roman 1A, it defines declared emergency, and I like when you create a definition that sets guardrails. However, this says declared emergency shall include, but not be limited to. In your opinion, does shall not be or shall but not be limited to open the door wide to anything that a governing body could declare an emergency?
I think even though this bill says that the governing body could declare an emergency, I still think the existing statute for declaring an emergency and having a special meeting might prevail. I think if a governing body were to say we're going to declare an emergency, I think there would still be an expectation that in declaring the emergency and seeking to get a bond, you would be doing it to have a special town meeting and you would still need to petition the Superior Court. That would be my personal interpretation. But you could have some that may think that this could be interpreted as a very broad authority given to the governing body under the statute with extreme limitations on how they can bond infrastructure projects locally.
Further questions? Seeing none, thank you.
Thank you.
So that represents my last card. So at this time, I will ask, is there anybody present who wishes to testify on this bill who has not yet had the opportunity to do so? Seeing none, the chair will recognize Representative Gilman.
Thank you, Madam Chair. In the remote testimony today, there were two folks in support of this bill and 7 opposed.
I'm waiting for the sheet to come.
Well, I would recommend reading the what has been offered in these, on all these bills, actually. On today's blue sheet, there is 1 registered in favor and 1 opposed.
Thank you. And with that, the chair will close the public hearing on House Bill 1427 FN.
Okay, so that went to.
Next, the chair will open the public hearing on House Bill 1224, relative to default budgets for official ballot town meetings. Chair recognizes the prime sponsor, Representative Dunn, to introduce his bill to us today. Good morning and welcome to Municipal and County Government.
It is still morning, so thank you. Good morning. Thank you, Madam Chairman. Good morning, Madam Chairman, committee members, and guests. I'm Representative Ron Dunn from Londonderry. I am here today to sponsor a bill that would change the way we calculate the default budget here in New Hampshire. A default budget, in simple terms, is based on the previous year's operating budget with adjustments for debt, contracts, and other obligations. The default budget has been a topic of discussion in many towns for many years. No one seems to like it, but no one knows a better way. This bill takes one of the issues, using unfilled employee positions to fund other areas of the budget, and would eliminate this practice. An example of these issues this bill would fix would be using unfilled positions to fund other areas of the budget. Departments would not hire unfilled positions, so they can use this money to pay for other areas of the budget that may be underfunded or overspent. This practice needs to end. If this position is needed, it should be filled. If it is not needed, it should be eliminated. When the residents go to the polls to vote, they are voting on the budget that they want. They are not saying the department heads can give you a slush fund to allow for overspending or allow towns to spend on other things that are not in the budget. This practice can lead to inefficiency and wasteful spending. It also leads to lack of trust and transparency in government. The fixes I'm proposing in this legislation will not solve all the problems in the default budget, but moves in the right direction. The default budget is complicated and needs to be fixed and reworked. This is one step in the right direction to fix one of the issues. Thank you, Madam Chairwoman and the committee for your time this morning, and I'm happy to take any questions.
Are there questions for the prime sponsor? Representative Grund is recognized.
Thank you, Madam Chair, and thank you for taking my question, Representative. So are you aware that when voters vote on a warrant article, especially like operating budgets that you're speaking about, that they're voting on a dollar amount, not on line items, and that during a following year, sometimes priorities change. You might have front door locks that break, skylights leak. So now you might be transferring mine saying, okay, maybe my furniture purchase, which I know I need to replace my furniture because the chairs are falling apart, or you're going to transfer that money to the priority item and you're not going to spend it. But that doesn't mean you don't need to spend it. So why would you remove it automatically because it's a one-time transfer?
Representative Grund, when you speak, you're not close enough to the microphone.
Oh, I'm not. Sorry.
Yeah, it's hard to
Do
hear.
you need me
Thank
to
you.
repeat it?
No, I think he
That-
understood. Maybe he could answer in a abbreviated,
Apologize.
complete sentence.
I apologize.
Sure. Thank you for the question. So this bill takes away unfilled positions that are put into the budget that municipalities leave in there unfilled because their line items may be underfunded or in that fashion. So they use that money for other things other than the position that it's in there for the budget.
Follow up?
Yes, I'm looking at line items on page 1, line 15 to 17. So that's why I was asking the question. Because it's a one-time transfer, so I'm just asking that question.
Yes, so it'd be removed from the budget if it wasn't in there within a year.
Further questions? The chair recognizes Representative Colby.
Thank you, Madam Chair. Thank you for taking my question, Representative. I appreciate the efforts to exempt some public safety positions. I'm not sure if you are aware, are you aware that positions that remain vacant in public safety, those monies are often used and redistributed to overtime costs in an effort to retain public safety. Or a municipality may contract with the state of New Hampshire to provide state troopers in a municipality greater than 3,000 people. That's you have to pay. They may use the overage to cover the cost of a contractor for snow removal. Is it your intention to eliminate that flexibility that ensures public safety by preventing that type of transfer in line items?
Thank you for the question. No, public safety was specifically removed.
Follow up, yes.
Thank you. But it's still, I guess I should make you aware that lines 26 through 28 would prevent a municipality from using it for contracting, even under a public safety item, or for overtime.
That is. I don't read it that way, but this bill was written specifically to exclude public safety, so I don't read it that way.
Further questions? Representative Gilman is recognized for a question.
Thank you, Madam Chair, and thank you for taking my question. Are you aware of just how hard it is to fill empty positions in these days since COVID? And a follow-up question, Madam Chair.
Thank you for the question. I absolutely am aware. I'm the town council chair in Londonderry, and I absolutely understand how hard it is to fill positions.
Follow up?
Thank you, Madam Chair. If we have a position that is open for 10 years while actively looking for someone, and we have to use a consultant to fill that position while we're still actively using for someone or looking for someone, is that considered using that line item improperly?
Thank you for the question. I would say it is.
Another follow-up.
Well-
I'll let people go around.
Yeah.
Further questions? Seeing none, Representative, I'll finish up with Representative Gilman, just to keep your, okay? Representative Grund is recognized.
So I want to follow up on Representative Gilman's question. So superintendents, principals, town managers, business administrators, finance directors can take a year or so at this point to fill. And a lot of times we have interim that's sitting in, similar to a consultant, but they're actually hired as an interim.
Correct.
So then that position is sitting open for more than a year. Are you saying that those positions should be eliminated in the?
Thank you for the question. I'm not saying that at all. A town manager position could take you a while to fill. I'm saying that in the budget, if you have an interim town manager, that money's being used to interim town manager. Okay, and you're.
Yes, follow up.
And most of the time they're hired as a consultant. So it's following up on Representative Gilman's question.
Thank you for the question. In my experience, that is not the case. You hire an interim town manager, you appoint them for 120 days, and then you vote as a council to either accept that person on or you don't, or you extend their contract.
Further questions? Representative Gilman is
Thank you.
recognized.
Thank you, Madam Chair. Now, this will be my last. Given that it's the atmosphere right now that it is incredibly hard to find people to fill positions like snow truck drivers and public works folks, if a position is unfilled, I think your bill says for more than a year, if you're not advertising it. Is it wrong to use that money for the one position to raise the pay of two other empty positions so you can attract people to those two positions?
Thank you for the question. In your example, it would not be affected because plow drivers are exempted.
They're public safety.
They're exempted.
Further questions? I have a quick question with regards to overtime pay in terms of municipal budgeting. How is that properly budgeted for?
Thank you for the question. I can only speak for Londonderry. In our town, we budget for overtime, and we try to right size those lines every year.
Thank you. Further questions? Seeing none, thank you. Next, the chair recognizes Mr. Deshays. Good morning and welcome back.
Thank you, Madam Chairwoman. Thank you to the committee for taking my testimony again still this morning. For the record, Brody Deshays, I represent the New Hampshire Municipal Association, and we are opposed to House Bill 1224 as introduced. I'll also flag for the record, House Bill 1224 is very similar, but not quite the same as House Bill 475, which was vetoed last year by the governor. This bill presents kind of three significant problems for municipalities or other similar local governments, political subdivisions of the state. House Bill 1224 requires that the budget be reduced by the amount of any positions that have been vacant for more than a year, minus types of positions described in Section 2, primarily public safety, of the bill that are being actively recruited. I'll flag, I'm not entirely sure how to interpret actively recruited. Does that mean that you're currently interviewing someone? Does that mean that someone has applied? That's pretty open-ended, actively recruiting. Does it mean that you just have the posting up? I mean, that could be actively recruiting, or you have it in a classified page. So I want to flag that as that's in and of itself ambiguous. Hiring for municipal and governmental positions is extremely challenging. Many municipalities are understaffed, and it's uncommon for recruitment for open positions to take much longer. It's common for recruitment of open positions to take much longer than anticipated, with other municipal staff stepping up in the interim to wear multiple hats. So people have to start doing multiple jobs to fill and to serve for the municipal government and to make sure that these jobs and these important tasks get done so the municipality can operate. This means that municipalities may be actively recruiting for a position, even though a position has been sitting open more than a year. This change would prohibit municipalities from finally hiring someone for a much-needed position that has been open for more than a year, further straining municipal services. It also interferes with the normal management decisions by the select board or town council or other similar governing body relative to employee salaries and benefits. House Bill 1224 prohibits the default budget from including any salary or benefit increases issued after the last budget was adopted. If any salary increases were made during the previous budget, but after that year's budget was adopted, those salary increases could not be included in the default budget calculation. And this ties into kind of the previous bullet, which would also require certain vacant positions to be removed from the default budget, making it impossible to fill them. So you would have your salary lines further and further be reduced and decreased and not be able to fill positions or make adjustments for people's salaries, adjusting with inflation to retain employees. The third problem is it misconstrues the purpose of line item transfers and creates more ambiguity and administrative burden in calculating a default budget. It requires that the default budget be reduced by the amount equal to any reductions in line items for transfers made for one-time expenditures. This may sound innocuous, but it's not. This provision severely threatens the routine and necessary authority of select boards to transfer money between line items to meet evolving needs of the town throughout the budget year. It also directly contradicts existing RSA 32:10, Roman 1, subsection B, which states, quote, "Neither the Budget Committee nor other citizens shall have the authority to dispute or challenge the discretion of the governing body in making such transfers." It also would be very confusing in implementation, meaning that the governing body and any other administrators would need to keep track of every single line item transfer that they make throughout the calendar year, and then make sure that their default budget reflects every single line item transfer. In small towns where there's limited line item transfers, that might not be too difficult. The bigger the municipality, though, and the more moving parts and the more needs that for what they're offering, that's where it gets complicated. So an example is, imagine an interdepartment transfer between the highway equipment line and the maintenance line because a plow breaks down. A new one needs to be purchased as soon as possible to meet the demands of winter maintenance. Is that a one-time expenditure that must be reduced in the default budget? Or is it normal operating and maintenance expense with so many routine transfers like that happening daily in municipalities? This would be very confusing. So I'd be happy to answer any questions the committee may have, and I appreciate you guys letting me, I think, go over my 3 minutes a little bit.
Thank you. Questions for Mr. Deshays? Representative Majori is recognized.
Thank you, Madam Chairwoman, and thank you for taking my question. Might be a little silly, but the NHMA keeps a list of classifieds or has a classified section. There are nearly 200 open positions on the NHMA classified sections. Do you know if any of them there have been there for longer than a year because of difficulty finding qualified candidates?
Thank you for the question, Representative Majori. And yes, that is a service we offer to our members, is our classified, and it's very beneficial to helping them recruit new employees. And I would imagine, while I can't say definitively, I would imagine there are probably multiple up on that classified that have been open for over a year, especially town manager positions, town planner, those larger, more technical positions that can be difficult to recruit.
I had a follow-up to Representative Majori's question before I recognize Representative Colby. So you're saying that there are some municipalities in which there's no town manager for over a year? How would that municipality operate and run without a leader?
Thank you for the question, Representative Power. Madam Chairwoman, I should say. So oftentimes they'll have an interim town manager or interim town administrator. It might be someone who, for example, is some other leader in the municipality. Sometimes it could be a fire chief. It could be the finance director. It could be an assistant town manager. Some towns have an assistant town manager. That's the assistant town manager and might wear another hat like finance director. So it really depends locally on what the governing body decides of who to appoint as the interim town manager, but that can be an issue. There are some times where towns struggle to be able to find someone who's qualified to be their town manager, or they go out and they do a multi-month process for trying to hire a town manager, and the pool of candidates just does not meet their needs or expectations, so they redo the process.
Representative Colby is recognized.
Thank you, Madam Chair. Thank you for taking my question. I'm wondering what the NHMA's interpretation of lines 26 through 28 is. Is it also your interpretation that it would limit, that this statute would limit, even for public safety positions, the ability to move funds from a budgeted vacant position to an overtime line, or for use for having to contract out work?
Such items. I read that as, so such line items shall only be expended for the designated public safety positions, and any unexpended funds in such lines shall not be transferred to any other line item in the budget and shall be used to reduce local taxes. I interpret that as for line items designated to public safety positions, benefits and salaries, that you could not transfer monies out of those lines for other purposes, even if you can't fill a position and to meet other growing needs in the municipality.
Thank you.
Representative Stavis is recognized.
Thank you, Madam Chair, and thank you for taking my question. Another interpretive question by NHMA, lines 27 and 28 of that section, and shall be used to reduce local taxes for the current fiscal year. Does that mean school taxes? Does that mean municipal taxes? How is a municipality to interpret local taxes?
I would interpret that as meaning, while I see your point, I would interpret that as meaning the municipal, tax effort. I think one important issue to potentially flag is for the current fiscal year, how exactly you're going to make sure that unexpended funds before maybe the end of the fiscal year are actually used to decrease the tax rate. And usually you won't know that until prior to the next fiscal year. So there is, that would be an issue of how municipalities, just based on how they set their tax rates and timing, how they could actually abide by these sections.
Representative Majori is recognized for a question.
Thank you, Madam Chairwoman, and thank you for taking another question. In the last House session, the House sent a bill over to the Senate, which will, and I think it's a good bill, but it will prohibit certain positions, elected or appointed, from serving in other positions. And we know that's not just limited to, for instance, oh my God, I'm drooling. That's terrible. I'm really excited about this. This is terrible. I've lost my mind. Somebody please just put a net around me and send me away.
Deep breaths.
But in this instance, in some instances, we heard from representatives who are in small communities where you might have a salaried position serving in another, appointed to another otherwise salaried position to serve in that job because there's no one to do it. Do you think that this bill will conflict with that bill that we just sent over to the Senate? I might have to go to the bathroom now.
I don't think. Thank you for the question, Representative Majori, and I hope any problems you're having are resolved shortly. Um, So I don't think per se there's anything in this that would conflict with that. With that, I believe you're citing House Bill 488, which has passed. It's a prime sponsored by Representative Terry Spilsbury, and we're going to be working closely with him on some technical issues with the bill over in the Senate. I won't speak to that bill, Madam Chairwoman, because I can tell you're about to cut me off and want me to speak to this bill, and I will. I think the key thing is that those two bills, the way if this became law with that bill, the interplay would make it much more difficult. I mean, you're asking for additional restrictions and not allowing municipal officials to wear multiple hats so they can do multiple positions and duties to save the taxpayers money. But then now you're creating issues where if you can't fill those positions, that could be multi-hatted positions. You're going to force a municipality to decrease its salary lines to fund those positions, essentially getting rid of them in the default budget. And I also just want to, from a practical standpoint, the default budget is based on a calculation of an approved budget that was approved at some times. It could have been many years ago. If you keep going to default budgets, it could have been the previous year. So those positions that exist, they were approved by the voters in the legislative body. So it's not as if those positions were always just magically created. Those funds were included in the default budget calculation because at one time, some voters approved those line items.
Further questions? I have a question. You had mentioned in your testimony, you referenced that this bill is a refiling of a bill that was vetoed by the governor. And could you please refresh the committee's recollection as to what the content of that veto message was?
Thank you for your question, Madam Chairwoman. So my understanding is that House Bill 1224 is a variation of House Bill 475. So it's not an exact refiling. It's different. It's based on the version of House Bill 475 that passed the House. I do not recall what was in the governor's veto message exactly, but what I do remember was concerns about being able to adequately fund public safety positions.
Thank you. Further questions? Seeing none. Oh, no. Okay. Seeing none, thank you.
Thank you.
And my last pink card, the chair calls Mr. Power. Good morning and welcome back.
Good afternoon, committee. It's a little afternoon. My name is Eric Power. I'm from Brookline, and I'm here in support of this bill. This bill is similar to the House Bill 475 from last year that was vetoed by Governor Ayotte, primarily because of public safety positions being eliminated in a default budget. So you have to remember, a default budget is when the voters say, we want the bare bones continuation. We don't want extras. So it's not like if you want all these other positions, you put it in the proposed budget and you convince the voters to approve it. The default budget is supposed to be the bare bones. The voter says, no, we didn't like your proposed budget. We're going to go with the bare bones continuation. So all these things that are talked about here are things that you could have if you pass your proposed budget. The default budget is supposed to be the bare bones, so keep that in mind. And right now, there's a lot of loopholes that pad that budget. The bill on line 6, in lines 5 and 6, it says previous incurred by law or mandated by law. It adds a by in there because some people were saying it was just mandated by law. Then on lines 8, it talks about eliminating positions that have remained vacant for more than a year. And that's important. There's also on line 9 and 10, there's where they talk about using actual benefits and salary that actually exist when you have the budget hearing. And that was from Representative Yokella's bill in 2024, House Bill 313, so that's also in here. And then it also talks about the harvesting of budget line items for one-time expenditures. You need to keep track of those because those show that you had extra money, and that's important to be able to, get down to the bare budget, the continuation budget. So that's very important. If you're looking for some people have said, we want to have some extra funds in the default budget. We want some extra contingency. Well, that's not the purpose of a default budget. The default budget doesn't have a contingency. There are mechanisms under municipal budget law to have a contingency fund. There's RSA 3198-A, which allows you to put a warrant article for a contingency fund. And, municipalities, that's good practice. You don't put the contingency fund in the default budget. That's what we're trying to eliminate here. And then we also addressed Governor Ayotte's veto message about public safety with Section 2 of this bill. And this is excluding the public safety positions, which includes, law enforcement, fire protection, emergency medical services, emergency management, and town positions with plowing duties. The language in there, I think, would cover, using it for contracts or overtime, because that's the purpose of those line items. But a small amendment might be able to shore that up and make everybody happy. But I think it is okay as it is today. It also makes a couple other small changes for the RSA that gives the budget committee the enabling legislation that gives the budget committee under RSA 4014B the ability to determine the default budget instead of the governing body. So that's also been corrected in a couple places. That's not correct in current law. And for these reasons, I think it will make default budgets a true continuation budget, and it'll let voters, it'll make the governing bodies and the budget committees come up with true budgets that are proposed that voters might accept instead of defaulting to the default budget. And for those reasons, I support this bill, and I'll take any questions.
Questions? Representative Gilman is recognized.
Thank you, Madam Chair. Do you see anything that would be, I don't know how I'm saying this, but I want to talk about when the default budget is lower than the proposed budget and still has empty positions in it. Do you see that this might further cut those positions?
Thank you for the question, Representative. It might, because if you have extra positions that have been vacant for a long time, they will be taken out. As long as if they're in the public safety area, they will not. But this will enable voters. Voters always complain that they can never have a default budget that gets lower. When there's extra things that aren't being done, there's one-time expenditures. This gives the voters the opportunity, and I also think it gives the governing body and the budget committee incentive to come up with a budget that they can accept and not just go with the default budget. Thank you.
Representative Majori is recognized.
Thank you, Madam Chairwoman, and thank you for taking my question. I think I'm reminded of something after Representative Gilman said this. The fire department, the staffing for the fire department in the town of Northampton was set by our own statute. This is what the town said they wanted. And we, like many other towns, had some vacant positions that were not filled because of conditions that we wanted there. So would this bill create a conflict that we have with our own statute? And I guess that then the natural second question is, would we have to default to state law rather than our own statute or our own ordinance, excuse me? Does that make sense?
Representative, I think it makes sense. So first of all, the public safety positions are explicitly exempted, so they would never be deleted under this law. So they would stay. But if you had other things, they would. And I do think state law does preempt local law as well.
Further questions? Seeing none, thank you.
Thank you.
So I'd like to ask, is there anybody present who wishes to speak to this bill who has not yet had the opportunity to do so? Seeing none, the chair recognizes Representative Gilman to report out the blue sheets.
Thank you, Madam Chair. Today, in the remote testimony, there were 2 folks in support of the bill and 16 opposed. And on the in-house blue sheet, there is one opposed.
Thank you. And with that, the public hearing on House Bill 1224 is now closed. Next, the chair will open the public hearing on House Bill 1575, relative to the determination of the default budget by the Budget Committee. Chair recognizes the prime sponsor, Representative Bohm, to introduce his legislation, and good afternoon. I apologize for being behind schedule here. Thank you for your patience, and welcome to municipal and county government.
Thank you, Madam Chair and members of the committee. I've been a selectman, school board member, and budget committee member for a total of 22 years, and this is my 18th year as a state rep. In the past, I put in multiple bills on trying to fix the default budget. In most cases, they passed the House and killed in the Senate. The default budget has turned into something that is not believed. In the past, when SB 2 was adopted in 1995, there was a big difference between the proposed budget and the default budget. And some towns and school districts, they had to hold special meetings for a modified budget because it failed. Gradually, the difference between the default and the proposed budget has gotten less and less. And over the years, I've seen default budgets higher than the proposed budget. Problem is that there is no oversight on a default. It is completely made up. No one verifies its numbers. It is submitted to the DRA and they file it, only to come out if there is a lawsuit, and over the years there have been a couple. The default is not believed by the voters. It can't be changed by the voters. No one sees it except for the governing body, and in most cases they only see it briefly before it has to be sent to the DRA. When I was on the school board, the votes on the budget most of the time was 3-2, mainly because I didn't believe the default. But the governing bodies try to, let's not have a problem. Last year, the budget warrant articles failed in at least 3 towns that I know of and school districts, Litchfield, Hudson, and Merrimack. No special election had to be held because there was very little difference between the default and the proposed operating budgets. What this bill does, it gives some accountability to the default. It has to be proven to the budget committee. It can be easily done. When presenting to the budget committee, one just adds a column: current budget, department proposed budget, governing body budget, and the default budget. So with that, thank you. And also, bill that was vetoed last year, and I'm on the county exec committee, and we do this all the time, the overtime budget takes care of those empty positions. Thank you. Take any questions.
Thank you, Representative Bohm. Are there questions for the prime sponsor? Representative Colby is recognized.
Thank you, Madam Chair. Thank you for taking my question. You noted that the difference between the default budget and the operating budget is becoming a slimmer and slimmer difference. Could this be the result of our municipal employees tightening the belt, so to speak, and making sure that they are presenting a bare bones budget and more bare bones over time? Could that be the result of that versus the nefarious activities you are suggesting?
Not really, because the proposed operating budget isn't getting smaller, it's getting bigger over what the cost of living increases are, especially on school districts when they have less and less students, yet the budget keeps increasing a whole lot more than should be, and the default increases along with it.
Further questions? Representative Guthrie is recognized.
Thank you, Madam Chair. Thank you for taking my question. The way the addition to the bill reads, I don't see any time frame. When does the Budget Committee get the default budget in the process? And if I could add, if when they get it, does this bill actually let the Budget Committee change the default budget?
Yes, if they don't agree with what the governing body has submitted, they can modify it. I mean, hey, that's the whole point of proving it. And if they prove it correctly, there wouldn't be any change. The problem, and there shouldn't be any problem with time. I mean, they schedule enough time. For example, in most cases, the budget committee finishes the school budget around Thanksgiving time. And then they have late January for a budget hearing, and then and deliberative sessions in late January, early February. So there shouldn't be any time problem.
Thank you. Thank you, Madam Chair.
Further questions? The chair recognizes Representative Gilman.
Thank you, Madam Chair, and thank you for taking my question. Is it your feeling or evidence that this is a chronic problem across the state, or would you believe that there are towns who are doing exactly as you recommended with the line and the explanation?
I think it's pretty much across the state. Like I've said, you know, it's amazing that I've been doing this for many years, and I think we were like the second town in a lot of towns, and I know a lot of towns before the law has been changed over the many years, including one good one some years ago, where if the position doesn't exist anymore, you remove it from the default. That wasn't always the case. And I remember school districts, especially, I know in Merrimack and other towns, that the default was higher than the proposed budget, mainly because they needed less teachers, but they kept them in the default. And that was fixed. You can't do that anymore. But yeah, over the years, it's been fixed because problems have been found.
Follow up?
I think I've been sitting here for hearing the bills, all of those bills that you've talked about in the past. We've been jiggling with the default budget for years. Now I forget my question. Sorry. The default being higher than the proposed budget can be made not just because you've finally eliminated or have kept those positions open, but also because of retiring debt or actually getting rid of those open positions. So it can in fact be higher than the proposed budget.
I don't see how. For example, when you mentioned that the debt retiring, I remember one year in our district when the high school was paid off, and yet at the hearings and everything, I expected the default to be a whole lot less. It wasn't. So where did that money go? That was the bond payment go into other things, on the default, because you expected the default to be less because of the bond payment no longer existed.
Thank you.
Further questions? The chair recognizes Representative Majori.
Thank you, Madam Chair, and thank you for taking my question. If this bill were to pass, would there need to be a repeal bill for RSA 4014, which allows for a vote about whether or not the Budget Committee can set the default budget?
I'm not aware of that. I'll take a look.
The chair recognizes
Oh, excuse me. Let me make a question to that.
Representative Bohm.
Yes.
The chair is speaking.
Yeah, I'm sorry.
I have a follow-up question. What did you want to say?
The chair recognizes Representative Majori for a follow-up. Thank you.
What did you want to say?
Yeah, I now I'm recalling that. Yes, there is a place to put in the warrant article for doing that. And in places, the problem with that warrant article, which I was looking at first fixing, I mean, that bill, that law, I mean, says the budget committee can create the default. And the word create has a problem. When we brought it up at our school district meeting, it was defeated because the people didn't like the word create. So that was the problem with that. Thank you. I'm sorry.
The chair recognizes Representative Elwood, and the chair also apologizes to the member. I did not see your hand up when I called on Representative Majori.
Thank you, Madam Chair. Thank you, Representative. So this bill is allowing the Budget Committee to determine the default budget?
It can make corrections to the default budget, yes.
Follow up?
Yes.
So could this unintentionally bias the outcome of budget votes?
I think it will give credibility to the default, which most people do not have credibility for it, including members of, like when I was on the school board, I didn't believe the default.
Okay, thank you.
Further questions? The chair recognizes Representative Grund.
Thank you, Madam Chair, and thank you, Representative, for taking my question. So I believe, I'm on a school board as well, that because we do this, you have to present the line item, the differences between your operating budget and your default budget, and you can show the categories and where it comes from. So in that, isn't there a review done? I know it's done at my school board level. And the question I have as well is, do you believe finance directors from towns, business administrators from schools are not following the law, but yet they're filing documents with the DRA saying they are?
Well, the problem is interpretations of the law. And over the years, like I've said, why all of a sudden the default is pretty much close to the proposed. And the school board, and I've been on the school board, we try to get as much money as possible for the schools. And that, well, not me, but other members of the school board. That's why we were 3-2 votes. And so I think in most cases, the school board will agree with what was presented to them. And what was presented to them, here's a good example that I've run into. The teacher's contract, for example, may say we're going to spend X amount of money for stipends, and they list them all, the clubs and whatnot. And say that comes to $20,000. But over the years, no more than $12,000 has ever been spent. So the proposed budget has $12,000 in it, but the default got $20,000 in it because the contract says, but the contract is only if those exist. So that's wrong. Okay, so just for an example.
Further questions? Representative Guthrie is recognized.
Thank you, Madam Chairman, and thank you for taking my second question. I had some real problems because I have a advisory budget committee, which is a very weak position. And here we are, we're telling the advisory budget committee that you'll look at the default budget and you can change it. It seemed to be setting up a situation.
I don't think this goes right on to the RSA for a municipal budget committee. I mean, for budget committee law. So I don't believe the advisory budget committee would be affected.
Thank you for your comments.
Representative Colby is recognized.
Thank you, Madam Chair. Thank you for taking my question. I think we can both recognize that a finance director is a professional, an executive with professional certifications, ongoing trainings in municipal law, tax law, degree in financing and accounting. They already have their work reviewed, amended multiple times throughout the year. What are they doing in particular that is concerning enough that we need to have yet a
third overview. I feel like this is a third overview. We have the selectmen look at the budget. We have the budget committee look at the budget. Now we're going to have the budget committee look at the default budget. What in particular, what situations have arisen that we've proved that these people aren't qualified to do their jobs?
Well, over the past couple of years, we've seen how many business managers in school districts losing their job. And that's who does it on the school side, school district sides. So, and I think, like I said, they're probably doing what they think is right. But the laws are being manipulated. Oh, this law says this, so we can do this. And I've seen that over the years. So, and why all of a sudden, say in the last 10 years, and this has been around for 30 years now, that the default budgets have gotten higher and higher and higher in relation to the proposed because of, hey, we can do this, we can do this, we can do this. So they try to make it, and the school board go with them, and I've seen that because I've been on the school board. Let's get as much as we can, and let's not make sure the default is as close as possible, so even if we do lose, we haven't really lost that much. Nobody believes the default.
Further questions? Seeing none, thank you. Next, the chair recognizes Mr. Royce. Good afternoon, Mr. Royce, and welcome to Municipal and County Government Committee.
Sorry, initially I thought I would be saying good morning, but good afternoon, and thank you for allowing me to testify. I'm here to testify actually on a follow-on bill, and when I saw this on the agenda as a member of the Budget Committee in my town, I said, this seems to be a good thing, so I should make some comments on it. The way I read this is that it just is going to provide some transparency to the Budget Committee on the default budget. We spend hours and hours and hours going through the budget line by line, providing feedback to department heads on things that should or should not be in the budget, challenging their assumptions, making sure that they're well thought out. And the budget committees are committed to do that work. And to reply to an earlier testimony, we don't finish in November. We're still working today, getting ready for our final public session. When we finish our budget review work and we approve the overall budget, then we're advised of what the default budget will be. It's provided as a total number, not the transparency that this amendment seems to want to provide. So because it's going to give us additional information at the line level, and since many of the towns, and certainly my town, year in and year out, the only budget that gets approved is the default budget. People are frustrated with a high level of their taxes. That I think that this is a good change. The Budget Committee should be able to see this transparency of the default budget. So I ask that you support this. Thank you. And I can take any question that people might have.
Questions? The chair recognizes Representative Grund.
Thank you, Madam Chair, and thank you for coming and participating and answering my question. Does the Budget Committee currently have the ability to ask for the detail that goes from the operating budget to the default budget so you understand the details?
It's not currently part of our process.
Follow up?
Yes, follow up.
Do you have the ability to ask?
I would say I don't know because it's not part of our process. The default budget is presented at the end of our budget process.
Further questions? Representative Guthrie is recognized.
Thank you, Madam Chair, and thank you for your testimony. Are you uncomfortable with the fact that the Budget Committee can make changes? And whether or not those changes stand up if there's a dispute between the Board of Selectmen and the Budget Committee?
I'm not uncomfortable with that at all. I often ask questions and challenge assumptions that are in the departmental budgets.
Thank you, sir.
Further questions? The chair recognizes Representative Elward.
Thank you, Madam Chair. Thank you, sir. What safeguards prevent manipulation of the default budget?
I guess I'm a little uncomfortable with the term manipulation. I think changes in the default budget to move monies around to cover unexpected events to a line that didn't have enough budget is part of governing, and I think that's done through transparency. They're certainly done and approved at select board meetings, which are open to the public that anyone can attend.
Follow up?
Yes.
Well, then, what is the inconsistency in current law that prompted the bill regarding determination of the default budget?
I didn't see this amendment as a determination of the budget. I saw it as transparency to the default budget, to the Budget Committee.
Thank you.
You're welcome.
Further questions? Representative Gilman is recognized for a question.
Thank you, Madam Chair, and thank you for taking another question. You said in answer to another question that when asked if the Budget Committee could ask for that information or receive that information, your response was that it's not our process. Can your process change?
I'm not sure, and that's why I was interested in this piece of legislation, to come here and listen to the testimony and see what direction it was headed.
Further questions? I have a quick question. Seeking your thoughts on this this issue is that following up on a member's question regarding this bill allows the ability for the Budget Committee to make corrections, and the member cited the possibility that there may be disputes or conflicts with regards to, well, what should the default budget actually be? So in that case, how do you think such a dispute would be resolved? Who would have the ultimate authority as to the determination as to what the default budget is and will appear on the warrant?
I think that would be a combination of the town administrator and the select board.
Thank you. Further questions? Seeing none, thank you.
Thank you, and thank you for all that you do. Something that seems relatively simple. The amount of discussion is impressive. So thank you all.
Well, thank you for participating in this process. Next, the chair recognizes Mr. Power. Good afternoon and welcome back.
Yes, Eric Power from Brookline. I previously served on a cooperative school board that had a budget committee. Our school district in Brookline has SB2. We don't have the combination right now of having a budget committee and SB2, but I would like to talk a little bit about the default budgets in the budget committee. So one thing about the default budget, there is a lot of interpretation there. That's why there's these bills out there. So there's a lot of interpretation and oversight. And in my town or my school district where we have SB2, we do not have a budget committee. We have an advisory finance committee. And they try to look at the default budget. Sometimes I will take a deep dive into it, try to find things, and I found things that were wrong in there. They had principals contracts that ended, and they had built-in raises and everything in the default budget, which is clearly not allowed by the law. And I had to fight that with the school board and the SAU, and they actually found out that I was right in the end. But that took a little bit of a battle. But the point is if you have a budget committee was going to be looking at all those things a lot more than just a member of the public. And I think it's important that they have an opportunity to make corrections. Now, I think this bill probably, if you're interested in moving this forward, it would probably need an amendment. And you have to look at RSA 4014-B, which I alluded to earlier, and I think it was partially brought up today. That's the enabling legislation for a budget committee to create the default budget. And heard that some people didn't like the word create. And sometimes you take enabling legislation and you make it mandatory. And this may be a case where that's warranted, I think, because I think having another set of eyes is on it. Default budgets are the biggest thing on the warrant every year, the biggest dollar item, and it's very important for those to be correct and to really be the bare bones budget. So I would, maybe the committee looks at this if you feel as a policy matter that it's important to have two bodies look at this default budget to make sure it's right for the voters. That's what I would recommend. I mean, I would very much like a budget committee that exists by default, a municipal budget committee, to have the power to adjust the default budget, because I think it's important. And it would result in a lot better and accurate budgets. And with that, I will close.
Are you willing to take questions?
Yes.
Questions for Mr. Power? Representative Stavis is recognized.
Thank you, Madam Chair, and thank you for taking my question. Do you represent the School Board Governance Association of New Hampshire, or are you testifying on behalf of yourself as a resident?
I'm a resident today.
Okay. Are you the president of the School Board Governance Association?
That is what I have that as a role.
Thank you.
So Representative Stavis, maybe you didn't hear, but he introduced himself as a member of the public, and I do not recall him stating that he was here today to represent the School District Governance Association, which is a completely voluntary, volunteer organization. Further questions? Seeing none, thank you.
Thank you.
And my final pink card is for Mr. DeShays. So good afternoon and welcome
Good
back
afternoon.
once again.
Thank you, Madam Chairwoman, and thank you to the committee for taking my testimony this afternoon. For the record, Brody DeShays, I represent the New Hampshire Municipal Association, and we are opposed to House Bill 1575 as introduced. This legislation specifically adds an additional requirement to the posting requirements for the default budget in a ballot form of town meeting towns, commonly called SB2 towns. So this actually is currently amending the notice requirements. These posting requirements established again in 32:5 Roman 7 are prior to the first session of the annual meeting. So what we would commonly call the deliberative session. The new mandate would require the default budget to be presented to the Budget Committee prior to the first session of town meeting, and the Budget Committee could adjust the default budget despite it already being publicly posted in accordance with the statute, which was already likely reviewed by the Finance Director and DRA and the governing body prior to meeting these posting requirements. Additionally, the new requirement would have a pretty tight window of time, being between the second Tuesday in January when these are all finalized by the governing body and DRA, and this posting that's the last day, required by statute to post, when the default budget is officially posted, and the deliberative session, which has to happen in early February. In many ways, this could create some potential confusion where you have the default budget posted publicly and have it already been reviewed by your municipality, its governing body, and DRA, and then the Budget Committee could potentially change the default budget. So then the default budget that's ultimately taken up, as part of the budget process, that deliberative session, the presentation, you'd have two different ones that have been posted publicly. We do appreciate everyone flagging RSA 40:14-B, which allows voters to adopt provisions of law to delegate determination of the default budget to the Municipal Budget Committee, which likely solves the issue this bill is seeking to solve, allowing your Budget Committee to have this authority already enabled in statute so they can set an alternative default budget that they believe might meet the expectations of the voters more if they were to decline the presented operating budget. I also just want to flag one additional item is it's a little bit ambiguous about what if there is no Budget Committee, who makes the final decision on what default budget goes on the warrant. So it seems as if this is assuming every municipality or school district would operate with a statutory Budget Committee, but as Representative Guthrie alluded to, sometimes these are just advisory boards that the local municipality has established, or all the budgeting authority is vested with the governing body. And with that, I'd be happy to answer any questions.
Questions for Mr. DeShays? Representative Majori is recognized.
Thank you, Madam Chairwoman, and thank you for taking my question. Given the objections that you raised and the questions that have come up here, do you think it's possible that the Municipal Association might go neutral or support this bill if it were limited to requiring that the default budget be reviewed by the Budget Committee?
Thank you for the question, Representative Majori. I think it would really depend on timeline, when that would be required, and also who gets final approval. I mean, really, there's a lot of, while this seems like a very simple and innocuous bill, there is a lot of moving parts. And so we understand, based on the previous testimony, the prime sponsor's intent, making sure that the Budget Committee is involved in the formulation of the default budget and gets adequate review of it. But we also think that RSA 40:14-B, that probably is the best avenue because the Budget Committee would get sole authority over formulating the default budget. In many ways, that allows immense amount of flexibility for the Budget Committee. And if the Budget Committee is disagreeing with how the default budget is being set by the governing body and the finance director and town manager administrator, this could be an authority that they advocate that the residents, voting residents, provide to them.
Further questions? I have a question. So, the government, we understand that when there's a budget committee, an official municipal budget committee, as opposed to a finance committee, which is advisory only, that it is in fact the budget committee that is responsible or quote unquote owns the operating budget. So I find it interesting that with regards to default budgets, that it's the governing body when a budget committee exists that's calculating the default budget. That would be an inconsistency. So to add to my question is that clearly when there's a finance committee, they don't own the operating budget. It's the governing body that puts that on the warrant. And yeah, it would make sense that the governing body would therefore be responsible to calculate the default budget. So do you see the inconsistency here?
I mean, thank you for the question, Madam Chairwoman. And I think if what we're seeking is that the Budget Committee needs to review the operating proposed budget and the default budget prior to it going on the warrant, there are probably other statutes that should be addressed where that's done and clarified. So if I understand your question correctly, and please
So
correct me if I'm wrong.
I would have a follow-up to that, and it appears as maybe you didn't, or maybe I didn't state it clearly, is that when there's an official budget committee, they post the warrant article for the operating budget. So therefore, it makes sense that they would be responsible for the calculation and the posting of the default budget. In the absence of an official budget committee, and maybe you don't have a finance committee, or maybe you do have a finance committee where if it exists, it's advisory only, it is the governing body that is responsible, owns, and places the operating budget on the warrant with all the rest of the warrant articles. So in that instance, where there is no budget committee, and either you have no help, finance or budget committee, or you have an advisory only finance committee, then yeah, the governing body would be responsible for the operating budget, all the other warrants, and the default budget. Do you see the distinction that I'm trying to make? And
Yeah.
and to be clear, I'm moving beyond just what this legislation in front of us proposes to simply loop in a budget committee if it exists, because clearly it doesn't say finance committee. I'm going beyond that to loop them in to review. I'm proposing an amendment in which if an official budget committee exists, due to the fact that they own the operating budget and they place that article on the warrant, then it stands to reason that an official budget committee should also be responsible for calculating the default budget and also putting that on the warrant. Would New Hampshire Municipal Association support such an amendment?
Thank you for the question, Representative Power. So I think the first thing I want to address is who has the authority to move things onto the warrant. And the ultimate authority is the governing body moves things onto the warrant and then provides what warrant articles that they've if there's a budget committee, what's on the warrant then is provided to the budget committee for them to change the budget, the operating budget, and scrutinize the warrant articles that were moved onto the warrant by the governing body, maybe change the dollar amounts, and ultimately both if it's enabled in the municipality, they provide recommendations on these specific warrant articles in the operating budget. I would have to see, and we'd love to work with you on a potential amendment if it's the will of the committee to move forward with ensuring that there's adequate review and that's enshrined in law by the budget committee over what the default budget is. But I'd have to see the language prior to making any kind of commitments about whether or not we'd support it, and ensuring a lot of these timing issues are also addressed as part of that.
Thank you, Mr. DeShays. Maybe we're parsing words, but yeah, it's the governing body does, prepare the warrant. But to be clear, as a former chair of an official budget committee, that the budget committee is responsible for the operating budget.
Of
So
course,
that's my
the
point.
bottom line of the operating budget is within if it's a statutory budget committee. Couldn't agree more, Madam Chairwoman.
Further questions? Seeing none, thank you. And with that, I will ask, is there anybody present who wishes to speak to this bill who has not yet had the opportunity to do so? Seeing none, the chair will recognize Representative Gilman to report out the blue sheets.
Thank you, Madam Chair. In today's remote testimony, we had 1 in support and 13 opposed.
Did you get the hard copy of the blue sheet? Oh, you did. Okay.
I'm sorry, it came faster than I thought. No one signed the blue sheet.
Thank you. I missed it too. And with that, the chair will close the public hearing on House Bill 1575. Cards do we have? Can you tell me how many we have? Can you count? Yeah. Okay. At this time, the chair will open the public hearing on House Bill 1649, prohibiting certain tax dollars from being donated to nonprofit organizations. Chair recognizes the prime sponsor, Representative Lori Ball, to introduce her legislation to us this afternoon. Good afternoon and welcome to municipal and county government. And I do apologize for being behind schedule. I appreciate your patience. And all the people that have been waiting to provide testimony on this bill. So, one moment. Okay, so in addition to the prime sponsor, we have 8 individuals who filled out pink cards. So as a reminder, we are going to allow up to 5 minutes for the bill introduction, followed by questions and answers. And then for people providing in-person public testimony, we would ask that you will provide your comments within 3 minutes, followed by questions and answers. And if you have more information that you would like to share with the committee, we invite you to either pass out hard copies or feel free to email after the hearing. So with that, I recognize Representative Ball.
Thank you, Madam Chair. Good afternoon, everyone, members of the committee, and thank you for allowing me to speak. I am the prime sponsor of this bill, House Bill 1649. Before I speak to the substance on the bill, I want to make it very clear about something. I'm a very strong supporter of nonprofit organizations. I currently serve as the president on 2 nonprofits. I sit on 2 other boards, and I'm an active member of 2 national nonprofit organizations. In addition, I've prepared nonprofit filings free of charge for individuals seeking to establish charitable organizations in our state. My support for nonprofits is longstanding and genuine. And that's precisely why I believe House Bill 1649 is important. This bill addresses a gap in how taxpayer dollars are handled at the local level, specifically the practice of donating public funds to nonprofits through warrant articles without any enforceable accountability once those funds have been, once they leave the municipal budget. House Bill 1649 is not about restricting nonprofits or limiting valuable community services. It's about drawing a clear distinction between a donation and a public expenditure. Taxpayer dollars are not charitable contributions. When the public funds are appropriated, there should be clear expectations, transparency, and verification that the funds are used for their intended stated purposes. Under current practice, donated funds may leave the budget process entirely without contracts, deliverables, reporting requirements, or confirmation that the money was even spent in the town that raised it. That lack of oversight is not fair to the taxpayers, and it ultimately undermines the trust in the municipalities and the nonprofits. House Bill 1649 closes that loophole while explicitly preserving the ability of towns and to partner with nonprofits through contracts or competitive grant programs, mechanisms that already exist and work very well. I've heard concerns that this bill limits local controls. I would respectfully disagree. Local control does not mean lack of oversight. It means responsible decision-making within a transparent budget process. At its core, House Bill 1649 is a good government bill. It protects taxpayers, respects nonprofits, and reinforces fiduciary responsibility at the local level. I respectfully ask the committee to support House Bill 1649. Thank you. I'm happy to answer questions.
Thank you, Representative, for your bill introduction. Are there questions for the prime sponsor? The chair recognizes Representative Gilman for a question.
Thank you, Madam Chair, and thank you for taking my question. I understand what you're saying here, and because my town went through the exact same thing. Why are we paying this one that much, et cetera? We had a really old-fashioned way of doing it where they put a slate of them on the ballot, and we figured that wasn't wrong because I didn't want to vote for that one, but it's stuck in the slate. So we developed a process during our budget season where we have a subcommittee that looks at welfare and human services. And we developed a form for them to fill out to show us how much of their property or how much of their business is being used for Exeter residents. And they have to show us their annual, not their annual report, but their annual income and, do they volunteer, do they pay someone? So we have all the information that we think we need to make an informed decision. And it goes as a subcommittee of the budget committee is then reported out to the full budget committee, listing all of the things that they've gone through. So my question is, can't that be something other towns do? Develop exactly what you've said in here to show how it's used, how the nonprofit is working, how much it serves the town, that kind of thing. I'm going to take it out on you because I'm tired of hearing these, my town doesn't do this, and so, do it.
Thank you for the question. As I understand it, and the way this was written is that the towns can certainly contract goods and services with the nonprofits. The thing that we're looking for is just put it as a line item. If the town needs a service or they need to contract, they're going to contract someone anyways, then certainly a nonprofit can do that. So we're not looking to stop that. We're simply asking that it be moved to a line item as opposed to being put out as a warrant article. It can be just embedded in the budget, because the way that things are happening now in some towns is that the nonprofits can put in warrant articles, thereby bypassing deliberative session, bypassing the budget, and then, as I said, not even towns knowing where the money was spent or how.
Yes.
No, I really appreciate what you're saying, and so then my question is it one line item for all of the nonprofits, or one line item for each one? And not all of the services we need can be provided by them as in a contract.
I appreciate the question, and I think that each town would have to look at how they're working with the nonprofits to make sure that they're providing the town a service that's needed by the town. If they do it as one, this is what we're going to do, then they can. I think we could also look at, if you have two nonprofits that provide the same service, are they equally being allowed to provide that for the town, or are they competing against each other? So there's where the competitive kind of a thing bidding would come in so that everyone gets an opportunity to help the town. I'm sorry if I'm not understanding you correctly.
Further questions? Representative Walker is recognized.
Thank you, Madam Chair. You said in your opening testimony that your main concerns or some of your concerns with the town's putting it on warrant articles. But yet in your first sentence of line 1, you're including cities in this prohibition of thing. We don't have warrant articles for such things. We have line items in our budget.
So then you would already be covered, as I understand it. if
I
I'm
don't think
asking
it's
you.
particularly clear of that. And this could really do damage to a lot of things that cities provide their citizens. Coast Bus, for instance, there's childcare centers that we do. There's all V&A, there's all kinds of them. Same with the county. The counties do the same thing. And I don't think this language is really specific enough for cities that have line items, or because it's unclear whether this applies to cities or not.
Thank you for the question. I believe in number 3, it says that nothing in the section will be interpreted to disqualify a nonprofit from entering into a contract for goods and services. So however you do it within the budget, whether it's a town or a city, it's my understanding it's to get it into the budget as opposed to in a warrant article that is not then followed up.
Follow up, please.
Yes.
We don't enter into contracts. It's just a line item in our budget. So it's kind of like we're not entering into a contract. So it's kind of ambiguous of whether or not cities, this pertains to cities or counties.
Thank you for your comment. Again, it goes back to the transparency to the taxpayer to know what exactly they are paying for. So if you have something in your line item on your budget, you should be able to tell the taxpayer, this is what we're paying for. If it's Meals and Wheels, we're expecting that we're paying this many meals per month. And if it's this is what we're doing. So the same way you would contract with an organization that is not a nonprofit, so that you can explain and be transparent with your taxpayers on how their money is being spent.
The chair recognizes Representative Frucht.
Thank you, Madam Chair. Question, Representative. Thank you for taking my question. How would a town contract with, say, visiting nurses when the caseload over a year and the types of services required by the residents of the town are completely unknown?
Thank you for the question. I think that would be a contract that you would do it where you're contracting for a certain service. If you can put, we will spend this amount of money and the expectation is that this is what we're getting, so that then we can check to make sure, did that even happen? Did they provide the services within your town? Did they meet the objectives of why the money is being given to them?
Yes.
Thank you, Madam Chair. The amount of money given to, let's again say, visiting nurses, does that represent the actual cost of delivering those services, or is it more of a token payment that says, yes, we endorse what your organization is doing for our residents?
Thank you for your question. I think that's exactly what we're trying to get to here, is we don't want token donations. We want to be able to follow the money and know exactly what's being given and what services are being provided. So if the town says we're going to budget a certain amount of money, we should be able to look and say, this is how much we're going to do and this is what it's being used for. And they should be able to track and make sure that that's happening within their own community and that those same funds are not going to the communities next door unless there's an agreement to work with the communities, surrounding communities. The concern that we're having in my area, which has brought this up, is that there are nonprofits that come in and put in a warrant article, but they bypass a budget. They bypass deliberative. They're just put on the warrant article and then they're voted on. And you have people who have not been able to contribute to a conversation, have not been able to ask questions. We don't even know if the money is staying in our town. So that was the purpose of this. And if the language needs to be adjusted, or amended to make sure that the money's staying within the communities where the taxpayers are giving the money.
The chair recognizes Representative Guthrie. Did you have your hand up?
I have a point of order. First, I'm going to testify against the bill. Should I be asking questions
No.
at the same time?
No. You have to choose one. So you're going to choose to
I'll
testify.
make my comments later.
Sure. So the chair recognizes Representative Franz.
Thank you, Madam Chair, and thank you. In reference to you saying that a nonprofit.
Mike,
through a-
pull your mic
I'm sorry.
closer.
In reference to you saying that a nonprofit can put through a warrant article, you're talking about petitioned articles?
Where the 25 people put in a warrant
Oh,
article.
okay. So it is. Thank you.
The chair recognizes Representative Grund.
Thank you, Madam Chair, and thank you, Representative, for taking my question. So I'm curious how they're bypassing a legal process. Even if it's a citizen petition warrant article, you still have to have public hearing, deliberative session before you even go to get placed on the ballot. So how is it getting bypassed?
Thank you for the question. It was my understanding when this was brought to me that when the 25 people put forward a petition for a warrant article, it goes on as a warrant article. And what I was told from my town is that it is bypassing the budget process because it's not within the process. So I could be wrong here, and I will apologize. I'm going by what was told to me.
The chair recognizes Representative Stavis. Did you have your hand up?
I did. Thank you, Madam Chair. Conversation had kind of gone beyond my question, but I'll ask it anyway. Thank you for taking my question. Are you aware of any statutory requirement that mandates that a given nonprofit can only provide services to the town in which it derives some kind of token payment?
Thank you for the question. I am not. That might be where we need to be looking, is to make sure that those donations stay within the town.
The chair recognizes Representative Majori.
Thank you, Madam Chairwoman, and thank you for taking my question. And I'm going to apologize if I am just hungry and I'm missing this. But in Roman 1, it says that you shall not appropriate, I'm summarizing, shall not appropriate funds whether through a budget or warrant article. But in section 3, and based on the conversation, what I'm hearing is you can put the items in the budget, but Roman 1 says you can't. So I'm trying to reconcile Roman 1 with Roman 3. Can you help me?
Thank you very much for pointing that out, because that is something that I noticed, and it went by me when it went through the legislative process. When they wrote this up, that really should not be there. It should just be for what I'm looking at are the warrant articles.
Follow up?
Thank you. So just to be clear, in Roman 1, if I'm hearing you correctly, it would be to strike budget and this be limited only to warrant articles?
Yes.
Right. Okay, thank you.
The chair recognizes Representative Stavis.
So to limit it to warrant articles, you would have to get rid of cities. Cities don't have warrant articles. And yet cities are clearly subject to this constraint in your bill. Can you help me with that?
Thank you for the question. I am bringing forward this bill at the request of the taxpayers of my town. And I will admit that this is not my area of expertise. And if there was a question of such sort, I would have hoped that when we brought it through the legislative process, they would have brought that to my attention.
So just to be clear, Representative Ball, your last comment, when you said that would be during drafting, that's what you were alluding to? during drafting?
Yes, Madam
Okay,
Chair.
thank you. The chair recognizes Representative Frucht.
Thank you, Madam Chair. Following up on my previous question and perhaps to clarify it, do you know what percentage of the budget of again, visiting nurses is represented by the donations or contributions from all of the towns in their catchment area? And I don't want an exact percent, but, are we talking 10% or 5% or 100%?
Thank you for your question. Unfortunately, I cannot answer that. I do know that in the towns, there could be multiple line items for different nonprofits, and I cannot tell you which each town does. I know of one town that's got 12 line items. I know that in my town, once something passes on the warrant article 3 times in a row, it automatically becomes a line item, and that nonprofit no longer has to be putting forward warrant articles anymore. So apologize, I don't know that answer.
Yes, follow up?
Follow up, would it be fair to say that the donations that these nonprofits receive from the towns is a fairly small fraction of their entire operating budget, and that they receive income from many sources other than the towns that they serve?
Thank you for your question. I can say that in particular, in one situation, I know that the nonprofit who received $10,000 in my town, and it's a good nonprofit, please don't get me wrong. I support it personally. I support it through my other nonprofits. I know that they also received $800,000 in federal grants and then put warrant articles for $10,000 to my town and several of the surrounding towns. It's really just a matter, the purpose of this bill is really for taxpayer transparency. We keep hearing taxpayers saying they need, bring down my property taxes, bring down my property taxes, and all of these nickel and diming of the taxpayers add up over time. So I'm just saying, if at least we could explain and show that this is a service that, or goods that are needed by the town, and if we didn't use a nonprofit, we would be contracting with someone else, is really what the purpose is of this bill, is to provide that transparency.
Quickly.
Why are we dancing around the fact that property taxes are at the high level where they are because we don't have enough revenue coming into the state?
Is that a question that I'm dancing around? I'm misunderstanding.
No, consider it a rhetorical question.
So Representative Frucht, were you looking for an answer? Because we don't ask rhetorical questions. We ask questions that we seek answers to for items, for things we don't know the answers to.
My apologies, Madam Chair. I am asking the representative for her personal opinion.
Thank you for your clarification. My personal opinion is that we have people in my town who may not qualify to get the services being provided by the nonprofits, but at the same time are having difficulty paying their own property taxes. So this is like putting salt in the wound, because it is not transparent, and it just isn't. I really can't say other than it is difficult for people to see that their taxpaying money is being nickeled and dimed away from them.
Further questions? The chair recognizes Representative Karazinski.
Thank you, Madam Chair. Thank you for taking my question. Does your county also fund the nonprofit you had spoke of?
I do not know if the county actually funds that. I would have to look that up.
The chair recognizes Representative Colby.
Thank you, Madam Chair. Thank you for taking my question.
Is there any concern that this could have an unintended effect on nonprofits who receive property tax exemptions? And I'm asking because this, in section 1, it expressly prohibits expending taxpayer funds, and that the prohibition applies to all taxpayer funds, including general funds, reserve funds, and other type of public funds. So isn't the very process of tax shifting doing this and causing those insane increases to property taxes that you're talking about?
I'm sorry, I'm unable to answer that question.
Further questions? The chair recognizes Representative Status.
Thank you, Madam Chair, and thank you for taking this question, which is a version of the question that Representative Colby just asked. So in this committee, we deal with highly technical issues of municipal governance. And one of those issues is taxation of property. In my city, there's a very large multi-community social service organization called LISTEN. I used to be chair of the board of that organization. That operates thrift stores in order to generate most of its operating revenue. Income from the city in which it resides is minimal. It's a token contribution. Most of the income comes from the thrift shop. Should that be tax exempt? It currently is tax exempt. Would you consider that a donation of taxpayer dollars?
I appreciate the question. I'm really not able to answer that. I think that, as I said, this is not my area of expertise. I will say that we have 36 charitable organizations within my town, many of whom overlap in what they do and the services that they provide. I am really thinking that this is more in terms of, are we going to get 36 warrant articles asking for donations? Are we going to start getting donations from extreme organizations that are being, now everybody can get 25 people to sign a warrant article? So I apologize that this is not my area of expertise. As I said, I brought it forward because taxpayers were upset that their money is being used in ways that they cannot verify. So it's really going back to the transparency.
Further questions? Quick question. So this bill was precipitated by the fact that in your town of Salem, that there was petition warrant articles or a petition warrant article. So in the bill, premise is to promote transparency. So if public dollars are being raised and appropriated through a specific warrant article and the voters, pass that, approve that spending, how is that not transparent?
Because there's no way that we know that that money was spent within our town.
Further questions? Seeing none, thank you. Next, the chair recognizes Ms. Harkey. Good afternoon and welcome to Municipal and County Government.
So good afternoon, Municipal and County Government. My name's Colleen Harkey and I live in Gilmanton, New Hampshire. I've been a leader in the nonprofit sector since 2008, and I hold the Certified Fundraising Executive Credential, the world's only globally recognized accredited certification for fundraising professionals. I'm here to testify in support of HB 1649. This bill is a critical step in protecting New Hampshire taxpayers from the lack of transparency that would never be tolerated in the private philanthropic sector. As a CFRE, I adhere to the Donor Bill of Rights, which mandates that voluntary donors have the right to see an organization's balance sheet and receive proof that their funds are achieving measurable results. In contrast, our current warrant article process treats New Hampshire property taxpayers as compulsory donors without any of these protections. We see this risk play out locally. In my community, the Gilmanton Library Association is requesting $35,000, a decrease from prior years, which is roughly 37% of their operating budget from the town. This is effectively the budget of a small municipal department, yet it lacks any equivalent oversight. The organization requesting the funds has dismissed requests for strategic fundraising plan and failed to provide a full balance sheet to the voters. Votes are gained on emotion. HB 1649 addresses this by distinguishing between an unvetted donation and a contract of service, which would be applicable to a city organization, a city budget, I'm sorry. When we allow unvetted donations, we create a discrepancy trap that leads to organizational atrophy. Nonprofits stop innovating and instead rely on a permanent tax-funded line item. This crowds out private philanthropic and burdens the taxpayers with the cost of ineffective or duplicate services. Nonprofit professionals work in a world of empathy, where our true north is fulfilling a mission in a responsible, ethical way. However, true empathy requires us to build resilient organizations. By creating a dependency on tax dollars, we create a built-in failure mechanism. If taxpayer funding stops, the mission collapses because the donor base was never cultivated. We fail those we serve when we build fragile institutions rather than sustainable, community-supported solutions. HB 1649 ensures that if public money is used, it is through a transparent, variable contract that protects the taxpayer and the mission's future. I urge you ought to pass.
Thank you. Are you willing to take questions?
I am, thank you.
The chair recognizes Representative Majori.
Thank you, Madam Chairwoman, and thank you for taking my question and for all you do for our state. I'm struggling with the word contract and basing it on asking this question based on your experience.
Yep.
Do you, I guess the question is, do you think there should be some uniform contract that all municipalities or all nonprofits could submit? Or is it just up to the municipalities about what they construe to be a viable contract?
Well, I'm not an attorney. I'm a fundraiser, and I'm also an authority in that area. But the premise of nonprofits is when a government cannot provide a service to their community. That was initially the premise, and it really started with the American Red Cross, when Lincoln sent out Clara Barton to look for the missing soldiers. And then Wilson contracted the American Red Cross to help with the care and health of those during the war periods of times. Then it has grown to contract services in my old town with the Get About, where seniors weren't able to have transportation to and from medical trips or make things like that. So they did what would be how you would calculate any good or service. How much do you anticipate needing in the town? What is your population? What is the demand? And you kind of have to tweak that number over time, and it gets voted in as a budget item if the town cannot provide that service that is extremely important and necessary in their town. So how that contract is written, I can't tell you, but I can tell you how the fundamentals of the need are based and how that can be established. And then I would think it would be part of the governing law department or, the attorney to be able to formulate that contract. Therefore, that line item is put into the budget, and once the end, when you do your actuals versus your budgeted, you can then understand if there was an overage or you didn't use those funds, and then you'd be able to build in some actual numbers for the next year and meet the needs of the community. You're welcome.
Further questions? The chair recognizes Representative Gilman.
Thank you, Madam Chair, and thank you for taking my question. Do you think nonprofit organizations that offer grants for projects, not services, would fall under this bill?
So I'm sorry, let me make sure I understand the question. Nonprofits that offer grants to do
Survey of the historical buildings on your street instead of providing transportation on your street or Meals on Wheels on your street.
I'm not familiar with a nonprofit offering a grant for that. They would engage with the service as a subset of what their mission is, and that whatever the revenue generated from that would have to support the core mission. Any nonprofit cannot do anything outside of its core mission. It shouldn't have any mission creep. If it does, it's not a good investment for your town or for the people that it's serving.
The chair recognizes Representative Davis.
Thank you, Madam Chair, and thank you for your testimony and for taking my question today. Are you aware of any nonprofits that, quote unquote, place warrant articles on the ballot?
I'm currently aware of I don't know what you mean by place warrant articles. They achieve their 25 signatures, and then it gets onto the ballot. But I can actually speak to the process in our town that does not ask. They ask some questions of it, but they don't ask questions that they would ask of their own departments in their own town governance for it. So there is not a lot of transparency in that. I've sat in those meetings specifically, and have scratched my head at that, because as any funder, I would make sure that my donor has all of that information, because my goal is to make sure that they invest into the nonprofit.
Didn't really answer the question, but thank you anyway.
The chair recognizes Representative Elwood.
Thank you, Madam Chairman. Thank you for taking my question. When you say that the nonprofits serve members of the community in transparency and asking questions that may include personal identifying information, do the nonprofits have to keep their clients' PII confidential?
So I'm sorry, I don't know of any question where someone would require personal information about anyone to receive funding. Is that
No,
what
to
you're
receive
asking me?
services from the nonprofit,
Okay, so
like LNA.
So you're
let's say.
asking a separate question about the confidentiality agreement between a
The
nonprofit?
witness will suspend. Representative Elwood, ask your question. If you have a follow-up, please be recognized. To clarify or have a follow-up, this is not a discussion with the witness.
Correct, I'm sorry.
So would you like to answer the question?
Can you repeat the question?
Yes.
Thank you.
With community members receiving services by a nonprofit, let's say LNA, and this need for transparency, would LNA be required to release the names and other personal identifying information about the members who were serviced?
Absolutely not. They would only provide data.
Okay, thank you.
Representative Elwood, that would be a violation of HIPAA, so the answer is no. The chair recognizes Representative Grund.
Thank you, Madam Chair, and thank you for being here today and taking my question. So I'm going to just ask process. So following the law, they get the 25 signatures. They should go through a public hearing, goes through deliberative, and then is placed on the ballot at that point. Is there anything being bypassed in that process where it may come across as not legally done?
There's a difference between ethics and legal aspects of things. So there are the sin of omission in many instances with not providing balance sheets or reserves in accounts. So those they're not required to be presented. The transparency of the funds from the town is not equivalent to the transparency that is given to the independent donor. Absolutely not.
So, Ms. Harkey, I don't believe that you actually answered the question. You answered a different question, but I will recognize the member for a follow-up.
Thank you. So just to clarify, was there anything through the legal process that was missed, or was it legally followed to go through public hearing, through deliberative, to get placed on the ballot?
I don't specifically know what you're referencing, so I don't think I can answer that question.
Further questions? Seeing none. Representative Majori, do you have a question? No. I saw a hand moving. Okay. Okay, thank you, Ms. Harkey.
You're welcome.
Thank you for being here
letting me
today.
speak.
Next, the chair recognizes Representative Wheeler. Good afternoon and welcome to Municipal and County Government. I did not see you behind the post.
That's okay. I know these posts are kind of interesting, but thank you, Chairman Power and Ranking Member Stavis. My name for the record is Representative Jonah O'Brien Wheeler. I represent the towns of Peterborough and Sharon, and I'm here today to speak in opposition to House Bill 1649. I'll be brief because for the love of lunch, I know you all have been sitting here for a long time, but I do just want to issue my opposition because of the nonprofits in my district who I know are doing the work that would otherwise go undone or be done by government. And so I'd just like to mention two of them now, Avenue A and the River Center, reading off of some of the things that the River Center does, which is connecting people with needed resources such as free diapers, wipes, formulas, wood from our wood bank, and for those who are eligible, access to funds to help pay for unexpected car repairs, medical bills, and the rest, tax preparation for eligible households, coaching to provide guidance in creating a personal budget and personal finance goals, coordinating with area agencies to locate temporary overnight shelters. Just in the last week, the River Center helped 3 people in my area find a shelter who would have otherwise slept in their cars, and some of those people have children. And assistance in determining what programs they are eligible for and filing applications, so helping citizens out with the bureaucracy and dealing with the bureaucracy of the state. In-depth support to families who have been referred to home visiting, family programs for foster and community support, and much more. These are services that the small amount of tax dollars that the towns of Peterborough and Sharon provide to these nonprofits help them in assisting to do. And if they were not doing these services, like I had mentioned, there would be people sleeping in their cars. There would be people going without help. There would be people who could get assistance from the bureaucracy who would not otherwise get that assistance because they don't have the wherewithal to be able to deal with mountains of paperwork. The point of what I'm trying to say here is these nonprofits provide a government service for very little government dollars. And if the idea here is to protect the taxpayer's dollar, I would like to continue this public-private relationship that the state has with a number of the nonprofits across this state, because that public-private relationship means that the state, for less dollars, is putting out services which are helping our people, which would otherwise be used for government services. So rather than having the massive bureaucracy that it would take to help these people and get the services that Avenue A or the River Center provides, we can put out tax dollars to these organizations which are willing to do it on their own private dollar and their private dime. Most of these organizations do fantastic work. I'm concerned about fraud in government as well, but I don't think that this is the appropriate way to deal with fraud or to protect our citizens' tax dollars. So with that, Chairman Power, I'll take any questions that are needed, but I am here for my opposition, and I thank you for the time.
Thank you, Representative Wheeler. Questions for the representative? Seeing none, thank you. Next, the chair calls Mr. Royce. Good afternoon, Mr. Royce. Thank you for your patience. This may be the bill that you have been waiting for, right?
It may be, yes, and thank you again. My name is Norm Royce. I'm a resident of Northwood, live on Northwood Lake, retired as a Vice President General Manager from the aerospace defense industry, and the past president of the Northwood Lake Watershed Association. I'm currently an elected member of the Town Municipal Budget Committee, an appointed member of the Conservation Committee, and a board member of New Hampshire Lakes. The lake associations use multiple fundraising activities, membership fees, merchandise sales, business donations, grant requests, and town warrant articles. In the past, I wrote warrant articles for the towns of Northwood, Deerfield, and Epsom that have shoreline on Northwood Lake. These warrant articles describe the need for education, prevention, and treatment of aquatic invasive species, cyanobacteria, E. coli, and other pollutants. These warrant articles only provide a small amount of funds required, typically less than 35%. The voters of each town have an opportunity to either approve or reject these warrant articles. So they have an opportunity to either approve or reject by voting. Small nonprofit organizations are volunteer-based, with most not having the skill set for the contractual agreements required in this bill. The town contributions to nonprofits already have a process that works. The Municipal Budget Committee approves the warrant articles going on the ballot. The voters approve or reject them. So please don't change that. I'm in opposition of HB 1649, and at this time, I can take any question you might have.
Thank you, sir. Are there questions for Mr. Royce? Seeing none, thank you.
Thank you all for your time.
Next, the chair recognizes and calls Mr. DeRosa. Good afternoon, Mr. DeRosa. Welcome to Municipal and County Government.
Good afternoon. Thank you. Tom DeRosa, Principal of Main Street Strategic, here on behalf of the New Hampshire Center for Nonprofits. We are opposed to the bill, but in the interest of everybody's time, we've uploaded testimony a few minutes ago, and we'll leave that to you to read and let the nonprofits behind us speak. Thank you.
Would you like to take questions?
I could, but I don't want to delay you any further. So if there's something great,
Okay.
otherwise,
Questions for Mr. DeRosa? Seeing none, thank you. Thank you, and we will look for your uploaded testimony. Next, the chair calls Ms. Lamoureux. Good afternoon and welcome to Municipal and County Government.
Good afternoon. Thank you. Madam Chair and members of the committee, I'm Andrea Lamoureux, the President and Policy Advocate of New Hampshire Lakes. We're a statewide nonprofit organization working with about 150 lake associations throughout the state to restore and preserve the health of all of our lakes for everyone to enjoy. We are here in opposed to this bill. Mr. Royce pretty much summed up our opposition, but I want to assure you that as an organization, we understand transparency and accountability is very, very important. We feel that this bill, the mechanisms that it provides or suggests that nonprofits could use to, aren't necessary. We already have transparency, and our lake associations are volunteer-led. And they're really not set up to, a lake has a lake association, so the competitive bidding process for that organization to do water quality testing or to staff the boat ramp with boat inspectors to prevent invasive species, that mechanism just doesn't apply. And then, procurement models, these just don't apply to our lake associations. You will notice online there are several lake associations that are in opposition to this and several other conservation groups for very similar reasons. So thank you for your very careful attention to this, and I'd be happy to answer any questions.
Thank you. Other questions? The chair recognizes Representative Gilman for a question.
Thank you, Madam Chair. Quick question, maybe I should have asked this of the fellow before you, but is there anything that your organization does that a town would need to contract with you for?
My blank stare says I don't, no, I don't think so. It just doesn't apply. Thank you for the question. And I know you didn't ask me this question, but I feel like towns can, if they feel that they need more information, they can ask.
Thank you. That was going to be my question. Representative Stavis is recognized.
Thank you, Madam Chair, and thank you for taking my question. Are you aware of any formalized processes that nonprofits have to do competitive bidding on contracts?
Speaking from the Lake Association perspective, no, because, Squam Lakes Association has one lake association. Squam Lake has one lake association. So thank you for the question.
Further questions? Seeing none, thank you.
Thank you so much.
Next, the chair recognizes Ms. Richer. Is it Rich? Yeah, Richter. Richter, okay. Good afternoon and welcome to Municipal and County Government Committee.
Thank you, Madam Chair and members of the committee for this opportunity to provide comment today. My name is Barbara Richter and I'm the Executive Director at the New Hampshire Association of Conservation Commissions. NHACC is opposed to this bill and we ask you to vote ITL on House Bill 1649. Simply put, this bill would decrease government efficiency and increase spending at the local level. Every day, NHACC provides direct assistance to conservation commissions, to planning board members, and often to town staff as well. We help towns with everything from how to correctly spend their conservation funds to how to write a warrant article. We offer this to our members at a very reasonable fee. So without our help, towns may have to hire more staff or perhaps consultants to do their research or to provide guidance. Or they may simply do things improperly, opening up the town to expensive lawsuits. Essentially, this bill would undermine the important work that nonprofits provide to the state of New Hampshire. The nonprofit community provides an incredible public benefit to the state, and they accomplish so much with a relatively small amount of money. And this bill would negatively impact the good work of those organizations. And I'm also considering the earlier testimony that if this bill's intention is to provide more transparency, instead of going after simply nonprofits, perhaps the whole citizen petition warrant article process could be reviewed, because this would also be an issue with any citizen's warrant article, not just the nonprofit ones. So again, I urge you to vote ITL, and I'm happy to answer any questions. Thank you.
Thank you for your testimony. Questions? The chair recognizes Representative Elward.
Thank you for taking my question. Am I understanding that some of these nonprofits are getting citizen petitions for funding?
Thank you for your question. I do not find that happens often. It's typically goes through the regular warrant article process. And there may be a case where a petition warrant article comes into play for a specific project. They're usually project-based, and there would be, a groundswell of support in your community to have this project in your town, and then that warrant article may be petition warrant articles. But typically, they go through the normal process as any other warrant article.
Follow-up, please.
Yes, I'll allow it.
I was mistaken. I meant that the nonprofits are using are soliciting governing bodies to put their funding needs on a warrant article. And if so, are these nonprofits located within the municipality?
Again, I'm going to have to be very limited in my response because I can only answer for, what conservation commissions would do. But in the majority of the work that we do, it's not a petition warrant article, and they would be providing services in that community, and the warrant article would clearly state what those funds would be used for.
Thank you.
The chair recognizes Representative Stavis.
Thank you, Madam Chair, and thank you for taking my question. Conservation commissions are somewhat different than nonprofit organizations, I believe. So my question is really a follow-up to Representative Aylward's question, which is a conservation commission can perform quasi-governmental activities that a nonprofit providing charitable services could not perform. Is that correct?
Thank you for your question. I believe that's correct in the way you phrased it, yes.
Further questions? Seeing none, thank you.
Thank you.
Next, the chair recognizes Mr. Tabori. Tabery? Tabery. I apologize. Good afternoon and welcome to Municipal and County Government.
Thank you, Madam Chair and members of the committee for the opportunity to testify today. My name is Michael Tabery, and I am here on behalf of the New Hampshire Community Action Association to share information and highlight several concerns we've identified regarding this bill. There are 5 community action agencies in New Hampshire, which are nonprofit organizations that serve every community in the state. We work to reduce poverty, we respond to urgent local needs, and we support the most vulnerable in our communities to secure economic and social stability. We provide services such as energy and heating assistance, nutrition and food security programs, child development programs, housing stability, crisis intervention, and we coordinate with local welfare offices. My statement was going to be a little longer, again, understanding that, none of us have had lunch. I'll just highlight a few key points and let my written testimony stand otherwise. Local municipal support is critical for us in leveraging state and federal grants. Funders often look for evidence of community backing and engagement. Even small town contributions help attract much larger outside funding. Current local oversight already exists, including budget committees, public hearings, select boards, and town votes. Towns knowingly choose to support community action because the services are cost-effective and responsive, and we are trusted partners in the community. Reducing or restricting community action funding could increase costs for municipalities, as towns may face greater pressure on local welfare systems if services are scaled back. It is our practice to tell welfare offices to refer residents to us first and let us do what we can before expending town welfare funds. Local funding helps sustain our core services, including energy assistance, crisis response, food pantries, and Meals on Wheels. Losing this support could result in service reductions that directly impact vulnerable residents. I will speak in regards to the Community Action Program for Belknap and Merrimack counties, specifically in that we do reach out to towns every year for town funding to help support our Meals on Wheels, to help support our local area resource centers. And our preference is always to be a line item when allowed. If we're going for a warrant or to have residents sign up for a special warrant, we've been directed to do so. That is not an avenue that we choose to take. We meet with each of the budget committees or select boards as requested and share information on our results from the previous year and the impact we're having. So on behalf of the New Hampshire's community action agencies and the residents we work with every day, we appreciate the opportunity to share these concerns and provide information to help your deliberations. And I'm happy to take any questions. Thank you.
Are there questions? Representative, I forgot. Can you move, Dennis, Representative Murphy? I'm very tired right now. I need lunch.
I get that. Are you for or against House Bill 1649?
Thank you for your question. We as Community Action try not to take a specific position one way or another, but to provide information and answer questions that help you deliberate.
Thank you.
Further questions? Seeing none, thank you.
Thank you.
Next, the chair calls Mr. Deshays. Welcome back.
Thank you, Madam Chairwoman, and thank you to the committee for taking my testimony. I'll try to be brief. For the record, Brody Deshays, I represent the New Hampshire Municipal Association, and we are opposed to House Bill 1649. This bill as currently drafted would limit the authority of the municipality with approval from the legislative body to appropriate money to local nonprofits. there is an exemption when a bidding process happens, or that the assistance serves a, quote, clear public purpose, end quote, which is a fairly vague term and could lead to lots of disputes over appropriations to local nonprofits. There's a lot of nonprofits that municipalities give to where those who approved the expenditure at town meeting may say that that's a clear public purpose, and there might be others who voted against it who would say, I do not think that is a clear public purpose. Our concern is that small nonprofits that serve needy individuals and families in municipalities would lose the ability to partner with local governments to help residents who need it. These small investments can pay large dividends, limiting the number of people utilizing local welfare budgets. Additionally, municipalities are allowed to scrutinize these proposed appropriations and require nonprofits to submit paperwork and report on how they utilize local appropriations from municipalities and ensure that these dollars are truly being invested on residents in the municipality. And I'll just finish my testimony with if someone puts forward a petition warrant article to provide an appropriation to a local nonprofit or any nonprofit, it goes through the same budget process as, for the most part, as any other warrant article. So receives recommendations from governing and budget committee if there's a statutory budget committee, can be amended by the legislative body and receives a yes, no vote from the entire legislative body. In most municipalities, the annual town meeting. With that, I'd be happy to answer any questions.
Questions? The chair recognizes Representative Majori.
Thank you, Madam Chairwoman, and thank you, Mr. Shanes, for taking a question. Is the New Hampshire Municipal Association a nonprofit?
We are a nonprofit, and I had a feeling someone was going to ask this question, so there might be.
Funny, it comes from a former board member.
Yes. And if I may, let me expand upon NHMA has a statute specific for dues paying. So we actually, because that statute exists from 1961, it would pre-exist this and explicitly gives municipalities the authority to be able to join NHMA and pay dues. We likely wouldn't be impacted, as with, there's 3 other organizations specific to statute, like the tax collectors, town clerks, and I think I'm forgetting the third one that's in the statute right above ours, in RSA Chapter 31. However, there are several other organizations that are nonprofits that represent local officials. Those associations that could very well be impacted, like the New Hampshire Fire Chiefs Association, the New Hampshire Chiefs of Police Association, the New Hampshire Association of Conservation Commissions. I could go on and list a whole plethora of organizations that are affiliates of ours that we work with regularly to come and educate and do collective advocacy in front of the legislature. So we would have concern that those local voices would be silenced, amongst also the fact that we believe municipalities should have the authority to support nonprofits and those organizations.
Further questions? Seeing none, this represents my last pink card, so I will ask at this time, is there anyone present who wishes to testify on this bill who has not yet had the opportunity to do so? Representative Guthrie, you're behind the poll. Okay, I don't have a pink card for you. No, I don't. I'm sorry, I don't. But you want to testify on this bill? Yes, well, come forward and fill out a pink card. Okay.
I'll be quick. You heard all the testimony. I'm sorry. I'm Representative Guthrie. I represent Hampstead, and I'm here to represent my town because it's one of the targeted towns on this bill. So I have felt that I would rather testify, at least show a face to my fellow townspeople instead of sitting behind the post where I always sit. My wife tells me she can't see me. So anyway, I think the big thing was transparency, and I think it's been obvious to the testimony that there is transparency. It's through any of these requests go through the normal or excited process that anything else goes, whether it's a town warrant or whatever, or budget or whatever it is. In fact, my town is, what we do is we select usually 3 nonprofits and have them come before the board, do their tap dance, if you will, and then they so there's an awful lot of transparency because we know as a board of selectmen, that we have to be careful and be transparent with our money, at least in Hampstead. So I don't know where this comes from, whether there are any towns that don't know what's going on, particularly in this issue. And we have a criteria, and it's really only one criteria, and that is the providing services to the town that we can't provide, If we can provide the services to our regular organization, that's one thing. But these are people who are nonprofit and are providing a service that we can't provide. And I think that's the way it's run in most of all the towns in New Hampshire. So as I support an ITL on this bill and ask you to vote, and I'd be glad to answer any questions. But I'd rather go to lunch.
Thank you, Representative Guthrie. The chair recognizes Representative Stavis for a question.
Thank you, Madam Chair, and thank you, Representative Guthrie, for taking my question. As a long-standing member of municipal and county government, are you aware of our long-standing tradition of not passing bills that address problems in one or two communities?
Sorry, I didn't hear the question. I have my hearing aids on, but you have to speak up.
As a long-standing member of this committee, are you aware of our long-standing practice not to pass bills that only affect one or two towns?
I don't know. Am I aware? Thanks for the question.
Further questions? Seeing none, thank you.
Let's go to lunch.
Yeah. At this time, the chair recognizes Representative Gilman to report out the blue sheets.
Thank you, Madam Chair. For remote testimony, we have 10 in support, 533 opposed, and 1 neutral. And on today's blue sheet, we have 4 in support and 6 against.
Thank you. And with that, the public hearing on House Bill 1649 is now closed. At this time, the chair will open the public hearing on House Bill 1355 relative to eliminating the default budget from the official ballot referenda. At this time, the chair recognizes Representative Osborne, who is present today to introduce this bill to the committee. Good afternoon, Representative Osborne, and welcome to Municipal and County Government Committee.
Thank you, Madam Chair. For the record, Jason Osborne, representing Rockingham 2, towns of Auburn, Candy, and Deerfield. Representative Noble regrets that she could not be here to introduce her bill today, asked me to sit in for her. So thank you. HB 1355 eliminates the default budget from official ballot referenda in towns like ours. Too often, this mechanism has served as a backdoor for maintaining or even inflating local expenditures without true voter consent. Voters end up facing a false binary choice: approve the proposed budget or default to one that frequently triggers a tax increase anyway. Last year in Bedford, residents were told the operating budget itself carried no tax increase, yet the default budget did, leading to significant frustration among those who value fiscal responsibility and are seeing their property taxes continue to rise year after year. This isn't unique to Bedford. Similar issues occur in towns across this entire state. HB 1355 changes that by requiring a special meeting for a revised budget if the operating budget fails. And if that also doesn't pass, it imposes a real consequence, a 10% cut from the prior year's budget. This promotes accountability, forces elected officials to prioritize essential services, and ensures that spending doesn't grow on autopilot. It's a common sense reform that empowers taxpayers and prevents the kind of fiscal creep that burdens families. I strongly support HB 1355. And go Patriots. Thank you.
Thank you, Representative Osborne. Are you willing to take any questions?
Oh, I really shouldn't do that, no.
Okay. Thank you. At this time, the chair recognizes Mr. Deshays. Welcome back.
Thank you. I wasn't anticipating the testimony to be so quick, so just need a second. Thank you. Well, good evening. Yeah. Whew. Again, for the record, Brody Deshays, thank you for hearing my testimony. I represent the New Hampshire Municipal Association, and we are opposed to House Bill 1355 as drafted. I'll be brief. There's a lot going on in this bill, but it's one of those, it's kind of funny. The small bills that do the very small innocuous things sometimes can have a lot more impact. And the large bills that look like they're very busy can actually have a pretty simple, straightforward impact, which is, this is, as was the previous speaker mentioned, eliminating the default budget calculation, establishing a new process for if a town that operates under the town ballot form of, the ballot form of town meeting, if the operating budget fails at the second session of the town meeting, that there is a subsequent second special town meeting for the budget, a two-session. So you would have a deliberative session and then a second regular, voting session. And it would require a budget to be adopted at the second special town meeting that basically emulates the SB2 form of town meeting. And if that budget were to not pass, it would be an automatic 10% reduction on the bottom line of the budget. Our concern is that this 10% is very arbitrary and could prevent municipalities from meeting their contractual obligations. Also, by forcing municipalities to have two meetings, that is a new cost that's being imposed onto SB2 towns. While we understand the default budget is not everyone's favorite statute, it's better than I think folks would give it credit. And there needs to be some kind of process for ensuring that municipalities can raise and appropriate enough money to meet existing contractual obligations. That's the whole purpose of the default budget. And those contractual obligations having been approved at previous, having been funded and approved at previous town meetings. I also want to flag that RSA 40:13, Roman 10, allows the governing body to host a special meeting to adopt an alternative budget should the default budget fail. So there already is an option in statute for municipalities to hold a second special meeting if their operating budget fails and they choose not to do a default budget, but to do some kind of alternative. Sometimes it could be less than the default budget or the operating budget presented. Sometimes it can be a different proposal altogether that meets other new and existing needs that might have been missed during the budget process. So with that, I'll just conclude that we're opposed to this bill and would like to keep the current process intact for those towns that have already voted and adopted the SB2 form of town government. Thank you.
Questions? The chair recognizes Representative Guthrie.
Thank you. I've asked a question behind the poll, Representative. And thank you for taking my question. It's getting kind of late. Do you know that there's an automatic second session if the budget is rejected? Who calls for, instead of having who calls for the second session now? You said there's an opportunity because of the selectmen to call another meeting.
Oh, it would be, thank you. So you're talking about under current statute,
Right,
the
I'm sorry.
option. Yes, so currently it would be the governing body could call that, that special meeting.
So there can be a motion from the floor if the budget was rejected. Would there have to be a motion from the floor, or where would the action come from to go to a second meeting?
I would imagine that the action would come from the governing body at a duly noticed meeting.
So you think that's built in?
I wouldn't say as part of the town meeting process, but I would say as part of the overall process of, SB2 towns. So if a operating budget fails, the governing body at its option may hold a special meeting to take up an alternative budget
Instead of accepting the default?
instead of accepting the default. Yeah.
Thank you. Thank you for your answer.
The chair recognizes Representative Colby.
Thank you, Madam Chair. Thank you for taking my question. This statute would require a mandatory, if not adopted, 10% lower than the previous year's adopted operating budget. So I am reading this as this could happen 2 or 3 years in a row. Can you think of any other business or nonprofit where their operational costs to provide services to their clients is reduced by 10% every year, year over year?
I thank you for the question, Representative Colby. I could not recall or think of or find, to my knowledge, any organization or business that would decrease its operating expenses or its revenue, I should say, 10% every single year. I don't think it would be a sustainable model to survive.
Thank you.
The chair recognizes Representative Grund.
Thank you, Madam Chair, and thank you for taking my question. If the first vote fails and you have to hold a second vote meeting, for SB2 towns, this requires printing ballots, it requires voting machines being set, it requires costs. What, do you have any idea what a cost looks like in a typical town?
Okay. Thank you for the question, Representative Grund. It would really be dependent town to town. Obviously, you would have to have the town clerk would maybe have to anticipate to make sure that they have enough funds to host what is essentially a second round of SB2, I guess is the best way we can put it simply, if the operating budget fails. And they would have to do it within the prescribed timelines as set forth in HB 1355. They would need to have volunteers, et cetera.
Can I ask a quick follow-up?
Yes.
So in essence, it would cost the town more money to run a second vote.
Yeah, the more elections you have in a town, the more cost it is because elections cost money.
Further questions? Representative Guthrie is recognized.
Thank you, Madam Chair. Thanks for taking a second question. Would this not excite people to vote against the budget so they could get to the 10%?
Thank you for the question, Representative Guthrie. I think you're pointing out a flaw that I hadn't really noticed. With what this is being proposed is the immense amount of incentive to want to continue basically voting against budgets until theoretically, I guess, over a 10-year period, or well, maybe not necessarily, but over a long time, you could vote down every budget and essentially make it so the municipality's budget is next to near zero.
Thank you. Thank you, Madam Chair.
Further questions? Seeing none, thank you.
Thank you.
And next, the chair calls Mr. Power. Welcome back.
Good afternoon, committee members, Madam Chair. For the record, Eric Power from Brookline. And I'm speaking in favor of this warrant article, or this about warrant articles, about House Bill 1355. We've seen that the default budget has a lot of challenges. It's been trying to be tweaked over the years. It's even got some bills that we've talked about today. So this is actually trying to make the budget process a little more simpler, but while under SB2, but keeping some of the same processes. So really the way it works, as you've heard, is that you have instead of having your operating budget have a proposed budget and a default budget, it just has a proposed budget. Deliberated at the first deliberative session, final number goes to the ballot, the balloting session, the voters vote it up or down. If they vote it up, that's your budget. Great. If you don't, it triggers a second meeting, a second deliberative session, a second balloting session, which, by the way, is something that happens today anyway. It's already an RSA, so it's not like it's a new thing. This is something that happens today. And then you at the second deliberative session, you have to pick a number that is lower than the one that failed. Once you've done that, it goes on the ballot for a second vote. And if it fails a second vote, you get the previous year's operating budget minus 10%. The 10% is a pretty big cut. I'm not sure that that's going to be supported all the way through the House and the Senate and the governor, but an amendment to maybe make it at keeping it to the previous year's budget as a continuation budget might be more palatable, but it'll still be a cut in ways because you're going to lose money to inflation. And that would be something I would think about. So I did a lot of research around the country on how they do budgets, and this is not an unusual process. If you look at Connecticut, you look at Maine, you look at New York, you look at Georgia, many of them, municipalities do this. They will have a repeated budget process. They won't just do 2 times. They'll keep going until they find one. They could go 3, 4, 5 rounds. So this kind of cuts it off at 2, but but they do not cut at 10%. So maybe going 10% might be a little bit too much. So it might make more sense to just do a continuation budget and as an amendment to this, because I think it would be much more amenable to a lot of folks. And 10% is a big cut. Now, if you remember last year, Representative Harvey Bolia had a bill, House Bill 613, which was an optional reduced default budget, which would allow a municipality or school district to just decide for themselves if they want to have if a second failed budget happened, if it would be a reduction of anywhere from 1 to 10%. I think that might be a better, as enabling legislation, dovetailing with this, instead of making it a fixed 10%, let each municipality, school district, and the voters decide on that. With that, I'll close and take any questions.
Questions for the speaker. Representative Grund is recognized.
Thank you, Madam Chair, and thank you, Mr. Power, for taking my question. You mentioned in your testimony that it would be a simpler process. So my question is, how is it simpler, more simple? If towns personnel would have to come back together to figure out a lower budget, school district personnel have to come together to figure out a lower budget, you'd be pulling people out of their day-to-day jobs to get to that place within a 28 to 60 day cycle to hold a deliberative, to get ballots printed. How is that simpler?
Thank you for the question. I think it is simpler in some ways. If you have the budgeting process, you're not having to worrying about what's in the default budget. You don't have to keep track of any of that. You just come up with your proposed budget like you do in an annual meeting, and I have both kinds, so I know how they both work. The nice thing about it is that, when you know that if it doesn't pass, you're going to go to a second round, there might be more urgency on coming up with a budget that the voters will approve. You're not going to ask for the moon and then lay back on the default budget. So I think it's going to be a much more deliberative and much more fiscally responsible budget going in, because you want the operating budget to pass. And if it fails, then you have a second urgent time to come up with another budget instead of facing the continuation budget. So I think by not having to keep track of the default budget, it's simpler. And today, SB2 already has the second meeting if the budget fails. So this is not any different than that is today. This requires it, but that's probably the only thing that's complex, but it's not unusual because it's what we do today under SB2.
Further questions? Seeing none, thank you. And that was my last pink card, so I'll ask, is there anybody present who wishes to speak to this bill who has not yet had the opportunity to do so? Seeing none, the chair recognizes Representative Gilman.
Thank you, Madam Chair. In today's remote testimony, we had 1 person in support and 140 opposed. And the blue sheet seems to be blank. Thank you.
Thank you. And with that, the public hearing on House Bill 1355 is now closed. Just everybody hold on for a couple minutes. I need to confer with the ranking member. Okay, so could I have everybody's attention? So as you see, we've gone over on our schedule. And if you look at the schedule, the chair did have a break built in after the bill scheduled for 11:15. And then we were to take our lunch, come back at 1:15, which was an hour ago, and then finish up our publicly noticed hearings for those three bills. So what the chair and the ranking member have deemed reasonable is that we will take a 30-minute break for lunch. We will come back and we will continue our public hearings on those three bills. So what time is it right now? Well, it's all right. So I'm not sure that this clock is correct. Let's be back here at 2:45. Thank you. Welcome back, everybody, from lunch. It's 2:45-ish or thereafter. So we are going to continue with our public hearings as publicly noticed. And we are going to start up with the bill, and that was scheduled for 1:15, and that's House Bill 1505.
Okay, I'm going to open the public hearing on HB 1505-FN. Representative Powell, please.
Thank you. Thank you, Mr. Chairman and honorable committee members. For the record, I am Representative Diane Power. I represent the towns of Brookline, Mason, and Greenville in Hillsborough County District 36. As the prime sponsor, I am pleased to introduce to you today House Bill 1505. At its core, this bill accomplishes three important goals. First, it provides a clear process for towns and school districts with local tax or budget caps to show that they are operating and abiding by these caps. Second, it gives DRA a tool to ensure that these caps are applied lawfully. And third, it promotes both accountability and transparency for local governments as well as taxpayers. So I'm going to go over some key provisions of the bill. The first would be the reporting requirement. So under this bill, towns and school districts with caps would be required to submit documentation annually to the DRA showing compliance. The DRA, through this bill, will provide the appropriate MS forms for this reporting process, and the documentation would nominally include the cap calculations, both proposed and final appropriations, and any votes needed to override the caps. Second, the bill addresses budget enforcement clarifications, and that is if the appropriations exceed the cap without the required 3/5 vote threshold to override, the bill clarifies how the budgets are to be adjusted to stay within the legal limits of the adopted cap. So as you see, I have passed out an amendment to this bill. And to be clear, the amendment is based on feedback that I received from both the Department of Education, the Department of Revenue Administration, as well as from members of the public that have contacted me post-filing. So this amendment, at a high level, it clarifies and simplifies warrant article language for adopting a school district budget cap and a town budget cap. It updates RSA 32:2 for the school district budget cap and town budget caps, clarifying that these caps only apply to political subdivisions that have adopted them. And also, importantly, I had a meeting with the DRA, and the amendment reflects our discussions, and it adjusts the effective dates, which allows the DRA to update its portal 60 days after passage, and to, in doing so, to prepare the MS forms. And the review of these new MS forms would start April 1st, 2027. So noting the fiscal impact, the DRA did prepare the fiscal note, and they estimated that this, if this bill were to become law, that they would need approximately $75,000 in fiscal year 2027 as a one-time cost to update their, to contact their vendor, and for the vendor to update and implement the proposed forms in the municipal tax rate setting portal. That's a system that the DRA has for entities to input the necessary MS forms, and it aids the DRA in computing the local property tax rates. As towns and schools already complete these MS forms through the municipal tax rate setting portal, the cost for filling out the applicable cap MS forms under this bill, in my opinion, would be de minimis. So in conclusion, House Bill 1505 ensures towns and cities provide documentation showing compliance with the legal limits of any adopted caps. It gives the DRA the ability to verify such compliance. It upholds state law in the requirements of the caps, and most importantly, it respects the will of the voters who optionally and locally adopted the caps. For these reasons, I respectfully urge the committee to recommend this bill ought to pass with amendment. Thank you, Mr. Chairman. I'm happy to take any questions.
Thank you, Representative Powers. Any questions from the committee? Representative Walker. Thank you, Mr. Chairman. Like previous bills, this thing says it's for cities, but it's written for warrant articles and stuff that towns do. So I'm trying to figure out what part of this bill a city has to be.
Thank you for the question, Representative Walker. So I would comment that, in my opinion, don't rely too much on the analysis. It's a summary of the bill. I would refer to the actual language of the bill, which is on the next page, and it states that this bill pertains to political subdivisions that have adopted a local tax cap. So that pertains to towns and school districts, and that's under that statute. And with regards to the school district budget cap and the town budget cap, it's self-explanatory.
Thank you. Representative Davis.
Cities have tax caps as well.
So my understanding is cities have tax caps. It would be different because it's in a different part of RSA.
So, but it is in this bill, cities are included in line 19, page 2. And then it goes on to talk about official ballot form of meeting under RSA 4013 and warrant articles. So again, I'm going to re-ask the question, how should a city respond to this legislation should it become law?
Well,
one more time.
Admittedly, I'm a little confused right now. And so to generically answer your question, I would say that cities would need to follow the law.
But
Follow up. Representative Graham, please.
Thank you, Mr. Chair, and thank you, Representative, for taking my question. On page 1, line 14, it references a budget committee. Proposing, what if you don't have a budget committee, but you have an advisory finance committee, or how's that work?
So are you referring to the bill or to the amendment, just to be clear? Could you repeat your reference page? What?
Sorry, it's
Sorry.
page 1.
Yep.
Line 14. I don't know what's been replaced. Is this a replace all? The amendment a replace all? Or no? Okay, so I'm looking at the original bill, line 14. It references a budget committee will also put their. We don't have one.
So the reference to the budget committee would pertain only to those political subdivisions that have a budget committee. So if you didn't have a budget committee, then the budget committee wouldn't be doing, proposing appropriations.
A follow-up?
Thank you. Just for clarification, so would Budget Committee also, if it was a Ways and Means Committee or a Finance Committee, should that be expanded versus just saying a Budget Committee so it's clear?
Perhaps we could entertain an amendment to clarify that and be more comprehensive. Yes, thank you.
Representative Majority, please.
Can I go to the bathroom? No. Thank you, Mr. Chairman, and thank you for taking a question. I actually do have a question. Am I allowed to talk, Mr. Chairman, am I allowed to talk to the amendment that was handed out since it's not a replace all?
Certainly.
Yeah, okay. Thank you. So if I understand what you have added in lines 8 through 22 on page 2, is the wording of the question that needs to go on the ballot. And if I'm also looking quickly, and I do admit that I'm looking quickly, this section of law was amended just last year. It went into effect September 13th of 2025. So my question is this amendment to that language fixing a deficiency in the law that has only been in effect for 2 months or 3 months?
Yes, thank you for the question. And so looking at this amendment, and just to be clear, there was 5 versions of this amendment. This is the last one. So what you see on page 2 that you referenced with regards to the question to adopt, that's exactly the same wording as what's in the original bill. So to answer your question, yes, as I stated, that the reason this bill was filed is because I received feedback from both the Department of Education, the DRA, and members of the public who were, with regards to members of the public who are looking at these newly enacted laws, specifically the school district budget cap and the town budget cap, that was interested in putting those forward for adoption. And they were reading the language and attempting to understand and to be able to, speak to it and propose adopting that. So based on that feedback, I thought it was important to provide the clarification when I filed the bill. Yeah.
Any other questions? Representative Colby?
Thank you, Mr. Chair. Thank you for taking my question. I feel like we beat to death budget caps. So I'm just going to move to the new paragraphs in the original bill, page 1. And I'm trying to understand why or what would improve the process of accountability. Would having a new MS form to fill out to show that you're in compliance with the tax cap. How is that more beneficial than the required audit?
Thank you for the question, Representative. So when voters in a political subdivision choose to adopt an optional cap, it's important that the cap be followed according to the law. And as long as I've been a state rep, I'm going on my 6th year, I am keenly aware of political subdivisions who have in fact adopted specifically local tax caps, because the school district cap and the town budget cap are new and nobody has yet adopted that. But unfortunately, it was prior to when I became a state rep. And these caps just were not being applied consistently across the state. They were being interpreted differently, and that compelled me to file past legislation to clarify that, because based on my research, it was very clear to me what the legislative intent was of a local tax cap. So in order to be, fair to everybody and not to, I'm not suggesting that everybody is purposely doing creative accounting and having creative interpretations. I'm not saying that, but clearly in practice, I've been contacted by people across the state who, inform me of difficulties with the language. So I felt that in order to uphold the legislative intent in the law and to respect the voters who, adopted these caps, if they're not being followed, if they're not being applied as the law intends and consistently, it's really ineffective. And I think that it's important to have this piece because it affects taxation and also the DRA in calculating the tax rate. So I don't see any problem in proposing legislation like this. The DRA, for any budget, there's MS forms that the entities fill out and report to the DRA, and there's all sorts of information. You may be familiar with MS forms. So to me, this makes complete sense to also include this type of detail with regards to the application of a tax, because at the end of the day, it does in fact, and it should affect your tax rate. So it's just more information in determining tax rates and ultimately what our citizens are paying for local property taxes.
Thank you.
Representative Allwood.
Thank you, Mr. Co-Chair. I'm sorry. Which local budget and tax caps does this apply to? Only voter-adopted caps or also caps imposed by statute or charter?
So specifically, it pertains to local tax caps under the RSA that's cited and school district budget caps under the RSA and town budget caps. With regards to charters, like in cities, the whole notion of a cap under that type of governance would be dictated or come under the framework of the charter.
Okay. Follow up, please.
Follow up.
Thank you. So what authority does DRA gain if non-compliance is found?
Thank you for the question, Representative. That's a good question. And the legislation puts forward that the authority that the DRA has is to flag the illegal appropriations and to follow the same process that they would do in going through any of the other MS forms that they would receive that's currently required under current statute. For example, we have the 10% rule, and there is MS forms that require reporting of such, and the DRA does go through that information, looks at what was approved by the voters with regards to the warrant, and looks to see that if you have a statutory budget committee and the 10% rule applies, then they're a check on that. And if that was applied improperly and the 10% rule was not followed, then there are adjustments to what ultimately can be raised by the entity.
Thank you.
Representative Grund.
Thank you, Mr. Chair, and thank you for taking my second question. What you were just referencing, the page 3 lines 29 to 33 on the original bill. So about the DRA, it's So okay, so it says, basically DRH override cap, blah, blah, blah. The appropriation shall be deleted pursuant to RSA 21J 34. Is there an appeals process in case there's a question whether they have the right information?
So I believe that a representative from the DRA is here and will be testifying behind me. But I understand your question, and the answer is that the reason in part for the MS forms is to verify that if appropriations exceed the cap, then your vote threshold was properly achieved, and then that appropriation would be allowed. So I think that the Mr. Canoyer can better speak to that appeals process, because I'm not sure, to be honest. That's a fifth order detail. Thank you.
Any other questions? Seeing none, thank you.
Thank you, Mr. Chairman.
That was my last pink card. Is there anyone else present? Okay, please come up, sir. Common spelling. You'll have it. Sir, if you can just introduce yourself to the committee, and you can fill that out after you get done testifying. Thank you.
Good afternoon. My name is Bruce Knuer. I'm the supervisor of the Municipal Bureau at the Department of Revenue. The question of what happens if an appropriation is being reviewed by DRAs after the voting, and it's determined in this law that it failed to gain the supermajority necessary. The statute says it will be, actually I don't have it in front of me, but to me it's disallowed. Now what happens at that point? Under current law and conditions, most likely the entity, the political subdivision in question, would ask us to consider other possible evidence. For instance, if the vote count was somehow suspect, and ask the clerk to go back and look and so forth. Technically, at this point in time, a disallowance normally strikes the appropriation from the calculation of the tax rate, which would be months later. And a tax rate is set, and then there is in 21J an appeal period of 10 days from the time that the rate is sent to the entity. So there is a remedy to that action foreseen in this law.
Thank you. Representative Majori.
Thank you, Mr. Chairman, and thank you for taking my question. If and I may be off by one or two, there are 6 towns and eight school districts, I believe, or incorporated places that have the tax caps. What's the prevalence for errors that you have seen? I'm trying to get to, what is this bill fixing?
I don't have any history regarding errors in the 6, and there's 2 school districts that have adopted local caps.
Sir, do you have any other testimony you want to provide other than the questions that we just asked you?
This is a rather technical one, and I'm not certain, but some of the questions this afternoon regarding whether this would apply to cities may be stemming from those section titles, if I'm not mistaken. Because on the face of it, all of the details in the bill relate to Chapter 32. And the cities are operating outside of that under different statute and their charter, the respective charters. They do operate under 21J in reporting to DRA so that we can set a tax rate for this, city of Laconia. We need the same kind of information. But the section headers, we don't have in the room the hardbound copy, but I'm thinking that might be the title. And then within that title contains the chapters involving cities. So if the section headings are carrying the title first and then sort of the subsection, that may be dragging the word cities in to the bill just through those section sort of headers, if that's the right term. And we could verify that if we had the actual bound copies.
Thank you, Representative Davis.
Thank you, Mr. Vice Chair, and thank you for taking a question about that point. So if it is the case that it is the headers, and I believe that to be the case, then what are the implications for cities? If they're in the header, but then the rest of the statute doesn't apply?
Frankly, I don't know. This is the first time I've thought about it because of what I heard this afternoon, seeing that word in there. I look at that and realized it's Chapter 32 that is in play in the bill, and that's going to involve the towns and the school districts, not the cities.
Mm-hmm.
And so city tax caps are governed by their charter, which have been approved by not only the voters, but initially the review by the three agencies, Justice and State and DRA. So I don't know if this is a question for maybe legislative services as to whether or not it has to be there. I don't know the answer to that.
Thank you.
You're welcome.
Representative Allwood.
Thank you, Mr. Vice Chair. I'm sorry. Thank you for taking my question. How are small towns protected from administrative burden created by the bill, if any?
Protected from the burden. Well, I think the intellectual burden is already there. They're going to do calculations. The bill proposes getting that information to DRA. We initially, when seeing the bill, believe we're going to introduce it through the tax portal to cut down basically paperwork going back and forth. And so I don't know, there's a lot of burden. And you're going to, at the local end, you're going to know the numbers and introduce them, and then it provides us with the numbers. It also then provides the record if it turns out to be a separate record. As you know, the tax portal operates that way. Data goes in locally. The software produces what we all, know and love as the budget form, tacked up next to the warrant, so forth.
Thank you.
Sure.
Any other questions? Representative Colby.
Thank you, Mr. Chair. Thank you for taking my question. I'm still trying to wrap my head around why or if or how to make this easier. We're already doing, especially on a municipal end, right? We're already doing municipal audits. I'm trying to see or figure out if this would not be served better in a municipal audit report to see if we're in compliance with the requirements.
If by municipal audit, you refer either to the non-CPA report or the CPA financially audited statements, those are going to be reported long after the voting has taken place, the appropriations are looked at by DRA, and then utilized. It would be, in effect, too late for the audit, other than to note somehow that it had happened. This bill introduces an enforcement mechanism that is much more immediate, just as that you've heard of that 10% rule. That's RSA 3218. That permits DRA in reviewing those appropriations. So sometime as early as late March, early April, if it's identified that in a hypothetical case, the total appropriations exceed that calculated limit, DRA has the authority to disallow the necessary amount of appropriations to put it back at the limit. And just to introduce one other thought is that it is not statutory, it is historical precedent. We generally use a a LIFO, last in, first out approach. So the last thing voted on would be subject to the disallowance to bring it back. However, there are special cases that have arisen in the past, most notably if for some reason a water and sewer operating budget is about to be the next up, we will consider not using a strict LIFO to prevent public safety, public health issues. In other words, we're not going to try and introduce that disallowance on top of something so critical as a water and sewer operation.
Thank you. Representative Davis.
Thank you, Mr. Vice Chair, and thank you for taking another question. It's kind of a philosophical question. So bear with me while I try and formulate it. So when a municipality adopts a tax cap, that is done by the municipality's voters.
Yeah.
And the governing body of that municipality is responsible to its voters. What is the compelling state interest in controlling how municipalities run their budgets if the governing bodies of those municipalities are not, in fact, elected by state officials?
I believe the state's interest in DRAs and Municipal Bureau in particular is in setting a correct tax rate. And when we identify something that makes that tax rate not correct according to statute, that's our interest. It would be applied here in a new way, but with the same underlying idea. We want the tax rates we set to be accurate, not just mathematically, but that all the laws have been followed, starting with the appropriation votes and anything else that applies that helps us determine what that rate will be.
Any further questions? Seeing none, thank you for coming in and testifying.
You're quite welcome. Let me get you this card.
Okay, the last pink card is for Mr. Eric Power, please. Afternoon, Mr. Power.
Good afternoon, committee and Mr. Vice Chair. For the record, I'm Eric Power from Brookline. Used to serve on a cooperative school board for 3 years, and I'm active in municipal government, school district government in my town. And I'm speaking in favor of House Bill 1505 because it adds something very important. Right now, the 6 towns and 2 school districts that have adopted the local tax cap, and in the future there may be some that adopt the school district budget cap and town budget cap, need an enforcement mechanism. We have, as I mentioned previously, in the Brookline School District, we're one of the 2 school districts that has done the local tax cap. But right now, when you see what's happening, the first couple of years, the school board didn't even have a calculation. They weren't even paying attention to it. We had to chase them to get them to actually come up with a calculation. Then they started coming up with a calculation. It would be on a PowerPoint. That's about as far as it went. Then they started doing some things differently, which we didn't agree with, but there was no recourse to us. We didn't think they were following the rules. They thought they were. They just prevailed because they say they do. There was nothing for the individual voters to be able to do. I assume we could have gone to court if we wanted to, but that would be kind of counterproductive. So, these local tax caps are important. They're adopted by a supermajority of voters. And so having enforcement mechanism makes sense. It helps the school board, select board, village district commissioners, if they have it there. They're the ones that need to know they have to follow the tax cap. And then the DRA gives them the guidance on how to follow that. So they have that information today. That's not the case at all. It's sort of, they just interpret it and they do the best they can. And so I think this law is very important. It's very low additional administrative burden because you're already having to do the work. And actually, it might make it easier because now you would have the DRA forms to help you make sure you're doing the tax cap appropriately. And so I think it's a very important, and there's a very important bill. There's also a few clarifications to help make the tax cap more clear for folks. And there was also an applicability area in RSA 32.2 that didn't add in the new school district budget cap and town budget cap that needed to make sure that people knew that not everybody, it doesn't apply to everybody, only to those who have adopted it. And for that reason, I recommend this bill. I know there's amendment. The amendment looks good. I would recommend ought to pass this amendment. I'll take any questions.
Any questions from Mr. Power? Representative Majori.
Thank you, Mr. Chairman, and thank you for taking my question. I'm trying to drill down on whether we're fixing a problem or we're being proactive and trying to prevent problems from happening. And in the instance that you cited where you had to chase down folks at the school district, were they found to have been, were they found by DRA to have erred, or were there no problems?
Thank you for the question. The challenge is that DRA doesn't even look at this right now. So there was no problem found because there was nothing looked at. It's completely a local issue, and DRA doesn't get involved at this point. They kind of keep track of which towns and school districts have a cap, and they sort of know that, but they don't do anything besides that. There's no enforcement, there's no check, there's no nothing. This actually introduced that deliberative process into having a tax cap. So that's, that, and I've called out to DRA and says, can you help me? And they said, no, we don't enforce it. There's no mechanism for that in law.
Any other questions? Representative Colby.
Thank you, Mr. Chair. Thank you for taking my question. So we understand that your school district was one where there was an issue or potentially an issue. There's apparently one other school district and 6 other municipalities that have adopted these. Have you found this to be the case in other places as well?
Thank you for the question. Yes, because there's only a few of us that have adopted tax caps and we know who each other are. We have been in contact, and I have talked to other towns and the other school district that have voters in those districts that have had things that they didn't think were quite right as well. And they welcome this enforcement. Some of the new laws have helped clarify some of those things. There was House Bill 1105, and then last year there was a House Bill 200 and House Bill 374 that helped a lot. But right now there's no enforcement mechanism. It's all local, and it is a challenge. And some seem to do it better, and some don't do it. Some do it worse.
Any other questions? Seeing none, thank you for coming in, sir.
Thank you.
Okay, that was officially my last pink card. Is there anyone else present that hasn't had the opportunity to talk or speak that would like to discuss this bill with the committee? Okay, seeing none, Representative Gilman.
Thank you, Mr. Chair. Today we have remotely 2 in support and 15 opposed.
Thank you, Representative. I now close the hearing on HB 1505.
Sorry, the blue sheet is blank.
Okay, thank you.
At this time, the chair will open the public hearing on House Bill 1711 FN relative to governmental land uses. Chair recognizes Representative Frock to introduce the bill to us today.
Good afternoon. Thank you, Madam Chair. Before I start, you will note an error in the opening line of my written remarks. You are clearly Madam Chair, not Mr. Chairman. Copy and paste and not proofing as well as I should have. Madam Chair and honorable members of the Municipal and County Government Committee, I am Representative David Fracht, Grafton 16, the town of Enfield. I come before you this afternoon to introduce HB 1711, which I'm bringing forth at the request of the New Hampshire Municipal Association. HB 1711 clarifies RSA 674:54, Roman 1 through Roman 2B, which expands upon the definition of government use as affirmed by recent court cases. It clarifies that authorized agents, contractors, and subcontractors are, in fact, acting as a legitimate government entity when it comes to land use. The bill changes substantial change in use and substantial new use to change in use and new use, eliminating any discretion in the interpretation of substantial. The bill expands the notification requirement beyond construction by adding changes in use. The bill makes an advisory public hearing before the planning board or governing body mandatory rather than optional, and it increases the time provided for holding the hearing from 30 days to 45 days following receipt of notification of the proposed construction or change in use. And finally, the bill authorizes the municipality to request documentation that an agent, contractor, or subcontractor is in fact acting as an agent of the state or any of its political subdivisions, and to request proof of applicable certification and or licensure to carry out its government use. In summary, this bill updates the definition of government use as recently defined by the courts. It increases transparency by requiring a public hearing and allows the local municipality to obtain documentation from agencies, contractors, and subcontractors showing that they are acting in the service of a government agency and that they have the required certification and licensure to carry out their mission. I will take questions.
Thank you, Representative Frock. Are there questions for the prime sponsor? Representative Colby is recognized for a question.
Thank you, Madam Chair. Thank you for taking my question. How does this proposed statute interfere with any right-of-way statutes or to accommodate road expansions or improvements, water or sewer installation or upgrades?
I don't believe that there would be any interference with any of the aforementioned statutes that you refer to.
Terrific, thank you.
Further questions? Seeing none, thank you.
Thank you.
At this time, the chair recognizes Representative Elward.
Thank you, Madam Chairman. My name is Representative Deborah Elward, and I represent Merrimack District 5. I'm here as a co-sponsor in support of House Bill 1711. This bill is about clarifying roles and expectations when governmental entities undertake land use activities within a municipality. Current law recognizes exemptions for governmental land uses, but it has not always been clear who qualifies as an authorized agent or what information local officials may reasonably request during the notice and hearing process. By clearly defining authorized agent, the bill ensures that municipalities know who is acting on behalf of the governmental entity, and those representatives are properly authorized and that they are qualified and licensed when required. In short, the bill is a procedural clarification bill. It improves communication, reduces disputes, and helps governmental projects move forward more smoothly by setting clear expectations at the outset. Thank you.
Are you willing to take questions?
No, I think it's time to go to lunch.
Oh, we already had lunch.
Oh, you
Did you miss it? Thank you, Representative Elward. At this time, the chair calls Mr. Power. Good afternoon and welcome back.
Thank you, Madam Chair and committee members. For the record, Eric Power from Brookline. I also serve on the Brookline Planning Board. I'm starting my 6th year, and I'm in support of this bill. It's a very common sense bill. I think it's a good bill. The things I like about it is it takes the gray area of the change of use is now addressed directly, and we don't have to stretch when we're on the planning board what's going to be happening when somebody comes in to do something with our land. We'd understand that. It also, I think, relaxing the requirement to 45 days is very helpful because we have typically 2 planning board meetings a month, and one of them is more of a work session, but we do hearings on the other one. And the 45 days with the calendar shifts gives that extra little bit in case one happens early and because of the way the calendar lands, and the other one happens to be 33 days later or something. So this makes a lot of sense. And I think also just making it clear what an authorized agent is, it does help the planning board and the select board, if they're the ones doing this, to be able to authorize the activity. So for those reasons, I recommend ought to pass on this bill. Thank you very much.
Are you willing to take questions?
Sure.
Are there questions for Mr. Power? Seeing none, thank you. Next, the chair recognizes Mr. Deshays. Good afternoon.
Good afternoon, representatives, and thank you for letting me speak again. Brody Deshays, I represent the New Hampshire Municipal Association, and we support House Bill 1711. We're very appreciative to the prime sponsor and the co-sponsors for working on this bill with us. NHMA helped write and draft this bill and worked with other stakeholders who could potentially be impacted to mitigate any of those impacts. I think the goals of the bill has already been pretty clearly explained. I think I'll talk to 2 things. One policy decision that I think the committee should review and consider before finalizing moving forward this bill that I flagged for Representative Frack back in the fall. And then kind of the impetus for why we requested this. So we requested this because there are a lot of organizations who are either uncertified or unlicensed or certified or licensed through the state performing activities, sometimes that are similar to medical housing or medical related things, where they were telling planning boards that they were authorized to operate under this statute of governmental use and exempt from local zoning and planning. And upon further research and discussion with our legal counsel and other stakeholders, we found that no, they are not actually carrying out a governmental use, but there was nothing requiring these organizations or sometimes even commercial entities to go to the planning board and actually certify that they did meet the exemptions of the statute. So really, this is a significant issue for multiple of our members, where folks are buying residential homes in areas that are only zoned for residential and doing a lot of non-residential activities right next door, sometimes in really dense zoning districts. One thing I will flag is the statute currently uses the term substantial change or substantial new use. That is a very well understood legal term for that. It's a change of use that's substantial. It's, not really somewhat related. It's a significant change. This would be for any change of use or any new use. It doesn't have to be substantial. So it actually requires more input to go through the planning board for any change of use for those who qualify as a governmental use. NHMA is neutral to whether or not you keep the term substantial throughout, specifically, lines 8 through 24, or if you remove it. It's just something I wanted to flag for the committee, though, because that is somewhat of a substantial change to the statute. I think that's all I have for my testimony, and I appreciate you guys indulging me. Thank you.
Are you willing to take questions?
Of course.
Questions for Mr. Deshays. The chair recognizes Representative Elward.
Thank you, Madam Chairman. Is the word substantial rather subjective?
Not with the amount of case law that exists in our state. It's pretty objective. Like a substantial would be like a, let's say it's a commercial use and you're changing the commercial use. There might be other similar commercial uses where it's not a substantial change of use. But let's say you're going from a grocery store to, I don't know, maybe like a Amazon warehouse type of commercial use, even industrial. That would obviously be a substantial change of use. In this case, it would be any change of use of the property that's a governmental use would have to go through this hearing process in front of the planning board.
The chair recognizes Representative Colby.
Thank you, Madam Chair, and thank you for taking my question. If I understand this correctly, even people or even entities that have a contract with the state of New Hampshire to provide services, would they be subject to this even though they're acting as an agent on behalf of the state?
That's a great question, and that's kind of the crux of what we're trying to solve, is that there are some organizations who are contracted through the state and even maybe receive as part of that state certification to carry out a specific state-funded function. Our interpretation is that for it to actually qualify as a governmental use, the majority of the funding for that function needs to be funded by the government, and they need to have some kind of formal agreement that they're carrying out, like a specific statute. We have some organizations that are getting very minimal amounts of state funding and just certification, who then are saying, well, we're carrying out, we got this grant and we're carrying out this state function, this interest, this governmental interest, but that doesn't qualify as a governmental use under this statute and how the courts have interpreted the law and based on our legal analysis.
No. Because you're the prime sponsor, but that's nothing, and yes,
Maybe
I made a mistake, Representative Grund. I forgot that Representative Elward provided testimony as a co-sponsor, and then she snuck back over there, and I spaced it. And I was going to interrupt her. Okay, so since she got to ask a question, I'm going to let you ask the question. Because I was going to say there's nothing preventing you from asking the question offline, but just ask the question.
Thank you, Madam Chair. I appreciate your fairness. Does removing the term substantial make the process more or less transparent to the public?
If in seeking transparency you mean requiring more public hearings potentially for when new governmental uses are happening, whether or not there is substantial change, then I think you could construe it as being more transparent. I don't know if it's wholly necessary, but I see the point of your question.
All right, thank you. I think you interpreted it correctly.
Further questions? The chair recognizes Representative Davis.
Thank you, Madam Chair, and thank you for taking my question. In all my years on the planning board, and you can correct me if I'm wrong about this, when an entity came before us proposing a governmental use, that was kind of the end of the story. The planning board didn't get to say yay or nay. It was a governmental use and therefore it was allowed. It was just informational that they were bringing this information to us. Is that correct? And does this bill propose to change any of that? I don't see how it can, but I'm just asking.
So what this legislation does is it increases the reporting requirements and increases the standard for someone claiming a governmental land use insofar as if they're acting on behalf of the state or one of its political subdivisions. No, the planning board could not deny whether or not someone's claiming the governmental use. However, what it will empower is that if some entity claiming that that what they're proposing, the development that they're proposing to do, the construction, land use change, et cetera, is a governmental land use, and they go through all these reporting requirements, municipality says you clearly aren't, well, at least maybe the municipality has that information now and can go to court and challenge it. That's really what we're trying to enable. I think we would be open to allowing some level of additional purview for planning boards over governmental land use. I also think that the state would not want municipalities being able to deny their governmental land use, the ability to use land that the state owns in a municipality or that they're renting potentially freely to meet state needs. So we didn't go that far.
Further questions? So just to be clear, you had testified that your organization, NHMA, helped to draft this bill and worked closely with the prime sponsor. But I think that you also said that pointed towards the possibility of needing an amendment. Did I understand that correctly or not?
Thank you for the question, Madam Chairwoman. I think the bill would be fine moving forward the way it is. I think if the committee felt as if getting rid of the term substantial made it so then it was a little bit too broad for the change of all uses, that could be a potential amendment. I'm just flagging that because that is not a significant change to the law, but that is one of the more substantive changes to the statute. And I didn't want it to go unseen by the committee and then the committee find out a few months later that they had done that. So I just wanted to flag it. I don't think it needs to be changed, but if it does, we'd be happy to work with the committee on that.
Thank you. The chair recognizes Representative Stavis.
Thank you, Madam Chair. Sorry to keep asking more questions. Could the word substantial cut both ways? In other words, if it's just a change in use, then it could be any change in use. But if you say substantial, then it has to clear a hurdle.
Yes, and there's a plethora of case law that kind of determines when something meets substantial, and this term is used throughout Chapter RSA 674 and other zoning statutes pretty regularly. So,
Further questions? Seeing none, thank you.
thank you.
So, Mr. Deshays, is there anybody hiding behind the pole?
There is not.
Okay, good. So I won't ask that question. We'll just, the chair will recognize Representative Gilman.
We had a light turnout on this one, Madam Chair. We have remotely one in support and one opposed. And in-house, we have 3 in support.
Thank you. And with that, the chair will close the public hearing on House Bill 1711 FN.
Okay, I'll open up the meeting on HB 1131. Representative Powers, please.
Thank you, Mr. Chairman and honorable committee members. For the record, I am Representative Diane Power. I represent the towns of Brookline, Mason, and Greenville in Hillsborough County District 36. I'm here today to introduce to you House Bill 1131 relative to the official ballot referendum form of town meeting, commonly known as SB2. This bill makes a narrow technical update to statutes governing how towns or school districts may adopt the SB2 form of meeting. And the goal clearly is to restore voter access consistent with the original legislative intent of SB2. SB2 was enacted 30 years ago in 1995 as a bipartisan Senate bill. Its purpose was to modernize local governance by allowing final votes on warrant articles to occur by the official ballot, expanding participation beyond those able to attend in person a traditional town meeting. From the very beginning, the law required the question to adopt SB2 to be placed on the official ballot with absentee voting and standard election procedures. So what changed in 2019? Well, in 2019, RSA 40:14 was amended to remove the question to adopt SB2 from the official ballot. And today, the question is placed on the warrant and it's voted upon in person at a traditional town meeting during a limited window if the meeting even allows that article to be voted upon. Rescinding SB2, however, remains, the question to rescind remains on the official ballot. And clearly, this change that occurred in 2019 has created both practical and procedural challenges for communities across the state. So I'm going to highlight 4 major reasons why this change in 2019 is a problem. First, it results in practical barriers to voting. Most New Hampshire towns do not have buildings or facilities that are large enough to even hold a fraction of their registered voters. Current law with regards to the adoption of SB2 requires physical attendance, like I said, at a specific place at a specific time window in order to adopt this form of governance. So to be clear, this change, essentially it excludes working residents, families with small children, seniors, disabled voters, and anyone who is unable to attend the meeting in person at the exact time and location. And I would also offer to you that this change operates as voter suppression. The official ballot election provides absentee voting, standard polling hours, and accessible polling locations. The current system, due to the change in 2019, it removes all these provisions and protections. And as a result, many registered voters are effectively unable to participate. As a Brookline taxpayer, you've heard me say that I must personally attend 3 separate annual meetings, 2 school districts and 1 town meeting just to have my vote counted. The fiscal consequences of this 2019 change are significant. As we all know, town meetings vote on budgets that directly drive local property taxes. And in many communities, only a very small percentage of voters participate and a small number of people are able to participate and attend these meetings, which results in allowing just a tiny minority to determine spending levels that affect households through their local property taxes. And finally, I would submit to you that this change in SB2 makes this form of governance, SB2, functionally unavailable. Since the 2019 change, dozens of political subdivisions have attempted to adopt SB2 and it's failed. And I did some research last night, and this past annual meeting in 2025, one more had successfully adopted it, so I believe that now it's two. So two have successfully adopted SB2 in the past 7 years since the 2019 change. Small in-person meeting voter turnout, often the people that do turn out to the meeting, often they oppose SB2 warrant articles. And so what this means is that due to the fact that it was removed from the official ballot, people who can't attend a meeting have to go to a meeting that they can't attend to say, I can't attend the meeting. That just doesn't make any sense. And often these meetings that they go on for many, many hours, 8 past midnight. My annual meetings typically run till like 2 o'clock in the morning, and they even go multiple days. We even had a meeting that was outside, I think it was 14 hours. And also, with regards to the adoption of SB2, that like I said, the ballot vote doesn't even occur. And the statute has effectively turned SB2, like I said, from a practical option to a theoretical one. So to be clear, what is this bill before you do? It returns the original process of placing the SB2 adoption question back onto the official ballot. It restores voter access, and it expands voter participation consistent with the legislative intent of SB2 in 1995, when this was the SB2 provisions were enacted 30 years ago. This bill before you, it aligns, this is important, it aligns SB2 with every other form of local government change, such as adopting a charter commission to craft a charter, adopting, rescinding, or amending a charter, it's on the official ballot, or rescinding SB2, as I stated, and to return to a traditional meeting, the question to rescind remains on the official ballot. And this, finally, this bill maintains the 3/5 majority to adopt it. Same statutory wording, is retained except for the change to put it back on the official ballot. And it provides full local control for communities who want to adopt or rescind. So in conclusion, House Bill 1131 corrects a misguided and imprudent statutory change that has restricted voter participation and made SB2 nearly impossible to adopt. And lastly, in my opinion, this bill restores fairness, access, and legislative intent. For these reasons, I urge the committee to recommend this bill ought to pass. That concludes my bill introduction, and I'm happy to take questions.
Thank you, Representative Powers. Any questions? Seeing none, thank you.
Thank you.
Okay, the next pink card is Mr. Brody DeShays.
Thank you, Mr. Vice Chairman, and thank you to the committee for taking my testimony this soon, I guess, to be late evening. For the record, I represent the New Hampshire Municipal Association, and we are opposed to House Bill 1131 as currently drafted. Our association's position is that warrant articles should be adopted in the procedure of the existing form of the town government. So in this case, under current law, if you're going to adopt SB2, you do in the typical procedures at the town meeting. Obviously, there's the increased threshold of a 3/5 majority to adopt SB2. But aside from that, one additional, sorry, it's getting late. Aside from that, one additional higher voter threshold, and then also required ballot vote because it's a change in town government that's substantive. We would believe that this should happen at the town meeting with the same debate and the same process. It's our position that by changing this and requiring it to be put on the official ballot for electing officers of the town, that would be kind of putting the cart ahead of the horse. You'd be adopting the warrant article similar to how you would adopt warrant articles in an SB2 town. So if you're a traditional town meeting town, you should be adopting these warrant articles at the traditional town meeting. And if you are an SB2 town, you should be dealing with these in the same form as you would in an SB2 town. Well, I won't go any further. That's all. I think we've all had a long day. I'll take any questions.
Thank you, Mr. Deshays. Any questions for Mr. Deshays? Representative Colby.
Thank you, Mr. Chair. Thank you for taking my question. Somewhat related, do we have a figure on how many towns that have adopted SB2 have tried to rescind SB2?
I
their
have no,
communities?
I don't have a figure on that. We don't always, I always get the question often about any local option types of things is how many people have adopted and how many people have rescinded, and our association just doesn't keep track of those things.
Interesting. Thank
Representative France.
May I provide an answer to Representative Colby's question?
Certainly.
My town, Enfield, was one of the first towns to adopt SB2 when it was allowed. We did it for a few years. We went back to regular town meeting, and last year we adopted SB2 again. So this will be this will be my first SB2 meeting, and I'm looking forward to it.
And I'd like to clarify, we do keep track actually of how many towns are SB2. I just would have to go into our database. So that is actually one thing that we keep track of, and we will need to update our database. I'll have to make sure that Enfield is reflected as being SB2 again. So thank you for sharing that with me, Representative Fract. Yes.
Thank you. Any other questions? Representative Gilman.
Thank you, Mr. Chair, and thank you, Brody, for taking my question. Have you found or have you heard from anyone that, people complain about the small minority of people that show up at town meeting, get to rule whatever happens in the town? But has the SB2 really changed that when the scale of the communities is different than a regular town meeting?
Thank you for the question, Representative Gilman. So I haven't personally tracked voter turnout when comparing SB2 to the town meeting. What I will say is that those who care about the issues on the warrant or on the ballot are going to be the ones who always show up, or those who care about the issues in an SB2 town, or those who care about the issues that are be taking up at town meeting will be sure to take the time and to show up. And again, there is still a process if people want to adopt SB2. It exists. They can still vote by ballot at the traditional town meeting. It's just those issues should be dealt with as they've been traditionally dealt under that existing form of town government, not under the new form of town government that they're voting on.
Representative Grund.
Thank you, Mr. Vice Chair, and thank you for taking my question. So I'm just going to give an example of my town. It's close to 12,000 people.
Mhm.
We have at least 25 to 70% people show up to our votes recently. We put new school buildings on the budget. All these things drive people out. We don't have a space to meet. So if I'm just wondering, is there more active participation in a vote, especially with the topics of taxes rising and things like that, if people didn't have to go for that one period, one time, and fit into one small space? Would there be more participation?
Thank you for the question, Representative Grund. If I understand correctly, you're asking if there was less space limitations at a traditional town meeting form of government, more people may participate?
Yep, if you were in an SB2
Mm-hmm.
form of government, that you have more participation because people can come during the day to vote versus a traditional town meeting where it's a very specific time, very much what was said before, and a small space. Do you believe there's more participation if you're able to show up under the SB2 format?
Thank you for the question, Representative Grund. I think obviously it's with the polls being open from 8 to 7 in an SB2 town, or sometimes they can be, shorter depending on the voting and everything. Obviously, there's more opportunity to show up at your leisure to participate in the final vote on warrant articles. Now, obviously, there's still, and that's the second session of town meeting. there's still the first session of town meeting. And I live in an SB2 town, and I live in an SB2 school district. I will say, just from personal experience, there is something to be said about folks attending and listening to the presentations and the discussions and the debate, and then voting after they've heard that, versus not attending the first session of town meeting, not hearing that discussion and debate, and then voting about a month later. So again, this is for local municipalities, and their voters should be deciding which form of town government is the best for them. This is local decision making and action. And ultimately, that should be their decision. But there's something to be said about when you're making a substantial change to how your overall town government's going to operate, you might want to do it, if you're in a traditional town meeting form of government, under your traditional procedures where everyone's hearing the debate and then they vote on the question at the end of debate. So I guess, in short, yeah.
Any other questions? Representative Alwood.
Thank you, Mr. Vice Chair. Thank you, Mr. Duchesne, for taking my question. Isn't there a statute somewhere that talks about the municipality must provide enough space for holding town meetings, providing transportation and whatnot? Because I know that our town hall only has a fire occupancy rating of like 100, and we have 1,300 in our town. And I find or feel that whether it's deliberative session or traditional town meeting form, there's just simply not enough space. And I think that skews things. Do you agree?
Thank you for the question, Representative Alward. I'm not sure if space limitations would necessarily skew outcomes of votes. I can't really speak to that. What I can say is that there are, to what you alluded to, there are standards for being able to accommodate voters at a traditional town meeting or at a deliberative session in an SB2 town.
Thank you.
Any other questions? Seeing none, thank you, Mr. Chase.
Oh, thank you.
Okay, our last pink card is Mr. Eric Power, please. Good afternoon again, Mr. Powers.
Thank you, Mr. Vice Chair and committee members. Eric Power from Brookline, and I'm speaking in support of House Bill 1131. I did some research on SB2. I went back in the archives, looking 1995. The reason they made SB2 is because constituents were saying they couldn't participate in traditional meetings. They faced many practical obstacles: elderly, handicapped, couples with children. If I didn't mention it before, I'm a 30-year veteran of the Air Force. I served in the Air National Guard and Air Force Reserve. I retired as a colonel in 2018. And I had to miss a lot of meetings because they're traditional meetings. And if I wasn't there, I had no voice. So I personally had that happen to me. I felt disenfranchised. People also like to be able to think about how they're voting. They want to vote in private. SB2 gives you that at the balloting session. They want to fact check arguments that people might not say the truth. That gives them a chance to do that. The other option that we have besides SB2 is charters, and that was the reason they made SB2. They made it SB2 sort of as a ready-to-go charter that you could easily adopt with the official ballot. If you're not familiar, charters are adopted mostly under RSA 49D. There's a charter commission that comes up with a charter. Then there's a vote on the charter, and then if you want to amend it later or even rescind it, that's all done by the official ballot. So that's the standard. And so when they made SB2, they said, yeah, we're changing the government. It's going to be an official ballot question. So I've actually put in charter commission questions as petition warrant articles this year for my school district, my co-op school district, and my town. And it's going to be official ballot question. But I put in SB2 and it's a warrant article. So that doesn't really make sense. You're changing government. You need to be able to do that in a way that is accessible to much more voters. They designed this special form of charter, the SB2, because it was simpler, easier, and quicker method to adopt. If you do a charter, you have to have a charter commission. It's elected with 9 members. They take a year to come up with a charter, then you vote on it. It still needs the 3/5 to adopt. So they made SB2 as a quick way for folks if they wanted to get this special version. But then the problem was in 2019, they took away the way of adopting it. And I helped adopt SB2 in our Brookline School District before the change. And now people in the town want to do it, and the people in the co-op want to do it, and we can never get it there. When we go to the meeting, we propose the adoption question for SB2, and it's a petition warrant article. It gets put at the end of the meeting. And so, you know how people are tired like we are today at the end of the meeting? People don't want the 1 hour ballot vote. So people will say, we don't even want to vote on it. And the small group at the meeting says, we're tabling it when people are ready to drive in and vote for it. So it really disenfranchises people. And I've had it happen to me where they don't even discuss it. The petitioner doesn't even get to bring up the question. They table it before there's any discussion. The other thing I'd like to mention about SB2 adoption, currently it requires a public hearing. And in a cooperative school district, it requires a public hearing in each town that's in the cooperative school district. So there's already a lot of discussion that's already required under law. The final ballot question happens on election day if we were to pass this bill. So I think it's a very important change. Doesn't sound like a lot, but getting people that can't make it to these traditional meetings the opportunity for them to be able to vote and say, I like SB2 because I can make it to those voting sessions. It makes a big difference, and people won't feel disenfranchised. For those reasons, I hope that you find House Bill 1131 ought to pass, and I'll take any questions.
Thank you, Mr. Powers. Any questions from the committee? Representative Allwood, you're a co-sponsor, right? No?
You're the first co-sponsor. Yeah.
Okay. Okay, go ahead and ask your questions then. Thank you.
Thank you. What do you say to Mr. Deshaies' horse cart before the horse comment?
I'm not sure what the representative, I don't know what the horse before the cart comment is, but
The cart before the horse.
the cart before the horse, I'm not sure the context of that.
He was saying that this procedure is that of SB2 while you're still officially in a town meeting form of government.
Thank you for the question. So as I mentioned, we all agree, or most people agree, that changing governance is a big issue. You're changing how you're going to operate your town meeting. In New Hampshire, for school districts and towns, it's primarily the choices are traditional meeting, SB2, and a charter. And when they made SB2 back in 1995, they were consistent with a charter, because if you have a traditional meeting and you want to go to a charter, it's an official ballot question.
Oh.
And so if you want to go to SB2, they made that an official ballot question. If you have SB2 and you want to go back to a traditional, that's an official ballot question. If you have SB2 and you want to go to a charter commission, that's an official ballot question. So it's an official ballot question everywhere consistently, except for if you go from traditional to SB2, and that's where it got broken. And that's why, and the reason they designed it that way is because people were disenfranchised. They can't go to the meeting to say they can't be able to be at the meeting. And it's really very sad, because I have a gentleman that I've talked to in Hollis who's wheelchair bound, and he really wants to vote. And we actually tried to get him to be able to go to the traditional meeting, but he can't endure sitting there for 3, 4, 5 hours. You know, I've had the SB2 question come up at 11:30 at night. And we did get to vote on it one time. But that's the problem. So it's not symmetric.
Follow up?
Follow up.
Is the order of the question by design? Who is manipulating that order of when these warrant or articles come up?
Thank you for the question. I don't know if I call it manipulation. Some people might. But the order of the warrant is set by the governing body going into a traditional meeting. So they have every right to put things wherever they want. And I've had the SP2 question put at the last question on the warrant sometimes. That's where they choose to do it. The meeting can vote to change the order, but we also had a new rule that the meeting didn't like when we were trying to do that, so the meeting adopted a rule saying you need a 2/3 vote to change the order. So they stopped that. So this is why I think it's really important to put SB2 back on the ballot on Election Day.
Representative Colby.
Thank you, Mr. Chair. Thank you for taking my question. Is it possible that people in your community just don't want to have SB2?
Thank you for the question. So when we proposed it in the Brookline School District, it passed on the first try. We actually did propose it in the co-op and before the change in 2018, I believe, and it failed by, I think, 2 votes in the 2 towns. So it's very close to what people want to do, and that's when it was on the official ballot. We've gotten simple majorities or close to it at the ballot sessions, but not the supermajority. I know in Hopkinton they've had almost a supermajority because I've talked to the Hopkinton folks. They've tried to adopt it there, but it hasn't passed, and they're still trying to do it. And there's been almost 60 attempts during this change, and only 2 have succeeded, only 1 recently. So I think that there are people that want it, and it will make a difference whether it's at the meeting or it's on the official ballot.
Thank you.
Any further questions from the committee? Seeing none, thank you, sir.
Thank you.
Okay, that was the last pink card that I have. Is there anyone else present that would like to speak about this bill? Seeing none, Representative Gilman, could you give us a report in the blue card, please?
Thank you, Mr. Chair. Mr. Chair. I was going to say speaker, but remote testimony today shows 114 in support and 4 opposed, and the in-room blue sheet is blank.
Thank you, Representative, and I'll now close the hearing on HB 1131.
So at this time, we have completed our publicly noticed business for today, and I have some afternoon announcements. So the first announcement is that the committee will meet next week on Tuesday, January 27th, as well as on Friday, January 30th. And as you may have heard, there will not be a House session held next week on the 29th. However, the House will be in session the following week, Thursday, February 5th. And we are not execing any bills today. So with regards to the bills that we execed on Tuesday, if you have been assigned to write a committee report, please have those reports to me no later than midnight on Sunday, February 1st. And I plan to submit the reports on Wednesday morning. Are there any questions or comments? Representative Gilman?
The weather's supposed to be really bad on Tuesday. Are we going to make a call at some point?
So thank you for the question, Representative Gilman. When I checked the weather prior to traveling here today, my understanding that the weather was going to be very bad Sunday and Monday. I understand maybe the weather has shifted and it's different. I will have to check, but I will have to, I don't have any, if weather is bad, depends on how bad it is, but I will be able to, my understanding is it's 24 hours notice. I will be able to do that on Monday, seeing that we meet on Tuesday, so long as it's 24 hours ahead of time. However, if the state shuts down, then definitely we won't be meeting. But that's to be determined. So I will be sure to check in on the weather. Okay. Further questions? Representative Elward. Well, yes, I will, multiple ways. I will email the committee, but also that, if our committee hearing is canceled, it will be on the website and the boards if the building's open. Yes, Representative Vogt.
Can you give us a time certain by which you will notify us if it's to be canceled?
Unfortunately, I cannot because weather in New England shifts and I don't have any data right now, but I will, for sure, it would be 24 hours prior, at least. Yes, and seeing that we meet at 9:30 on Tuesday, expect something Monday morning if it's going to be canceled. Okay. Further questions? Okay, so seeing none, the meeting is now adjourned.